Okay, we'll go ahead and get started. Good morning, all. This is the May 6, 2021 Arizona Board of Pharmacy meeting. The time is 8:32, and my name is Lori Walmsley, President of the Board. I'll call this meeting to order. Dr. Gandhi, can you start by taking the roll to establish a quorum for today?
Certainly. Thank you, Madam Chair. Mr. Solari?
Howdy, sir.
Mr. Dang?
Present.
Mr. Minkus?
Here.
Mr. Leba?
Morning.
Ms. Lahan?
Present.
Ms. Walmsley?
Here.
Mr. Tong?
Present.
Mr. Goodman?
Present.
And Ms. Nair?
Here.
All present and accounted for, Madam Chair.
Thank you, Dr. Gandhi. I know for this morning's agenda, we have a few things that might need to be taken a little bit out of order due to their connection together on the agenda. Can you direct me where is the appropriate place to start? Do we want to start with 26 or move into 27 and come back to 26?
Madam Chair, if we can move to 27, there is an adjustment to the agenda on 27.
Okay.
27D, Bruce Lee Vargas did show up to the board office here. And therefore, we're going to be pulling that agenda item. He and I are going to be discussing this in a week or two to see if we can come to an agreement of some sort that is in alignment with his case. And hopefully we can resolve the matter, vacate the hearing in July. So we're going to move this agenda item to July for now.
Okay, so you'll need a motion. So would you need a motion to vacate that specific hearing?
No, I just need a motion from you or approval from you to table it until July.
Okay.
Make a
If you're
motion
okay.
to table it.
Okay.
Did I have a motion? I'm sorry.
Yes, I make a motion to table it to
Do I have a
July.
second? Okay, thank you. I have a motion and a second. All those in favor?
Aye.
Aye.
Aye. Any opposed? Thank you, Mr. Vargas, for your attendance, and Dr. Gandhi will be in touch. All
So,
right.
Madam Chair, next one would be 27A through C is what we should take first, and then we can
Okay.
move to 26.
Okay. And Mr. Harris, A through C can be handled as one discussion, correct?
That's correct.
Okay. All right. So items 27A, B, and C. This is the time for the board to consider the consent agenda items 27A through 27C. Jacob Ryan Brugner, board case number 20-0065 PHR. Taylor Ray Style, board case number 20-0538 PHR. And Pam Renee.
Not anymore.
Seth?
Yes, Madam Chair, Seth Hargreaves, Assistant Attorney General. In the case of Taylor Ray Stale, I received an email this morning from Ms. Style indicating that she is no longer in the profession, doesn't intend on continuing. She's
You muted yourself, sir. Everybody got muted.
Can you hear me?
Yes. There's
Okay.
a little bit of background.
Is that better?
Yes.
Okay. I received an email this morning. I forwarded it to Dr. Gandhi. She indicated that she has been out of the profession and that it doesn't appear that she intends on staying in. She said she can provide the documents that were requested. She has not been paying attention to her mail or email until recently. However, she did respond to the motion. Apparently, this was in response to the motion to deem that I had filed. It was sent to the same email and regular addresses that everything else had to. To date, she still hasn't technically responded. I would ask to go forward with the motion to deem.
Mr. Harris, is that appropriate?
Yes, that's within the discretion of the board, Madam Chair.
Okay. Board members, do we want to handle these three together or pull that one out separately?
Given the council's advice that we have discretion here, I think we should just take them together and be done with it.
Okay. So moving on, going back to kind of the original piece here. So the third case for the time to consider on the consent agenda was Ambernay Zoe Hager, board case number 21-0002 PHR. Does any respondent or attorney or board member wish to pull any case from the consent agenda to discuss further? Hearing none, will the state's attorney please introduce themselves?
Yes, thank you. Seth Hargraves, Assistant Attorney General on behalf of the state. In each of these cases, the board voted these matters to an administrative hearing. The complaint notice of hearing was sent to each of the individuals at their address of record by regular, certified, and electronic mail. In each of the notices of hearing, they were informed of their requirement to respond to the allegations and that their failure to do so could result in the board deeming the allegations admitted and taking action in their absence. None of the individuals have responded other than Ms. Steele, who responded recently. They have not addressed the allegations. Therefore, the state would ask that the board deem the allegations in the complaint notice of hearing as admitted, adopt them as findings of fact, conclusions of law, and issue the recommended disciplinary action set forth in those motions, which is revocation of the licenses. Thank you.
Thank you, Mr. Hargraves. So board members, the state has filed a motion to deem and vacate the hearings in each of these matters. If these motions are granted, the board will have adopted the factual allegations as set forth in the complaints and the findings of fact and the alleged violations of law as conclusions of law. Is there a motion regarding the state's motion to deem?
Madam Chair, I will make the motion to grant the state's motion to deem and vacate the hearing.
Second.
I have a motion and a second. Any discussion? Is this a roll call, Mr. Harris?
Madam Chair, yes.
Dr. Gandhi?
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Labo,
Aye.
Ms. Lahan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. We will now deliberate on the appropriate discipline to be imposed. Do I have a motion regarding the discipline and the state's
Chair.
recommendation for revocation?
Madam
Yes.
Chair, I move that we adopt the state's recommendations as discipline as set forth in the motions, deem and vacate the scheduled hearings.
I'll second that now.
Thank you. I have a motion and a second. Any further discussion? Dr. Gandhi, can you take a roll?
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Labo,
Aye.
Ms. Lahan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. This concludes these proceedings. The board's decisions will be reduced to writing and the orders will be sent to each of the respondents. Thank you. Dr. Gandhi, at this point in the agenda, should we move to 26?
Yes, Madam Chair.
Thank you. Board members, item number 26 is an informal settlement conference with TW Wellness and Mr. White. Staff or can somebody please start the discussion here?
This is Jean Galvin, board counsel. I am also acting as a prosecutor in this case, but I can just give you a brief background. The board denied the renewal application for TW Wellness, and the matter is such, as was his right. Mr. White, on behalf of TW Wellness, filed a request for an informal settlement conference, and that's the agenda item that you were going to address next. He is on the phone, and you can proceed to ask him questions about how he would like to settle this matter. If it's not settled, it will then go to the formal hearing.
Thank you, Ms. Galvin. Mr. White, if you're on the line, if you could please introduce yourself for the record.
Mr. White is muted. Mr. White, you'd have to unmute yourself, sir.
Dr. Gandhi, given that Mr. White doesn't seem to be able to.
There we go.
Okay.
I've got you now.
Okay, thank you. Mr. White, can you please introduce yourself for the record?
I'm Tom White at TW Wellness here in Albuquerque, New Mexico.
And your role with the pharmacy, Mr. White?
I'm a pharmacist clinician. So I am a pharmacist. I'm a pharmacist clinician. My primary role here is seeing patients, writing prescriptions, taking care of people. I have a pharmacist who runs the pharmacy, who runs a compounding pharmacy.
But you're the owner of the pharmacy, correct?
I'm the owner of TW Wellness. Yes, ma'am.
Thank you. Mr. White, we've received your request for an informal settlement conference prior to your hearing that's also scheduled for today. Can you please give us a little bit of background about what your request is on how to resolve this matter in an informal nature?
The only request I have is that this not be turned over to a federal database. You know, you denied this, and that's fine. We're not asking to be licensed in Arizona. We're not asking to do business in Arizona. We just don't want this turned over to a federal database, which then, gives us a black eye for everybody. We don't believe that we've done anything wrong. We sent Dr. Gandhi a whole stack of stuff that was delivered to his office last Tuesday, I believe. And included in this was letters from patients who had received prescriptions from Arizona, or from us. They live in Arizona, but most of these patients lived in Albuquerque. So as you look at records, it looks as though they've been in Arizona for a long time, but they haven't. Some of these people haven't. So it's very confusing. So it's very important to read this. This was sent to you, and I think everybody should have a copy. But we have letters from every patient that we did business with saying that, yes, they did receive prescriptions, but it was through a third party, it was through families and things like this. And when they moved to Arizona, we told them, look, we can't send to you, so you'll have to find another way to get your prescriptions to you, which they did. When we became licensed, then we told them now we can send to Arizona, which we then started sending to Arizona. When it came time for renewal, it was a question, should we renew or not? Because we weren't doing that much business. These people had dropped off and we weren't doing that much business. So we sent in a renewal. And then after looking at it, we thought, well, that's probably silly because we just did that much business. So at this point, we are just asking to politely get out of this, so to speak, but we would prefer not to have it turned over to the federal registry. And that's our only objective here.
Thank you, Mr. White. So board members, just to orient you, the documents that he's talking about are included in the administrative hearing exhibits for case 28A. as a reminder, the hearing is to revoke the license. TW Wellness shipped prescriptions into Arizona while they have a practitioner that receives direct compensation for the prescription. So that's really the matter at hand. So Ms. Galvin, I know you're not really able to advise on this, but the question at hand here is if we are able to resolve this in some sort of informal matter, or if we wish to move forward with the hearing that is scheduled directly after this, correct?
Mr. Harris could advise you on that.
Mr.
Because
Harris.
if the hearing does go forward, I will be prosecuting.
So if I.
Mr. White, we're asking for legal advice here. If you could
Okay.
please hold on for just a second.
Sure.
Madam Chair, members of the board, that is correct. Basically, that's at this point. Whatever you.
Mark, we're losing your audio,
Yes,
or at least I am.
I'm sorry?
You're cutting in and out.
You're cutting in and out. We couldn't hear you.
Oh, I apologize. Is that better? What I was saying, Madam Chair, members of the board, at this point, they have requested a settlement conference. In essence, his only request is that the denial of the application not be reported to the data bank. I believe, and you may want to hear from the state what their position is on that. But based upon that request and what your decision is, if you deny it, then it would proceed to a formal administrative hearing based upon their request for a hearing on the board's decision to deny their application. Madam Chair, did that make sense?
Yes, it did. Board members, additional questions for Mr. Harris or Mr. White?
I wanted to ask board staff if we do have the ability to not report this. Is that proper?
Madam Chair, if denial is a form of discipline, and all discipline has to be reported to the national database, in order to not report it, we'd have to rescind that denial and allow the application to withdraw. Is the only way to avoid it.
If I may, the state would also suggest that an option would be to grant the application and perhaps issue a non-disciplinary letter of concern, or if you want to impose some sort of discipline, grant the application and with a civil penalty or something like that.
May I say something?
Yes, Mr. White.
When we filled out these forms, when you look at the question about compensation, when I look at medical practitioner, I guess I don't look at myself as a medical practitioner. I look at as a medical practitioner as an MD or somebody in this nature, but I never ever thought of myself as a medical practitioner. I guess I do. I prescribe and I see patients and what have you. But if you don't understand the question, how on earth can you give a proper answer? I don't lie on any type of form, no matter what it is, whether it's good or bad, I don't lie. So if I answer the question inappropriately, let's say, it was because I didn't understand the question. And so, but Tom White does not get specific perks. So I can understand if I had a quota to meet, and if I met that quota, then I would get a perk. That would be one thing. I get a salary. It doesn't matter what I do. I get the same salary from TW Wellness. TW Wellness is owned by Christine Thomas. So it's a LLC, owns LLC, et cetera, et cetera. So if I was getting a volume compensation or something like this, I can understand that as being, quote, a kickback or whatever. But I don't. But I never assumed that, myself to be a medical practitioner. I just assumed that when this question came up, it was my supervising physician that would be getting a kickback or something like this. Never, ever did I ever think that this applied to me.
I don't know if it's appropriate to ask at this time, but do we have proof that things were mailed here? I've read all the statements saying it was given to a family member or someone picked it up and mailed it. Do we have proof that they were actually sent to Arizona from their pharmacy?
Madam Chair, board office did receive a whole bunch of TW Wellness's patients stating that they didn't receive it from the pharmacy, but either a friend or family. I believe Ms. Galvin has those letters.
So Mr. White, so when I asked you earlier if you were the owner of the pharmacy, you said yes, and now you're saying that you're not the owner of the pharmacy.
Well, I am the owner, but you keep in mind, this company is owned by several LLCs. So I am a member of, part of that. But this company, TW Wellness, is owned ultimately by Christine Thomas. Christine Thomas owns the buildings, owns everything. Okay, and this is standard, I guess, legal stuff that corporations go through. So it's a level of shielding for liability purposes. The thing that that came to my mind here is that in Arizona, I'm not considered a practitioner. So when you're asking, a medical practitioner, I'm not a practitioner in the state of Arizona. I'm just a pharmacist. So if you look at the definition, I am not a practitioner. Okay, I am simply a pharmacist. Now, I don't know if you consider a pharmacist a practitioner, but anyway, it's a matter of wording, semantics, and things of this nature is where we're getting caught up here. But if I had some type of an incentive to do certain things, that'd be one thing. I send bunches and bunches of prescriptions out. If a patient has insurance, we don't do insurance. I always send it to a pharmacy so they can get it paid for by their insurance. We do everything that we possibly can to help the patient. There is no way that we do anything that says that a patient has to get something here. They don't have to sign anything. They don't sign anything. They come in here just like you would go to any practitioner's office, and they're free to go anywhere they want. And we don't limit them at all. And a lot of people decide to go to other pharmacies, and that's just fine. So if there was something.
Mr. Wells, Mr. White, I'm sorry, do you receive any payment based on prescriptions that are filled at the pharmacy? So do you receive any profits from the pharmacy outside of your salary?
I receive, no, I just receive my salary, that's it. I don't receive any quarterly incentive thing to do anything, nothing like this. I am paid a straight salary. I think I'm entitled as just somebody working as a pharmacist or otherwise. Everybody here makes a salary. I don't think I should be, not included in that. But I don't make something that is tied to a quota of any kind or anything like this.
But do you receive any profit from the pharmacy?
Well, if we're not profitable, how on earth can we stay in business? I don't personally receive anything in terms of profit. Every profit in a business, profit goes back into the business. You don't want to make any money. You have to pay taxes on it. But in answer to your question, I know where you're going with this. No, I don't receive any special compensation.
Madam Chair, may I ask a question?
Yes, please.
Mr. White, who did you say is the owner? Christine White?
No, Christine Thomas. It's an LLC.
Do you have a relationship with this individual? Are you married? Is she your sister?
This is strictly a corporation. This is not an individual. This is a corporation.
She's not related to you in any way.
Oh, this is a corporation. A corporation is not related to me.
No. The lady, Christine. I'm sorry.
My wife's name is Christine. Okay.
So she's your wife.
Yes.
Okay, that's what I wanted to figure out. Your wife is the owner, not you per se.
No, she's not the owner. Christine Thomas is the owner.
So what, do you have any relationship with Christine Thomas? Any related through marriage?
Christine Thomas is not a person. Christine Thomas is a corporation.
Oh, okay. That's the name of a corporation, not an individual. But are
That's
you
exactly right?
okay? Who is the chairman of this corporation, chairperson of this corporation?
Christine.
So she exists. There is a person.
She is the chairman. She is the chairman. You have to have a chairman of a corporation. Yes, all corporations are set up that way.
Okay, so you're avoiding my question. There is an individual by the name of Christine Thomas who exists. It's a live person.
No. There is an individual by the name of Christine who is the chairman of the corporation, Christine Thomas.
Mr. White,
is that Christine, your wife?
I'm sorry, ma'am.
Mr. White, Madam Chair, if I may ask.
Yes.
Mr. White, is the name of the company based off of your wife's first name and your first name?
Yes.
Okay, thank you.
I'd like to make a motion for executive session for the purpose of legal advice.
Second.
All those in favor?
Aye.
Aye.
Lynn, if you can move Mr. Harris and not Ms. Galvin and Mr. Hargraves into executive session.
All right, it looks like we've got everybody. Mr. White, before we proceed with potentially additional questions, I have just a request of clarification for you. So your request for the informal settlement conference today, your request within that is, I'm sorry, not Mr. Harris, Mr. White. Your request is that you do not want the denial reported to the National Data Bank. You're fine with the denial being on your record. You just don't want it reported. Can you please confirm?
Okay, can you hear me now?
Yes, thank you.
Okay. The answer to your question is yes. I just don't want it reported to the database. I mean, you can register the denial, but I just would prefer it not being sent to the national database.
Thank you, Mr. White.
And that's my only request.
Thank you, Mr. White. The question was asked earlier in the questioning of Dr. Gandhi, whether or not that was an option or not. Dr. Gandhi, just to confirm my understanding, is that an option or a remedy that is available to us as a board, if we so choose?
Fortunately, a denial is a form of discipline, and all discipline has to be reported to the National Practitioners Database.
Thank you. Given those pieces of information, board members, my recommendation would be that we deny this request and move forward to formal hearing, but I'm open to additional discussion.
Agree.
Do I have a motion?
Move to formal hearing, or if Mr. White does not want to move to formal hearing, that would be his option, right?
That'll be our next discussion.
Okay.
So I had a motion by Dr. Leba. Do I have a second?
Second.
I have a motion and a second. Do we need a roll call for this, Mr. Harris, or just a voice vote?
Madam Chair, members of the board, if we could have a roll call.
Okay, Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leba?
Aye.
Ms. Lehan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Aye.
And Ms. Nair?
Aye.
Okay, motion carries, Madam Chair.
Nice have it. Mr. White, we are going to move forward with the administrative hearing. I'll jump into that next and give you the opportunity to speak. Essentially, your denial, at this point, we are moving forward with your request for hearing. We'll begin that statement unless you wish to withdraw your request for the formal hearing to challenge the decision of the denial.
I do not, I wish to withdraw any kind of motion to continue with a formal hearing. I don't want a formal hearing.
Mr. Harris?
Yeah, Madam Chair, members of the board, as I understand it, Mr. White has withdrawn his request for a formal administrative hearing. If we could just ask Mr. White to confirm that, and then if you could entertain a motion to accept his request to withdraw, I think that would be most appropriate.
Thank you, Mr. Harris. Mr. White, can you confirm your request that you do not wish to move forward with a formal hearing as scheduled today regarding the denial?
That is correct. I do not wish to proceed with a formal hearing.
Thank you. Board members, do I have a motion to request to accept Mr. White's request to vacate the hearing?
I make a motion to accept Mr. White's request to vacate the hearing.
And thereby upholding the denial of his application.
And
Thank
thereby
you.
upholding the denial on his application.
Second.
Madam Chair, I'll second that.
Thank you. I have a motion and a second. Mr. Harris, do we need a roll call for this?
Please.
Okay, Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leyba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Ayes have it. Thank you, Mr. White, for your attendance today. We appreciate it.
So can I ask you a couple of questions?
I'd ask that you reach out to either Dr. Kamvang or Dr. Gandhi after the meeting with your questions.
Okay, so basically this is it. This is over with. And you're going to report it to the Federal Register, is that correct?
Yes, unfortunately, as we discussed, we don't have the ability to not report it. It's not within our options that we have, and so we'll have to stick by our decision since you wish to vacate the hearing.
Okay.
So it will be reported.
All right, thank you.
Thank you. Board members, moving on to case 28B, is everybody okay, or do we need a quick break?
Good.
Okay. Let's. Case 28B, Alicia Boyce, board case number 20-0483 PHR. This is the date, time, and place where the matter dealing with Alicia Boyce, board case number 20-0483 PHR is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violation of the board's statutes and rules and whether disciplinary action is warranted. The board is committed to ensuring that the business is conducted in a respectful manner. When conducting formal administrative hearings, the parties are expected to treat the board, witnesses, and each other with respect and in a civil and courteous manner. The parties will not engage in any conduct that brings disorder or disruption to the proceeding. Neither party will be allowed to interrupt the board or the opposing party except when necessary to make an effective objection. If the party does not adhere to these basic civilities, the board will ask the party to modify their behavior. If this party continues to exhibit disruptive behavior, the party's microphone will be muted until it is their turn to speak. Board members present today include Lori Walmsley, Kristen Snare, Joseph Leyba, Kevin Dang, Ruben Minkus, Mohammed Solari, Theodore Tong, Cedar Lehan, and Nick Goodman. Let the record reflect that the board members have been furnished copies of the complaint, notice of hearing, and all pleadings of record. Will all the parties please introduce yourself?
Seth Hargraves, Assistant Attorney General on behalf of the state.
Mark Bozen, counsel on behalf of the respondent.
Alicia Boyce, the respondent.
Thank you. Mr. Bozen, you're the attorney on behalf of Ms. Boyce.
Yes, ma'am.
A hearing of this nature differs from a court proceeding. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant repetitious or otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witnesses, and make a closing argument. In the disciplinary proceeding, the state bears the burden of proof and shall present its case first. Each party may now make an opening statement. This is a brief summary of the case that you intend to present today. Does the state wish to make an opening statement?
Yes, thank you. However, before I do, I'd like to raise some preliminary matters. I just have a question. Do you want to address objections to witnesses and exhibits as they arise, or would you prefer to handle those at the front end?
Mr. Harris, I would defer to your judgment.
Thank you, Madam Chair, members of the board. You could either address them up front as a preliminary matter or as they present during the administrative hearing. The decision is yours.
Madam Chair?
Yes.
I think it might be helpful for me if I heard him as we went versus at the end.
Any objections to that, board members?
No, makes sense.
Okay, please proceed, Mr. Hargreaves. Go ahead.
Madam Chair, if I may, related to Mr. Hargreaves' statement, please strike Dennis McAllister, an unnamed high school student, from our potential witnesses. We will not be calling either one of those.
Mr. Harris, is that within order?
That's fine, yes.
Okay. Mr. Hargreaves.
Thank you. Madam Chair, members of the board, this case involves pharmacist Alicia Boyce and issues surrounding her reporting and compliance with the board's continuing education requirements. Ms. Boyce has been licensed in Arizona since February of 2011. On October 28th, 2019, she submitted her renewal application to the board, in which she declared that she had complied with the board's CE requirements, which is 30 hours during the 2 years immediately preceding the application. In October of 2020, Dr. Boyce was selected for a continuing education audit and requested to submit documentation supporting her attestation that she had completed the board's CE requirements. Documentation that was subsequently submitted showed that she had only completed 18 and a quarter of the required 30 hours, leaving her 11 and 3/4 hours short of the continuing education requirements. It's the state's position that her failure to complete the continuing education and her statements on her application indicating that she had constitute unprofessional conduct and are grounds for disciplinary action by this board. Thank you.
Thank you, Mr. Hargreaves. Does the respondent wish to make an opening statement?
We do, Madam Chair. Apologize while I adjust the camera.
Yeah, mine keeps slipping today, so I don't know what's going on here.
I'm so sorry. Originally, we were on separate cameras, but it occurred to me that every time I talk, you saw a picture of Alicia and not me. So we're going to use the same camera, same audio device. Mark Bozen for Alicia Boyce. Alicia Boyce admits to all of the violations of law that the state cited in their notice of hearing. However, we plan on presenting several affirmative defenses. Affirmative defenses are generally those things that, assuming all of the things before you are true, we still think there are valid defenses. And at the root of our case is a request for a non-disciplinary outcome that is within the board's purview and discretion. The first affirmative defense is that the consent agreement, which describes a discipline of $1,175 along with 45 hours of CE and a mandatory audit, is unreasonable and inconsistent with proposed legislation and recently enacted legislation that was written by and presented by this Board of Pharmacy to the state legislature in the fall of 2019. It did not pass, but for COVID. and was reintroduced in the fall of 2020 and recently passed this session of the legislature in 2021 and was signed by Governor Ducey and is scheduled to become law 90 days after the state legislature adjourns. That piece of legislation makes this precise violation of law, that is, failure to complete CE as a first offense, a non-disciplinary issue. The second affirmative defense is that the proposed consent agreement is not the same discipline that has been imposed historically by this Board of Pharmacy prior to the implementation of what is called a disciplinary grid, which is a document that has no basis in regulation or statute, but it is used as if it is a statute or regulation, almost as if it is a mandatory sentencing for various violations of Arizona pharmacy law. The third affirmative defense is the proposed civil penalty of $1,175 is calculated at $100 per credit hour that's deficient. However, ARS 32-1927, capital B, subsection 1, states that the maximum penalty that can be imposed for failure to complete mandatory continuing education is only $1,000. So even if all of those things were true and the board still wants to issue a monetary fine, the fine for the CE violation, we believe, is capped at $1,000 by statute. The fourth affirmative defense is that the board's primary mission is to protect the public, and that continuing education has no bearing on the safety or competency of licensees under the board's authority, and we provided exhibits that help provide evidence of that. The fifth affirmative defense is that the magnitude of the discipline that is proposed by the proposed consent agreement could adversely affect this individual's ability to transition from her current profession to a new profession, which is in a insurance licensing role, and the imposition of any discipline at all could prevent her from transitioning to a new career in the twilight of her career to a new profession. And that draconian sort of outcome is something that I don't believe is consistent with the public health and safety, and may be prejudicial to her ability to do other things in her career. And with that, it is our request that the board reconsider the discipline as a non-disciplinary order of CE, however many CEs you would like her to complete. She's already made up for the 11.75 hours that she failed to do on time. She's agreed in testimony, it's in the state's exhibit, not to use that toward her 45 hours that we would like as a non-disciplinary order, and would be subject to mandatory continuing education. And with that, that concludes my opening statement.
Thank you, Mr. Bozen. State, would you like to please call your first witness?
Yes, the state calls Alicia Boyce.
Mr. Hargreaves, do we have a court reporter or staff swearing in the witness today?
Dr. Gandhi may be able to answer. I think it may be staff.
Madam Chair, I can take care of that.
Okay, thank you. Go ahead.
Ms. Boyce, if you can raise your right hand, please. You swear that the testimony you will provide will be truthful and complete?
I do.
Thank you.
Dr. Boyce, could you just state your name for the record?
It's Alicia Boyce.
And you're licensed as a pharmacist in Arizona, is that correct?
That is correct.
And when did you first become licensed?
February of 2011, when I transitioned here from Chicago.
Were you licensed in Chicago?
Yes, I was.
Okay. Do you hold any other professional licenses?
I am also a licensed insurance agent in 5 states.
Okay. Do you hold a nursing license?
No, I do not.
Okay. Have you seen the answer to the complaint notice of hearing that your attorney submitted on your behalf?
Yes.
Okay. Are you in agreement with that answer?
Yes, I am.
Is there anything in there that you disagree with?
No.
Okay. Now, since being licensed in Arizona in 2011, you've been aware of the board's CE requirements. Is that correct?
That is correct.
And have you continually renewed your license since it was first issued?
Yes, I have.
And with that renewal, each time required completion of continuing education. Is that correct?
That is correct.
Okay. Would you agree that the Board of Pharmacy is different from the Board of Nursing?
I guess so. I don't know anything about Board of Nursing, but I would assume.
Okay. Would you consider the nursing profession to be different than the pharmacy profession?
I'm sorry, would you repeat that question?
Would you consider the nursing profession to be different than the pharmacy profession?
No, they're still licensed practitioners that are required by law to do CEs.
Right, but what's the difference between a pharmacist and a nurse?
A nurse, they are able to do assessments of a patient. They're able to administer medications. They do not, some nurse practitioners have prescriber rights, similar to some pharmacists in certain states. So they're duty bound to uphold, of course, safe use of medications as well as pharmacists.
Would you agree that the nurses are regulated by the Board of Nursing?
Yes, I do.
Would you agree that pharmacists are regulated by the Board of Pharmacy?
Yes, I do.
Okay. Do you have a copy of the state's exhibits in front of you?
Yes, I do.
Okay. Could you turn to State's Exhibit 2, specifically Bates page 6?
Okay, I have it.
Okay. 1 second. And for board members, I'll give you the reference to the board book. It would be board book page 3626. Do you recognize this as being a document that you're familiar with?
Yes, I am.
Okay. And what do you recognize this to be?
The date is 10/28/2019 when I paid the renewal for my license to be renewed.
Okay. And you file that application electronically, is that correct?
That is correct.
And question 3 asks if you had complied with the continuing education requirements, is that correct?
That is correct.
And you answered yes?
That is correct.
Now, when you were filling this out, what did you do to verify that, if anything, before you answered that question?
I went over all the CEs that I had done, which at the time when I did sign that, I signed that believing that I had complied with the law and the requirements for CE, because I had 30, a little over, I think I had 31 or 32 hours that I had completed within the 2-year time frame. Not knowing that I had, that the ones I did prior to October, whatever the date was, prior to one day before the 28th, that those would not be admissible.
And having been licensed since 2011, you were familiar with the CE requirements, correct?
That is correct. At the time, I was still holding my Illinois license. So the Illinois license was renewal 1 year prior. So one was even, one was odd year. So when I maintained both licenses, a lot of the CEs that I had done for Illinois, I was able to use for part of the CEs for Arizona until I stopped carrying the Illinois license. I got tired of paying for 2 licenses and realized I was not going to move back to Illinois.
But as far as Arizona, those requirements have essentially been the same since you were first licensed, correct?
That is correct.
And at some point, you were selected for a continuing education audit, were you not?
I sure was.
And you submitted documentation after being requested by board staff?
That's correct.
And would you agree that the the documentation that you submitted does not show that you completed the required number of hours within the reportable timeframe?
At the time when I submitted, I believe I did, but after the fact, I realized and was told that I was not. So in answer to the question now, no, I do admit that.
Is it your position that you shouldn't be required to do continuing education?
Of course not. I should be upheld to the standards as any other pharmacist that's required to abide by the law to be licensed. Yes, I should do CEs. I totally agree with that. I'm not.
Is it your position that the board statute and rules do not apply to you?
Of course not.
Nothing further.
Mr. Boson, do you wish to cross-examine Ms. Boyce at this time?
I do, thank you. Alicia, are you an expert in pedagogy and continuing education development?
No, I'm not.
To your knowledge, is anyone in this room or on the Zoom call an expert in any of those things?
I don't think so. I mean, I don't know of anyone's credentials here on this board. I don't know what everyone here does in whatever capacity or role they have, other than they're part of the board of state governing board of pharmacy, but I would assume not.
Are you aware that many other health disciplines offer continuing education?
Yes.
With the exception of the accreditation process that's established by the Board of Pharmacy, are you aware of any fundamental differences between continuing education that's offered to a nurse or a physician or a physical therapist or a pharmacist?
No, because I don't practice those professions, so I don't know what their requirements are. I'm only concerned about what I'm required to do.
Thank you. You stated earlier that you are familiar with the requirements regarding CE for the state of Arizona. Were you aware that the requirements of 30 hours every 2 years was necessarily to be done between the months of November and October of the renewal cycle?
Yes.
Was there a reason that you did not complete the 30 hours specifically between those month periods?
I thought it was calendaring and not rolling calendar, which was my error.
So just to be clear, you were not aware that the 2-year period was November to October until the board audit occurred?
No, I knew it was November to October, but I didn't know it started at the beginning of when it rolled back to when I last paid for the renewal. That's what I'm trying to say.
Understood, understood. Nonetheless, is it your position that when you answered the question, I've completed all of my CEs, that you sincerely and in good faith believed that you had completed them in the time period required?
Yes.
Thank you. I have nothing further.
Thank you, Mr. Boson. Board, any questions? Mr. Hargreaves. Go ahead, Mr. Hargreaves.
I was going to ask, who are we able to ask questions of at this point? For the licensee or of the attorney, or?
Mr. Harris, can you clarify?
Yes, Madam Chair, members of the board, at this point, it would just be Ms. Boyce, based upon her testimony.
Thank you.
Mr. Goodman, do you have any questions for Ms. Boyce?
No, thank you.
Mr. Hargreaves, would you like to call your next witness?
Yes, the state will call Jennifer Kianavong.
Dr. Gandhi, can you please swear in the witness?
Yes, Madam Chair. Ms. Gillenvong, would you raise your right hand, please? Do you testify that the testimony we provide would be truthful and complete?
I do.
Thank you.
Good morning. Could you please state your name for the record?
Jennifer Gillenvong.
And what is your current occupation?
I am the Deputy Director at the Board of Pharmacy
And how long have you held that position?
since September of 2020.
Can you give us a brief overview of what your duties and responsibilities are as Deputy Director?
Certainly. It is to uphold the mission of this board and assist the Executive Director with any activities related to that.
And you're also a pharmacist, are you not?
That's correct.
And which state are you licensed in?
Arizona.
How long have you been licensed as a pharmacist in Arizona?
For 14 years.
As Deputy Director and as an Arizona licensed pharmacist, are you familiar with the board's continuing education requirements?
Yes, I am.
What is required as far as continuing education for pharmacists?
With each renewal cycle, 30 hours of CE are required for a pharmacist.
And is that set forth in the board statute and rules?
Yes, it is.
Do you have a copy of the state's exhibits in front of you?
Yes, I do.
Okay, I'm going to ask you to go to what's marked as Appendix D, which is Bates page 87, and that's page 3691 in the board book. Could you identify that statute?
It's ARS 32-1936.
And could you read subsection A for us?
All pharmacists licensed in this state shall satisfactorily complete approved courses of continuing professional pharmacy education or continue their education by other means in accordance with rules adopted by the board before renewing a license.
Okay. And subsection B indicates that the board will establish by rule the form and content of those hours. Is that correct?
That is correct.
If you can go to Appendix E on Bates page 89, board book page 3693. That's a copy of Arizona Administrative Code R4-23-204. Is that correct?
That's correct.
Could you read subsection A1 for us?
General continuing education requirement. In accordance with ARS 32-1925F, the board shall not renew a license unless the licensee has, during the 2 years preceding the application for renewal, participated in 30 contact hours or 3.0 CEUs of continuing education activity sponsored by an approved provider as defined in R4-23-110.
Okay. So it's 2 years preceding the submission of the renewal application,
That's correct.
and that's 30 hours. Is that correct?
30 hours. That's correct.
Okay. Now, what, if anything, does the board do to verify whether someone has actually completed the continuing education requirements?
The board conducts continuing education audits.
And are you familiar with that process?
Yes.
Could you describe that? Give us an overview of that process for us, please.
Sure. Each month, licensees are selected for audit. The licensee's CTE monitor is reviewed for compliance with continuing education requirements. If the monitor is incomplete, the licensee is contacted by the inspector at the board and possibly a compliance officer if necessary, with requests for CE documentation. If the licensee cannot provide sufficient documentation, the audit documentation and summary is forwarded to the Deputy Director for review. The Deputy Director determines that CE is sufficient. I then request that a complaint be opened. Following the opening of a complaint, a consent agreement is requested based on the number of deficient CE, and the licensee is noticed of the complaint and sent a subpoena and consent agreement.
So Dr. Boyce was selected for a CE audit, is that correct?
That's correct.
And are you familiar with her CE audit file?
Yes,
Okay. And Dr. Boyce is a licensed pharmacist in Arizona, is that correct?
that's correct.
Can you go to what has been marked as States Exhibit 1, Bates page 4, Board Book page 3608?
Yes.
You identify what this document is?
This is certification of Arizona pharmacist license for Alicia Boyce.
And according to this, when was her license first issued?
February 11th, 2011.
Okay. And the status of her license is open. What does that mean?
That she is in good standing and able to practice.
And the purpose of today's hearing has to do with the issue of her compliance with continuing education. Is that correct?
That's correct.
And do you recall when she was pulled for an audit?
Yes. In 1 moment. In October of 2020.
And when an audit is done, what time period is being looked at? What's the basis of the inquiry?
The time period that was looked at was the date of her last renewal, which was October 28th, 2019,
Okay.
to 2 years back to October 28th, 2017.
Okay. And looking at what's been marked as States Exhibit 2, Bates page 6, Board Book 3610, could you identify this document?
Yes, this is her.
Nope.
Yes, this is her renewal.
Is this the full renewal or just a portion of the renewal?
This is a portion of the renewal.
Okay. And what portion of it, what's the contents of this portion of the renewal?
This renewal asks the licensee to disclose if they've had any disciplinary action, any criminal charges, if they've complied with continuing education requirements, if they're an immunizer, or if they'd like a release certificate. So these are questions that are asked of the licensee since their last renewal.
Okay. And this Exhibit 2 was shows an electronic signature by Alicia Boyce, is that correct?
Correct.
And again, what was the date of that submission?
October 28th, 2019.
Okay. And could you read question 3 for us?
Have you complied with the continuing education requirements set forth in ARS 32-1925, 32-3248.02, and Arizona Administrative Code R423-204, including the pharmacy law and opioid-related, substance use disorder-related, or addiction-related continuing education requirements?
And how did she answer that question?
She answered yes.
Okay. And down below, just above the electronic signature box, there's a statement with a check mark. Is that correct?
Correct.
And what does that state?
States, I declare under penalty of perjury, under the laws of the state of Arizona, that the information I have provided this application is true and correct to the best of my knowledge.
And when we went through and read Arizona Administrative Code R4-23-204A1, that stated that the continuing education period is 2 years preceding the application, correct?
Correct.
And this application was October 28th, 2019?
Correct.
Looking at what's been marked as Exhibit 3, you identify this document?
Yes, this is also part of her, and this is actually a portion of her 2017 renewal.
Okay, so she had renewed timely prior to the 2019, correct?
Correct.
And what was the date of that renewal?
October 15th, 2017.
So when Ms. Boyce or Dr. Boyce was selected for a continuing education audit, did that audit follow the normal process that you described earlier?
Yes.
Okay. And if you can take a look at what's been marked as States Exhibit 4, Bates page 10, Board Book 3614. Actually be Bates page 10 and 11. Can you identify these documents?
Yes, these are the board's CE audit documents.
In the first one, Bates page 10, seems to be somewhat of a checklist. Is that correct?
That's correct.
And can you kind of describe the form and what is this? Well, is this something that the staff member conducting the audit would fill out as they're doing the audit?
Yes, that's correct.
Okay. Could you walk us through this document and kind of identify for us what is being reported here?
Sure. There's a number of things: the license status, the last renewal date, which is noted here, whether the licensee was licensed for the full 2-year period immediately preceding the renewal. If that's the case, then the questions that follow pertain: whether the licensee was audited within the last 5 years. If not, then the auditor or the staff member would look further into the continuing education, including whether the licensee was a certified immunizer. And then they would review the CTE monitor, looking for 3 hours of CE in law. That only applies to renewals 2019 and earlier. 3 hours of CE in opioid-related matters, 2 hours of CE if the licensee is an immunizer, and they're looking for a total of 30 hours of CE within the audited time period for a pharmacist.
And why is there a question about whether or not the individual has been audited within the last 5 years?
Could you repeat the question, please?
One of the questions asks, is a licensee audited within the last 5 years? What is the reason for that question?
To ensure that different I would imagine to ensure that different licensees are audited. And there.
I'm sorry. You cut out.
Oh, sorry. So I imagine so that licensees are not repeatedly audited, and so that they're not repeatedly audited.
And under that, it says, if answer no, then proceed. Is that correct?
That's correct.
Okay, so if this person had not been audited, then the audit would proceed. So if they hadn't been audited in the last 5 years, the audit would proceed, correct?
Correct.
Okay. And in this case, Dr. Boyce had not been audited in the previous 5 years, according to this checklist, correct?
That's correct.
Okay. And looking at the next page, page 11, what is this document?
This is a summary of Ms. Boyce's CE audit.
Yeah, can you walk us through that, this document and that summary?
Sure. This document summarizes the results of the audit, that she was short 11.75 hours of CE for the audit period. It also provides a summary of the activities that occurred during the audit, as well as the communications that occurred between board staff performing the audit and Ms. Boyce.
Okay. And going through that summary, it says the initial audit of CP Monitor. What is CP Monitor?
It is a database essentially that it's sort of a central database for maintaining CE hours, like ACPE accredited CE hours that have been earned by a licensee.
Okay. And you said earlier when you were describing the audit process, the first thing that the auditor does is go to CPE Monitor and see what has been reported there?
Correct.
Okay. So when that was done in this case, according to the summary, it only showed 3¼ hours. Is that correct?
Correct.
And then next in the summary, an email was sent asking to provide additional documentation.
Yes.
If you can go to what's marked as Exhibit 5, Bates page 13 and 14. Could you identify this document?
This is Ms. Boyce's CTE monitor activity transcript.
Okay. And on this, how many hours are documented during the audit period?
During the audit period, 3.25 hours are documented.
Okay. And that audit period again is the 2 years prior to October 28th, 2019?
Correct.
Okay. So as indicated in the summary, the initial review of CPE Monitor showed just those 3.25 hours?
Correct.
And then, according to the summary, email was sent out requesting further additional documentation, correct?
That's correct.
Okay. Going to what's been marked as States Exhibit 6, Bates page 16, Board Book 3620. Could you identify this first page?
Yes, this is essentially a notice of a continuing education audit.
And what is the date of this notice?
October 28th, 2020.
And what is being requested in this notice?
A copy of Ms. Boyce's CTE monitor transcript and or CE certificates for the 2 years immediately preceding her last renewal.
Okay. And did she respond to this notice?
Yes, she did.
Okay. Looking at the remainder of Exhibit 6, Bates pages 17 through 23, which would be Board Book pages 3621 through 3627. Could you identify these documents?
Yes. These are emails between Ms. Boyce and board staff.
Okay. And according to these emails, some of them had attachments of CE documents. Is that correct?
Correct.
Looking at is what has been marked as States Exhibit 7, beginning Bates page 25, pages 25 through 35, Board Book pages 3629 through 3639. Could you identify these documents for us?
These are documents that Ms. Boyce provided of her CE and CE test results.
So these were some of the documents that were attached to the emails?
Correct.
So were these documents reviewed as part of the audit?
Yes.
Okay. And flipping back to Exhibit 4, Bates page 11, the CE audit report summary, it was indicated here that documents submitted only documented 18¼ hours of completed CE. Is that correct?
That's correct.
Now, if we can go to what's been marked as States Exhibit 8, Bates page 37, Board Book 3641. Did you identify these documents?
This is an email from Mr. Boson indicating that he's representing Ms. Boyce. In his communication, he provides 3 exhibits.
Okay. And then underneath the listing of the 3 exhibits, what are the 3 exhibits that, as they're described in this email?
As they are described, Exhibit A is evidence of Ms. Boyce completing 19.25 hours within the specified audit period. Exhibit B is evidence of her completing 11 hours as makeup hours. And Exhibit C is an attestation that she will not use the 11 makeup hours towards her 2019 to 2021 renewal requirement.
Okay. And under that, it lists out all the different CEs that were attached. Is that correct?
That's correct.
Okay. And looking at what has been marked as States Exhibit 9, starting on Bates page 41, Board Book 3645, are these the documents that were submitted as part of Council's Exhibit A to that email?
Yes.
Looking what has been marked as States Exhibit 10, beginning on Bates page 55, Board Book 3659. Is this document that was attached under Mr. Boson's Exhibit B to that email?
Yes.
And looking at States Exhibit 12, Bates page 60, Board Book 3664. Is this the document that was included as Exhibit C to that email?
Yes.
Now, I apologize. Exhibit 11 was Bates page 58. That would be document of Exhibit C to the email, correct?
Yes.
Okay. Now looking at States Exhibit 12, Bates page 60, Board Book 3664. Could you identify this document?
Yes, this is a document that was completed by one of our compliance officers on November 19th, 2020, reviewing Mr. Boson's exhibits that were provided in the previous email.
Okay. And based upon that review, what was the determination about the CE that was provided by Mr. Boson?
That ultimately the total number of completed CE hours was 18.25 hours.
And why was that?
Just one moment.
Was that reason given in the second paragraph, starting with the word note?
Yes, yes, that is correct. It's because,
and what was that notation?
There was essentially she renewed on October 28, 2019, and any CE taken prior to 2017 or after. Rather, any CE taken prior to October 28, 2017 or after October 28, 2019 would not count towards her 2019 license renewal.
So one of the documents that were submitted was for a course that was outside that time frame?
That's correct.
And looking at the second page of the exhibit, Bates page 61, is that documentation of the course that was outside the time frame?
Yes, it is.
And what was the date that this course was taken?
October 16th, 2017.
And so based upon the audit that was conducted, did Dr. Boyce comply with the board's CE requirements for what was required for her 2019 renewal.
No, she did not.
And as a result of that, this matter ended up in today's hearing. Is that correct?
That's correct.
And looking at what's been marked as State's Exhibit 13, beginning on base page 63, Board Book 3667, do you identify this document?
This is the complaint and notice of hearing.
That's for today's hearing.
That's correct.
And the factual allegations have to do with the CE audit and the results of that. Is that correct?
That's correct.
And looking at Bates page 69 to 70, which would, what the alleged violations of the board's statutes regarding unprofessional conduct were ARS 32-1901.01B4, 7, 17, 18, and 19. Is that correct?
That's correct.
And did Dr. Boyce submit an answer to the complaint notice of hearing?
Mr. Bozen responded on her behalf.
Okay. And in that answer, they admitted to all of those alleged violations of unprofessional conduct, correct?
That's correct.
Thank you. No further questions.
Mr. Bozen, do you wish to cross-examine Ms. Kianamong?
Actually, Madam Chair, if I may, I'd like to move to admit Exhibits 1 through 13 into evidence.
Thank you. Board members?
You need a motion?
Madam Chair, first, can
Yes.
you ask Mr. Bozeman if he has any objections?
Thank you. Mr. Bozen, do you have any objections? Mr. Bozen, we can't hear you.
How's this?
Good.
No objections. Thank you,
Thank
Madam
you.
Chair.
Board members, do we have a motion regarding the state's exhibits?
I make a
Madam
motion.
Chair- Oh,
Sorry.
Go ahead, Ms. Mayor. Go ahead.
I make a motion to accept the exhibits as presented.
Second.
And I'll second the motion to admit Exhibits 1 through 13 into evidence.
Thank you. I have a motion and a second. All those in favor?
Aye.
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 Mr. Bozen, do you wish to cross-examine the witness?
Yes, please. I appreciate your time, and I'll be brief. Deputy Director Kianamong, thank you for your testimony. You had stated that you were part of the team that performed the CE audit and the subsequent activities that later occurred, including preparing a draft consent agreement. Is that correct?
Correct.
When drafting the consent agreement, was this board consulted?
Madam Chair, I'm going to object in regards to any reference to a consent agreement. Settlement discussions are kind of outside the scope under public policy. Settlement discussions are usually inadmissible. Further, under ARS 41-1092.06, proposed settlement negotiations are inadmissible in subsequent administrative hearings. Fact of the matter is the consent agreement is not before you today. The issue before you are the allegations regarding compliance with CE. At this point, there is no consent agreement. Settlement negotiations would be inadmissible. So the state would object to any question or reference to a settlement agreement.
Mr. Harris?
No objection. No objection to his objection. It's a good one.
Okay.
Question withdrawn. Deputy Director Kianamong, are you familiar, do you have a copy of the respondent's exhibits in front of you? And may the record reflect that we are withdrawing any reference to exhibit number 1. I'd like to call your attention to exhibit number 3.
I do have a copy in front of me.
Can you tell me what exhibit number 3 is?
One moment, getting there. Exhibit number 3 is the board's complaint and application guide.
Can you point to the part of Arizona law, either regulation or statute, that describes this document?
No.
Where did this document come from?
This document was created and approved by the board.
Was it put through the administrative process that's called for in the Arizona Administrative Procedures Act?
Not to my knowledge.
What does the board use this document to do?
Board uses this document as a guide to determine disciplinary action if a licensee fails to complete CEs, if they work without a valid license, or if they have a criminal background.
Can you read for me what the section on continuing education calls for?
Mr. Bozen, which section are you referring to?
The entire section that's entitled continuing education.
There is a section titled failure to complete CEs. Is that the section you're referring to?
My apologies. Yes, that section.
There is a section for pharmacists and technicians.
Does this section describe a mandate?
The section describes the disciplinary action associated with failure to complete CE.
Is this section mandatory? Is this a mandatory disciplinary guide?
This is a guide that was approved by the board.
I'll repeat the question, non-responsive. Is it mandatory that the staff follow this guide in all cases, regardless of facts and circumstances?
This document is used as a guide. And so if it's used mandatorily every time, I cannot answer one way or the other. It's used as a guide.
You use the word mandatorily. In fairness, let me rephrase the question. You just also described it as a guide. Is there a set of facts and circumstances that would allow board to deviate from this section on failure to complete CE when drafting potential orders for people that are similarly situated?
Can you please repeat the question?
Does the board have any discretion, does the board staff have any discretion when proposing penalties for people who have a failure to complete CE?
Since I have been employed at the board, I have seen this guide used consistently with respect to failure to complete CEs.
And you did describe it as mandatory in your previous answer. Would you consider this a mandatory requirement that people failing to complete CEs, this guide must be followed?
This is the guide that I have seen consistently followed since I have been employed here.
It's non-responsive. Is it a mandatory guide? Do you have any discretion as board staff to deviate from it based upon facts and circumstances? Yes or no?
I would say that there is room for discretion in certain sections of the guide. So with respect to failure to complete CEs, I've seen this portion of the guide used consistently.
Madam Chair, I'd ask that you instruct the witness to answer the question as posed. Does board have any discretion when evaluating CE to issue orders that are different than what's described? Yes or no?
Mr. Harris?
Madam Chair, members of the board, to ask the state if they have any objections to this question. It's been asked several different times, several different ways. The witness has answered it. The fact that Mr. Boson might not have liked her answer doesn't mean that she hasn't answered it.
My retort is that the response has been non-responsive. I've asked if it was a mandatory tool that the staff had discretion to use, and that hasn't been answered.
Mr. Hargraves, do you object to the question?
Well, the question seems to be all over the place. He's referencing an order which staff doesn't have the authority to issue an order. The staff may have authority granted by the board to offer a consent agreement to resolve the matter, but in the end, anything regarding a consent agreement would come back to the board. Only the board has the authority to issue an order. And even with a consent agreement, the board always has the discretion whether or not to accept that. So if the question is about staff in issuing an order, staff does not have that authority. State believes that the question is somewhat ambiguous, and it's kind of going all over the place.
I'll restate the question.
Go ahead, Mr. Boson.
Deputy Director Kianavong, does the Board of Pharmacy, the 9 members that are appointed by the governor, have the discretion to issue any sort of discipline or non-discipline based upon any violation of any pharmacy law?
Yes.
I would object again, Your Honor, Madam Chair. The board's authority to issue orders is set forth in statute, and it would require due process ahead of time. Again, I believe counsel is confusing offering a consent agreement and issuing an order.
In fairness, I'm not talking about a consent agreement because that's a settlement negotiation, and I don't want to talk about a consent agreement. I want to talk about this piece of paper that describes penalties related to failure to complete CE, and that's the entire scope of my question. And I want to find out if that's a mandatory discipline or a discretionary discipline.
Again, Mr. Boson, my response to your question is that I have seen this guide used consistently and without deviation since I've been employed at the board.
In fairness, that's still non-responsive. Is a guide discretionary or is it mandatory?
I think that would depend on what type of guide you're referring to, Mr. Boson.
Thank you for your testimony. I have nothing further.
No further questions for the witness, Mr. Boson?
That's correct. I'm complete with my cross-examination. Reserve the right to recall and directive or rebuttal if necessary.
Board members, any questions for Ms. Kianavong? Go ahead, Mr. Dang.
Madam Chair, I don't have a question for Mr. Kianavong, but I do have a question for Attorney Boson, if I may.
Mr. Harris, is that appropriate at this time?
Madam Chair, members of the board, Board Member Dang, since the state is still putting on its case, I would ask that you hold off on your question until after state is finished.
Fair enough. Thank you.
Thank you.
Board members, any questions for Ms. Kianavong? Mr. Hargraves, do you have another witness?
Well, I've got some redirect, if that's okay.
Okay.
Ms. Kianavong, the grid that council was having you look at, where did this come from?
This was approved by the board of pharmacy.
Okay, so this is something the full board came up with?
Yeah, Mr. Hargraves, I'm not entirely certain which members or how many members of the board were involved in creating this, but it was approved by the full board.
Okay. One moment, please. I would ask, council, I just sent you an email with what's going to be state's proposed exhibit 14. Ms. Kianavong, if you can pull up for the board members, board meeting minutes for November 18th, 2015. Are you able to share that on the screen?
Yes, I am.
Can you identify for us what this is?
These are the meeting minutes for the regular board meeting held on November 18th, 2015.
Okay. And are these, is this document Bates numbered?
Yes.
Okay. If you can go to Bates, well, these are for the November 18th, 2015 board meeting. Is that correct?
Correct.
If you can go to Bates page 37. Looking at agenda item 20, what is the topic?
Delinquent continuing education credit.
Okay. And what do the minutes indicate regarding that agenda item?
The minutes indicate that this topic was discussed and that it was decided that a consent agreement should be offered to pharmacists and pharmacy technicians that do not meet minimum CE requirements. It also defines the terms of that of that consent agreement.
And then it sets forth what those terms would be?
Correct.
Is this the basis of what ended up becoming the grid that is Dr. Boyce's Exhibit 3?
Yes, that's correct.
Okay. And how did the board vote on that?
The board voted to. The board unanimously approved the recommendations provided in these minutes.
Okay. So that recommendation was unanimously approved by the board?
Correct.
Okay. And those were provisions to offer a consent agreement, correct?
That's correct.
Is a licensee obligated to accept a consent agreement?
No, they are not.
And they can proceed with their due process rights if they don't want to accept a consent agreement, correct?
That's correct.
Thank you. Nothing further. And I'd ask that Exhibit 14 be admitted into evidence.
No objection.
Thank you, Mr. Bozen. Board members, do I have a motion regarding this exhibit?
Yes, ma'am. I'll make the motion to admit Exhibit 14 into evidence.
Thank you. Do I have a second?
I'll second.
All those in favor?
Aye.
Aye.
Aye. Any opposed?
State has no further witnesses.
I'd like another opportunity to cross based upon that redirect, please.
I'm sorry.
May I please cross based solely on the redirect of this witness before you proceed, Madam Chair?
Yes, please, go ahead.
Thank you. Deputy Director Cannabong, are you familiar with Respondent Exhibit 2, which is Arizona Senate Bill 1087 that was introduced, passed, and signed by the governor in the first regular session of 2021?
Madam Chair, I'm going to object to consideration or use of this exhibit. This is a bill that is not effective at the moment. It's not relevant to these proceedings. It's not anything that is in effect or binding on the board at this time.
I'd like an opportunity to rebut. The state just admitted evidence based upon minutes from 2015 that described what is the emphasis of the guide, that describes a guide to propose consent agreements, and this bill was drafted by the board, lobbied by the board, and is directly contradictory to the evidence just presented as Exhibit 14.
Mr. Harris.
Madam Chair, members of the board, ultimately the decision is yours. I would just ask you to consider that perhaps the introduction of that particular exhibit may be premature, as it was my understanding that Dr. Bozeman's questions were going to be limited to the very narrow focus of Mr. Hargrave's, bless you, redirect, which was just some additional background regarding the grid. So if we could ask Dr. Bozeman's questions to be limited to that area.
Thank you, Mr. Harris.
In fairness, if I could provide a little more rebuttal and to the objection, if I brought this in because I believe the state opened the door. The state has said there is a record of the Board of Pharmacy in 2015 creating a thing called the grid that exists today. I'm arguing that Senate Bill 1087 is a direct contradiction of that, in part because it completely overturns that. And I also plan on, just for knowledge, so you can rule on them both at the same time, Senate Bill 1372 from the second regular session of the Arizona House of Representatives 2020 that was adjourned prematurely sine die because of the pandemic, which also expressed the sense of the board that is completely different and opposite the Exhibit 14 that was just admitted into evidence, which states that the board no longer considers a first offense of failure to complete CE non-disciplinary. And those documents were approved by the board in 2019, were lobbied for in the session in 2020, reintroduced by the board in 2020, and reintroduced in 2021. And it's a direct rebuttal to Exhibit 14. And if I can't get it in now, the state's going to object to it when I do it on my piece, and I would respectfully allow that this is the piece that gets my exhibits in.
Madam Chair, if I may.
Yes, go ahead.
Well, first of all, this is not in direct response to the state's proposed Exhibit 14. Exhibit 14 was in response to Mr. Bozen's cross-examination of Deputy Director regarding the history. In Exhibit 14 sets forth what the board adopted as a policy to try to informally resolve complaints. And again, that's with an offer that has no binding effect on the recipient, who are free to reject it. This document that's trying to be introduced is in regards to a law that is currently not in effect. It won't be in effect until a couple of months down the road, and I would submit that council is misrepresenting what the contents of this bill are. It does not create automatically that the board's decisions will be non-disciplinary. It gives the possibility and the discretion. It does not make all board actions regarding CE non-disciplinary. So in that respect, he's misrepresenting that. And either way, it's irrelevant at this time because this law is not in effect and it's irrelevant to these proceedings. And I would ask that it not be allowed and be rejected as an exhibit. Thank you.
Mr.
The
Harris,
respondent disagrees.
Mr. Harris, so we have the option of holding off on admitting that exhibit and continuing on with the questioning and address the exhibit again later in the meeting.
Madam Chair, members of the board, you do. Just as a reminder, my understanding is we are at recross based upon the state's redirect of the board's deputy director.
Thank you, Mr. Harris. Mr. Bozen, can you please ensure your line of questioning is in that vein?
I will. But with that, I will end my cross-examination. I would, well, let me do this. Can the board rule on the state's objection, and then I will make a decision as to whether to proceed? Is that fair?
Mr. Harris.
Yes, and it's my understanding, and we can do it more formally, Madam Chair, members of the board, that you are affirming or sustaining the state's objections to the introduction of the respondents' exhibit.
It's exhibit number 2.
Thank you. Exhibit number 2 at this time.
This is Goodman. I move that we affirm the state's objection to not allow exhibit number 2
at this time.
At this time, yeah.
Thank you.
Do I have a second for that motion?
I'll second.
Is it just a voice call or is it a roll call, Mr. Harris?
Voice vote is fine.
All those in favor?
Aye.
Aye. Any opposed? Mr.
With that,
Hargreaves.
Madam Chair, I will end my cross-examination. I have no further questions for the witness.
Thank you. Mr. Hargreaves, do you have any additional witnesses on behalf of the state?
No further witnesses. Thank you.
Another page. Mr. Bozen, do you have any witnesses you wish to call today?
Yes,
Madam,
I wish to.
I apologize
I'm
for interrupting. Madam Chair, members of the board, and I might have missed it, but did we ask if the state rests?
Oh, I'm sorry, I missed that. No, we did not. Mr. Hargreaves, does the state rest its gates at this time?
Yes, subject to rebuttal.
Thank you.
Mr. Bozen, would you like to call your first witness?
Yes, I'd like to recall Alicia Boyce, and I will turn it over to her.
Thank you. Do we need to re-swear her in since she's already been sworn in for this hearing?
Oh, Madam Chair, she's still sworn, just a reminder.
Okay, thank you. Mr. Bozen, please proceed.
Alicia, I just have one question to ask you. Should the state impose discipline on your license, even as a form of a civil monetary penalty, whether it be large or small, would that have a impact on your future career?
I believe it would.
In what way?
Well, I started transitioning from pharmacy to insurance industry for a lot of reasons. My health started deteriorating, and I won't get into all that with the board, but I almost had a stroke from stress, and I had 2 relatives die. My mom and sister died under cancer, and also my mom had 2 strokes and died under COVID. So I went through a lot, physically as well as mentally, and I almost ended up and died with a stroke from the stress, and I realized that I needed to work from home now, and I started transitioning into doing into something else. And that started in 2019. And the time when I did renew the license, it was during the time when I was experiencing all the family detrimental health issues between that period of 2017 and 2019. So,
if I may, Madam Chair, it's my witness. Can Alicia talk specifically? My question was specific to your future career plans.
I'm sorry.
If there's discipline on your license, would that dramatically affect your future career plans?
Yes, because one of the questions you do when you become licensed with insurance industry, they ask, have there been any other infractions to any kind of licensing you've experienced? Any type of hearings or infractions to any of the licenses that you hold? And of course, at the time when I applied for all these licenses, I started this process a while ago, I said no. And so I've been licensed already for 2 years in these states, in several states, but moving forward with this, I guess with this penalty against my license as a pharmacist, civil license penalty, that would impact my future ability to continue to practice as a licensed insurance agent. It might impinge upon that as when it comes time for my licenses to be renewed, which will be in 2022, I'm up for renewal, and also any future reciprocity licenses I may request to have if I have a client that I am providing insurance services, because we are allowed to do reciprocity as with pharmacy as well. Yeah.
Thank you.
Mm-hmm.
Thank you. One more question, and then I'll turn it over to the state. Have you ever been disciplined for any violation of any pharmacy law during your career?
No.
Thank you. No further questions.
Thank you, Mr. Bozen. Mr. Hargraves, do you wish to cross-examine?
Oh, sorry.
No, no questions.
Board members, any questions for Ms. Boyce?
Madam Chair, this is Kevin Dang.
Yes.
So Ms. Boyce, through reading the narratives, we all learned that you had completed the application, submitted the application to the Board of Pharmacy dated October 15, 2017. And on the application, you had checked the checkbox that says all the CEs were completed. But then my question for you is, after you submitted that application, you should be very well aware of the fact that we do require 30 CEs every 2 years. How come by 10/28/2020, that's a date that our compliance officer conducted the audit, we found out that you are short. You had only completed 18.25 hours of CE. So explain to me and other board members that you know ahead of time when you submitted the application, the core requirement from the AZ Board of Pharmacy, the 30 CEs have to be completed within 2 years. So we didn't really conduct the audit until 2020. That's almost 3 years. 3 years after you submitted the application, that's when our compliance officer conducted the CE audits. So explain to us, how come there is a shortage of CEs?
There's a shortage of CEs because there were CEs I did prior to that period that was the rolling calendar. I had CEs that I had done one seminar thing I went to that was end of September, September 29th, if my memory serves me correctly. And then there were several CEs I did online and a couple of workshops I did. That was the beginning of part of October, which I thought incorrectly that they were also admissible as part of my CEs to be counted as well. And those were the 11.7 hours that were thrown out when the audit was done. So it's not a matter of I didn't do any CEs, I did them, but I did them in the wrong time frame. So that's why I thought when I checked the box that I completed all my CEs. To my knowledge at that time, to best of my knowledge, I thought I had conducted and completed all my required CEs.
Okay. So earlier during the interview, you had answered, I remember Attorney Posen had asked you to confirm that you do acknowledge that CE would count from November to October, and you said yes.
Yes, that's correct, because I learned that after the audit, when the deputy director started requesting information for the audit of my CEs, that's when I learned that I was out of sync for the calendar time period.
In fairness to all of us who are licensed in Arizona, my original state is not in Arizona. I know for the fact that the CE requirements are very specific on the law book, and we actually had to study for that. And if I remember correctly, this is about 15 years ago, but those questions pertaining to the CE's requirement and the window period are also on the exam. So it's very difficult for me to be convinced that you're not aware of the fact that the rolling period of the CEs and the requirement of the CE credits. So I'm somewhat not convinced that you're not aware of the fact.
I understand and I appreciate that and I respect that. I can only share what I thought I did. And also the fact that for several years I carried 2 licenses, so I used part of the CEs from the other license, or the other half of the year of the other license, to be able to use towards Arizona. And when I stopped carrying that license, that's when I, did not recall or remember the different time span in the time period in which you have to have your CEs for Arizona. Yes, I did take the law exam, but that was a while ago. And I'm sorry, but I did not recall that. And you're given the other things that was going on in my life at the time. I wasn't focused on pharmacy CEs. I was focusing on being a caregiver to a sister dying for cancer and a mom who had Alzheimer's and had 2 strokes. So I realized my license was coming up and I had to hurry and get my CEs done, and I did them. I started doing them in the beginning of October. It was a lot going on emotionally as well as stress, as well as physically at the time during that real license renewal period. Doesn't excuse it. I'm not asking for any excuses. I'm simply stating where I was at mentally.
Okay, so then what's the main purpose of your presence here for today's hearing? What are you actually asking from the board?
I'm asking for a non-disciplinary decision or judgment if there could be some leniency on behalf of the board, because...
Actually, Madam Chair, I want to object. Who's answering here? Because I'm pretty sure I heard Mr. Bozen feeding her the answer before she gave it.
The answer is, my apologies. That was inappropriate, but it is in our answer, the request.
He was rephrasing the question so I would understand it.
No, I wasn't. No, in fairness, I answered concurrently, and that was inappropriate, and my apologies to the tribunal. But the answer is in our answer.
I thought you was rephrasing the question. All right, well, I'm speaking from my heart and for me, what I'm interested in, which is why I'm here and why I even asked Mr. Bozen, or Dr. Bozen, he's a pharmacist too, to represent me. I knew this was a serious offense when I did get the audit from the deputy director, and when she and our correspondence went back and forth, and I kept saying, hey, I did my CEs, and she said, no, you're short, and she was very gracious. I'll admit the deputy director was very gracious. She gave me every opportunity to see if I can find any other additional CEs, and I went through everything I had. I said, you know what, this is what I got. She gave me a couple of days to try to figure it out. And I said, and I responded back like, no, I can't find anything else. This is all that I have. So, I'm just here asking for any consideration that can be given at this point, since this is my first infraction, any offense with this, or having anything against my license being brought before the board. And that's all I'm here for, asking for consideration, even though I am totally at fault.
Okay, so I'm glad that you are in front of the board admitting that you're at fault for not completing the required CE credits. Okay, so Madam Chair, that's all I have.
Thank you. Mr. Bozen, do you have any additional witnesses?
No, we did, but in the interest of time, I think the board has sufficient information to deliberate, and out of respect to your time and your busy work, we're going to rest.
Thank you. This concludes the evidentiary portion of the hearing. The board will now hear closing arguments. Does the state wish to make a closing argument?
Yes, thank you, Madam Chair, members of the board. The evidence and testimony that have been presented, and actually the admissions by Dr. Boyce, support the allegations and the violations set forth for this hearing. Under your statutes, you have the authority, after formal hearing, to issue a civil penalty not to exceed $1,000 for each violation of the board's chapter rules. In this case, as laid out in the evidence, testimony, notice of hearing, and Ms. Boyce's admissions, she has admitted to essentially 5 violations. The evidence has shown, and she has admitted that she has failed to comply with the mandatory professional pharmacy education requirements of sections 32-1936 and 32-1937 and rules adopted by the board, which is unprofessional conduct under 32-1901.01B7. She has admitted that she has committed unprofessional conduct under 1901.01B19, violating or attempting to violate directly or indirectly or assisting in, abetting in the violation of or conspiring to violate this chapter, and specifically 32-1936 in Arizona Administrative Code R4-23-204 regarding continuing education. In addition to admitting to violating and not complying with the board's continuing education requirements, she admits that she committed unprofessional conduct under 32-1901.01B4, obtaining or attempting to obtain a license renewal by fraud, misrepresentation, or by knowingly taking advantage of the mistake of another person or agency. Also, 1901.01B17, knowingly filing with the board any application, renewal, or other document that contains false or misleading information. And unprofessional conduct under 32-1901.01B18, providing false or misleading information or omitting material information in any communication to the board or the board's employees or agents. So this case is more than just not complying with continuing education. She also knowingly provided false, misleading information to the board. She's admitted to that. So whether it's 5 violations or if you want to break it down just by the conduct, you have 2 violations: the non-compliance and the false, misleading information. Based upon your statutes and the fact that she did not comply with continuing education, the state would ask that you make findings that the state has established the factual allegations and the alleged violations of law set forth in complaint notice of hearing, which were, again, admitted by Ms. Boyce. And I want you to take into consideration with that what just happened in the questioning by her attorney and her statements to the board, where it was questioned who was answering the question, whether it was her or her attorney. And she said that her attorney was just rephrasing the question. Mr. Boson was clear. No, he was wrong. He wasn't rephrasing the question. He was providing the answer. Despite that, she continued and was adamant he was rephrasing the question. She's being dishonest with this board to your face as we're sitting here on something you can clearly hear and something her own attorney is sitting there saying, no, that's not true. That tells you about the character of the individual before you for hearing. Based on the violations that have been admitted, the state would ask the board impose a $2,000 civil penalty, $1,000 for failing to comply with continuing education, $1,000 for the false, misleading information violations, that Ms. Boyce be required to cure the CPE deficiencies with her next renewal, or cure them prior to the next renewal, provide proof of that, but either way, prove that she has actually finished the CE that she was required to complete with her 2019 renewal, and also ask that based on the issues involving her failure to comply this past time, that her next renewal CE be subject to audit as well. Thank you.
Thank you, Mr. Hargraves. Mr. Boson, do you wish to make a closing argument?
I do. First, I'd like to apologize for the outburst that I had in responding to Board Member Dang's question. The prayer for relief still stands. This board has discretion to issue discipline related to this matter. The grid notwithstanding, there still is discretion based upon facts and circumstances. This is a pharmacist that has a long tenure of service without violation either in the state of Illinois or the state of Arizona over 2 decades. She did not complete her CE. She was truthful and admitted to that. She did not try to cover that up at any time. She was horrified to learn that she had not completed her CE and has simply asked, because the board does have the ability to issue non-disciplinary CE, that be the recourse. And that would be consistent with not necessarily recent action by this board, but historic action by the board in which there have been people who failed to complete CE who were not disciplined. And also there are people who committed acts unrelated to the completion of CE that may or may not have been related to patient safety who were also ordered to take non-disciplinary CE. Ms. Boyce respectfully requests that the state consider a non-disciplinary penalty that won't affect her ability to continue to practice in this profession or other professions because of the disciplinary nature that would result in any sort of civil penalty or disciplinary measure. And respectfully, the respondent completes its summary of the case. Thank you.
Thank you, Mr. Bozen. State, do you wish to make any brief rebuttals?
Yes, thank you. Mr. Bozen brought up, based upon what the board has done in prior cases where they didn't discipline for CE deficiencies, there has been nothing submitted into evidence to support that claim. He was certainly free to introduce whatever evidence he wanted to. His statement that the board has not issued discipline in the past, there's no evidence of that. That is not in the record of this matter. In regards to whether or not the board has issued discipline in other matters, again, we don't know what those matters are. Those facts, there's nothing in evidence to support that. We're here to talk about the case in front of you, the case involving Dr. Boyce, her specific facts, her admissions, her violations. State would ask that discipline be imposed consistent with the facts of this case. There are violations, not just with the failure to do the CE. There's veracity, there's honesty. There are other violations besides the CE that warrant discipline by this board. Thank you.
Thank you, Mr. Hargraves. At this point, the board can begin with general discussion or entertain motions to make the findings of fact, conclusions of law, and a final order.
Madam Chair, may I be allowed to ask a question?
Yes.
I guess this is directed mostly at Mr. Harris, but any of the attorneys that want to reply to this is fine. I wanted to refer to Exhibit 2 by the state. This is on my board book, page 3626, but all the board books may not be on the same paging number because I was having difficulty following. Anyway, Exhibit 2 by the state. This is the one that has the, since your last renewal, you attest to the following things. At the very bottom, we talked about the check mark where it says, I declare under the penalty of perjury under the laws of the state of Arizona that the information I have provided in this application is true and correct to the best of my knowledge. And Ms. Boyce did check that and electronically signed it. My question to Mr. Harris is, just for my education, what is the penalty for perjury? What are the ranges for perjury penalties in the state of Arizona?
Madam Chair, members of the board, what we have to focus on is as it relates to the board's Practice Act. There may be some criminal implications that perjury has, but in our context, we need to look at when somebody perjures themselves, is that an act of unprofessional conduct? And in this case, as you, if you take a look at the state's complaint, there are alleged violations related to affirmatively stating that the information provided in the application is true and correct, when in fact it turns out that it was not. So you will have the ability to find a violation for affirmatively representing that everything in the application that was submitted was correct. I hope that answers your question.
Thank you.
I have a question for Mr. Bozen.
Go ahead.
Are you asking us to do something that we're statutorily not able to do?
No, I don't believe I am.
Mr. Harris, can you comment on that? Because I don't know that I believe that that's truly the case.
Madam Chair, members of the board, would anybody entertain a motion to go into executive session for legal advice?
Yes, I would make that my motion. Do I have a
Second.
All those in favor?
Aye.
Aye.
Welcome back, everyone. Dr. Gandhi, do we need to take attendance, or is everybody present?
There's a lot of people. It's safer to take the attendance, Madam Chair.
Okay, go ahead.
Mr. Solari,
Present, sir.
Mr. Dang,
I'm here.
Mr. Minkus,
Here.
Mr. Leba.
Here.
Ms. Lahan,
Present.
Ms. Walmsley,
Here.
Mr. Tong,
Present.
Mr. Goodman, Mr. Goodman, Ms. Nair.
Here.
Okay, we'll keep an eye out for Mr. Goodman.
Thank you, Dr. Gandhi. Board members, we are still at the point of discussion. Are there any further questions or discussion related to this matter? Hearing no discussion, are we ready to start to entertain motions?
I'm willing to start things off by making a motion to grant the state's motion and deem the allegations in the complainant notice of hearing is admitted.
And that would be the factual allegations 1 through 13 for the record.
Yes, ma'am.
Madam Chair, the state didn't make a motion to deem.
Then I'll withdraw my motion.
Second.
Mr. Harris, would the appropriate motion be to adopt the findings of fact and factual allegations 1 through 13?
Yes, that would be fine.
I'll make a motion to that effect then.
Second.
I have a motion and a second. I believe this is a roll call.
Sure.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lahan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Ms. Nair,
Aye.
Mr. Goodman, are you back?
Aye. Yep.
Thank you, sir.
Ayes have it. Next, we need to address the conclusions of law.
Then I'll make a motion to adopt the factual allegations and the alleged violation from the complaint and notice of hearing as finding the fact and conclusion of the law.
Madam Chair, members of the
Yes.
board, if we could, if you don't mind, board members, just referring directly to the violations of law. I think we've just addressed the findings of fact. So my understanding is that your motion is to adopt the alleged violations of law set forth in the complaint as your conclusions of law in this matter.
Yes, sir. Thank you for clarifying. That's my motion.
Thank you.
Did I have a second? Okay,
I'll
thank you. I have a motion and a second.
Okay.
Any discussion? Go ahead.
Thank you, Madam Chair. Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leyva,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Next up is the discipline and the matter of this case. Mr. Hargraves provided a recommended action based on the state's recommendation. As a reminder, board members, we have the ability to accept that recommendation or determine to do something different. So at this point, let's discuss what we feel is the appropriate form of discipline.
I'm willing to start things off for discussion.
Please.
For my thoughts, I am more partial to our traditional discipline from the grid. I know that's controversial in this case, according to the defense attorney, but I am still thinking of $100 per violation. There was 11.75 hours. Each of them is a separate violation. So $100 for each violation puts us at $11.75, and plus the 1.5 times the customary amount. I know those are disciplinary, and I know the respondent does not want disciplinary, but to be fair and consistent across the board, in my discretion, I don't think there was anything in the evidence presented by the defense that made me feel like the guidance would not apply and that I need to use discretion. So that's kind of where I am headed.
Is that a motion, Mo?
At this point for discussion, but if nobody has any discussion, I will make the motion.
I agree with you.
Yeah, if it's a motion, then I will second that.
And I tend to agree as well. I mean, to me, the grid that has been in question to me is that it's guidance. We don't always act 100% on it. It is to apply consistency and fairness, but each case is weighed on its own merit. To me, there's been nothing that has been exceptional in this case that would warrant us to address it any differently than we would traditional cases. There hasn't been anything substantiated that would make me feel differently about it. So I had a motion by Mr. Solari and a second by Mr. Dang.
Madam Chair, if Mr. Solari can formalize the motion, I don't think he said that was his motion.
Okay, thank you.
And Mr. Solari, what if not signed?
Okay, let's address that then. Let me make a formal motion. At this point, I will continue with $100 per violation. That'll bring us to $11.75, then 1.5 times the CE for the next review period. This is unfortunately disciplinary. We will offer this consent agreement. If not signed within 90 days, and the fee paid, if not signed within 30 days and the fee paid within 90 days, then we will hold a hearing to revoke the license.
Madam Chair, members of the board, I would just like to remind the board that this is an administrative hearing. You do not have to offer a consent agreement. You have the authority to issue an order. You've just adopted findings of facts and conclusions of law.
Thank you, Mr. Harris. You are correct. My apologies then. Then that is an order. Pay within, pay within 90 days. I guess that's the end, right?
Would staff mind rereading it so that everybody is clear what the motion is?
Certainly, I believe Mr. Solari's motion order is $100 per CE, which would equate to $1,175 for the deficiency of all the CEs, 1.5 times CEs for the next renewal cycle. It was customary, and I don't know if you want to add this, Mr. Solari, is to an automatic re-audit for the next cycle as well. And if not signed in 30 days and paid within 90 days, you indicated you wanted to go to hearing for revocation, or you can order the license be revoked after 90 days if not paid.
Um,
That part wasn't clear, Mr. Harris.
That's correct. My understanding was that you were just going to issue a order based upon your findings of facts and conclusions of law that would address the civil penalty, the
Correct.
deficiencies, and an audit. Is that correct, or did you want to add additional terms?
That is correct, sir. And I do want to add the additional term. Thank you for Dr. Gandhi for reminding me that automatic audit for the next review period. That is correct. I would like that included in the motion, just to be clear and consistent.
And just for clarity, I would like to ensure that
Quiet.
that the order says $100 per violation.
Where's your
So
motor?
that is my
To be clear.
Yes, ma'am. That is my intention, and I want to be clear about that. $100 per violation.
So I have a motion. Is the motion clear? Do I have a second for the motion?
Second.
Any further discussion?
Yeah, this is Goodman. Oh, go ahead if
Yes.
someone else.
Oh,
wants
no,
to.
no, please, Mr. Goodman.
Yeah, I believe we should go with what the state proposed of the 2,000, not the 100 per credit. And you know, if this motion goes to a vote, that'll be why I'm voting against it. Or as it goes to a vote.
Any further discussion? Board
Madam
members?
Chair, the only
Yes.
clarity is I know Mr. Solari added that if not paid within 90 days to go to hearing for revocation. Or did he want to revoke the license if not paid in 90 days?
No, I was I was mistaken. Mr. Harris set me straight. This is an order, and if not paid within 90 days, we revoke the license. We're past the hearing stage, so it's the order to revoke, should it not be paid.
Is that your amendment to your motion, Mr. Solari?
Yes, that is an amendment. It was my initial intention. I just misunderstood or mistook, and Mr. Harris was kind enough to correct me.
And Madam Chair, members of the board, to be clear, if that is your ultimate, if that's the order that's issued, if there's any non-compliance issues, my understanding is that a complaint would be open for non-compliance and it would proceed down that path. Is that correct?
If that's the direction the board is going to give board staff, yes, that would be.
Okay, and that's my understanding of your motion. Is that correct?
Yes, sir. Thank you.
Thank you.
Mr. Dang, are you okay with that amended second?
I'm okay with that, yes.
Any further discussion, board members? Dr. Gandhi, can you please do a roll call vote?
Certainly, Madam Chair. Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Nay.
Mr. Leyva?
Aye.
Ms. Lehan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
No.
There.
Aye.
7-2, Madam Chair. Ayes have it.
Thank you very much. Ms. Boyce, Mr. Bozen, thank you for your attendance today. This concludes this matter.
Thank you.
Thank you for attending. Dr. Gandhi, looking for some direction on where to go on the agenda. Shall we proceed with the rest of the hearings, or do we need to take something else out of order since it's almost lunchtime?
We can take something out of order, Madam Chair. 29A, I believe that is a motion strictly for rehearing to determine whether we want to go to hearing again with new additional information or not. So.
Okay, board members, let's jump to item 29A. This is the date, time, and place where Oscar Augustine Lopez's motion for rehearing is scheduled to be heard by the Arizona Board of Pharmacy in case number 20-0388 PHR. Will the parties please introduce themselves for the record, starting with counsel for the state?
Yes, Seth Hawgraves, Assistant Attorney General on behalf of the state.
Dr. Gandhi, is Mr. Lopez present?
Madam Chair, he is here in the board office. We will set him up with a computer and a microphone.
Okay. Oscar Lopez, Oscar Augustine Lopez.
Thank you. Pursuant to AAC R23 128D, the board may grant a rehearing of the case if Mr. Lopez establishes that one or more of the 8 grounds listed in rule may materially affect his rights during the administrative proceeding. The board has reviewed Mr. Lopez's motion for rehearing in response to the motion filed by the state. Each party will have 5 minutes to address the board on this matter. This is the time for a legal argument related to the grounds for rehearing, and parties should not use this time to present new evidence or testimony to the board regarding the merits of the case. Mr. Lopez, your arguments to the board, please clearly identify and explain the grounds that support your motion for the rehearing. Mr. Hargraves, in your arguments to the board, please clearly identify and explain why the state does not believe that Mr. Lopez is entitled to a rehearing. We will now proceed to the oral argument. Mr. Lopez, you will present first, followed by Mr. Hargraves on behalf of the state. Mr. Lopez.
Sorry about that. I'm kind of new at this. The reason why I worked my butt off to get where I'm at. I graduated high school in 06. I haven't went to school since then. And then when I went back to Carrington College, become a pharmacy technician. So I'm trying my hardest to amend what I did was wrong to justify for my, I guess, how you say, just trying to justify for everything I did wrong.
Mr. Lopez, as I stated in my opening, could you please state the specific grounds in which you feel meet the burden of proof for a rehearing?
Can you clarify that for me, please?
There are 8 grounds for a rehearing. In order for us to rehear the case, you need to provide proof that you meet one of those 8 grounds.
What are the 8 grounds exactly?
Mr. Harris, do I need to answer that, or do I just proceed with the states?
You could let him know that those 8 grounds are set forth in rule. I don't know if there is a copy of the rules available that could be presented to him. I will say this is the time and place. He was notified in the order of his specific responsibilities. So it is incumbent upon him to set forth the reasons why he believes he's entitled to a rehearing.
We're getting him a copy. He has a copy.
Madam Chair, I just provided him a copy of my response that laid out the 8 grounds within it.
Thank you, Mr. Hargraves.
Okay, so I've read them. I'm kind of briefly don't understand them, but from what I'm understanding is, so I know that the state, that PillPack has brought me here under the fact that they said they gave me a pre-employment drug test, which I did not receive until 3 months into my actual job starting there.
Thank you, Mr. Lopez. Mr. Hargraves.
Yes, thank you, Madam Chair. In his request for rehearing review, Mr. Lopez stated he wants to appeal so he can have justice for the crime that he's being accused of. This matter started when the board received notice that his employment had been terminated due to a violation of the company's zero drug free tolerance workplace policy. That resulted in the board opening a complaint. Mr. Lopez was notified that the board had opened a complaint, requested he respond and provide a written explanation. He didn't do so. He was then sent a subpoena requesting that he respond to the complaint and allegations. He didn't do so. He was notified that the board would review the matter and his non-response at the complaint review committee. There was no response from him. The board voted the matter to hearing. The complaint notice of hearing was issued, sent to his address of record by regular certified mail and by electronic mail, notifying him of the hearing and his requirement to respond. He didn't respond, nor did he show up at the hearing. At that time, the board deemed the allegations admitted, being the violation of the board's subpoena, and the board took action to revoke. Under your rules, Arizona Administrative Code R4-23-128D, it sets forth 8 grounds for which the board could grant rehearing or review. His request that he wants justice for the crime he's being accused of does not address any of those grounds that would support a rehearing or review. Throughout this case, he has had ample opportunity to respond and participate with the board, and he just chose not to do so. All along the route, everything was sent to the same address of record. The board did not receive any response until such time as the board took a final action to revoke. Mr. Lopez has had ample opportunity to interact with the board to address this issue, and he just chose, for whatever reason, not to. His motion, his request, does not provide the board any grounds or anything that the board can hang its hat on to support granting a rehearing or review. Therefore, the state would ask that the request be denied. Thank you.
Thank you, Mr. Hargraves. Board members, any questions for Mr. Hargraves or Mr. Lopez?
Madam Chair, may I ask Mr. Lopez the obvious question of why has he not engaged with the board staff? This has been going on since October of 2020. 7 months has passed. This is the first we've heard from him. Why did you not engage the board? Why did you ignore its subpoena?
Sorry about that. So it's not that I intentionally try to. One, I had the initial hearing. It was I believe last month. I mistakenly took the day off the day after. I literally came down here and I talked to the security guard. She told me I needed to make an appointment, and that was on my mistake. So that's as soon as I left, I sat in the parking lot, called the State Board of Pharmacy to see if what would be my next step. So that's when they told me to excuse me, to do the rehearing. So that's why I went and talked to, I believe her name was Jessica, if I remember correctly, because it's on my emails, to see if I can get the rehearing. That's why we're at the state we're at right now. We're at right now.
I just want to know why you ignored the subpoena. That's a legal document. Did you not receive it? Were you overseas serving in the military? Why did you ignore the subpoena?
Like I said, I didn't intentionally try to. I just I've been so busy with work, and I just kind of overstepped it in my emails. It wasn't like an intentional thing.
Thank you, Madam Chair.
Board members, any additional questions? All right. The board has heard the arguments of both parties and have reviewed the pleadings filed in this matter. The board may grant the rehearing, which means that the whole case or specified portion is reheard by the board. The board may also deny or affirm the prior decision. If the motion is to grant the rehearing, the maker of the motion must specify the grounds on which the rehearing will be based. Rehearing would then be limited to only such specific grounds. Do I have a motion?
Madam Chair, I make a motion that we deny the request for rehearing.
Second.
I have a motion and a second. Any discussion? Mr. Hargraves, is this a roll call?
Madam Chair, yes, please.
Dr. Gandhi?
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Mr. Minkus, that was an aye, just to confirm, right? It didn't come out clear.
Yes. Aye.
Thank you. Mr.
Ayes have it. This concludes the matter. The board's decision will be reduced into a written order and served on the parties. The parties will have further appeal rights that will be explained in the board's order. Thank you all for attending today. Thank you for being present, Mr. Lopez.
Thank you.
Dr. Gandhi, suggestions on where to go? Do we want to do one more hearing before we break for lunch? Or any
Madam
parties
Chair,
present?
I just
Go ahead.
want to address one thing. Under Agenda 25F, under conferences, we just got an email from the attorney representing, and it's a pretty extensive document, which obviously we're towards the latter quarter of our board meeting. We're looking at about 60 some odd pages to review. And I'm not sure if it's fair to review that at the 11th hour before this discussion may take place this afternoon. So just wanted to draw that to everybody's attention and see what we want to do with it.
Was there a reason it was so late? Because it's my opinion that it is not the right thing to do. Thoroughness.
Hi, everybody. May I address that issue?
Ms. Galvin, is that appropriate?
Yes, you may hear from them in response to Mr. Leba's question.
Okay, thank you. Mr. Mohajerian, can you please introduce yourself for the record?
Good morning, everybody. Al Mohajerian for Axia. And I emailed that not necessarily for content, just for reference purposes, that we have a May 11th hearing, which is next week, which is a writ with respect to the outsourcing license with the state of California. So I just wanted everybody to take note of May 11th hearing. Basically, when a state license was applied for, we went through a process and there is a writ before the Superior Court. So I don't think it's necessary for you necessarily to go through the content. I was just, my main point was the May 11th hearing, if that helps.
Miss Galvin, does the staff need time to review these documents? Are they material to the case today?
I wouldn't know
Madam
without
Chair,
reviewing them.
sorry, Ms. Galvin.
Yes.
I think it may be premature. I mean, since we have a May 11th court date, for us to discuss this matter today might be, I don't know what the outcome of that case is going to be. Ms. Galvin, any guidance?
I do not know what the outcome is going to be or what bearing it would have on this board's, the question before this board.
If I may add one more point, just quickly.
Go ahead.
It is the client's decision to shut down the business in the event May 11th hearing is unsuccessful, meaning that if he loses his argument with the Superior Court, then the entire thing is moot because he's going to shut down immediately. If that helps this board for, your decision-making process. And that can be put in writing to your office.
Ms. Galvin, that doesn't preclude us from taking action you deem fit at that time.
That's correct. It does not. You would still have jurisdiction to adjudicate the complaint.
Yeah, neither here nor there for me. I would be only in favor of being able to read through the documents and then come back the next meeting and to discuss the case.
And just to clarify, from a public safety standpoint, Mr. Mohajerian, we do have a statement on the record, correct, that you will not be that your client will not be shipping into the state of Arizona until this matter is resolved, correct?
Absolutely. We have a stipulation as of the last hearing. Yes.
Okay.
Correct. Yes.
So I would be, go ahead.
I was going to make a motion for executive session for obtaining legal advice. I have a couple of questions about what would happen if and that. And so may I make a motion for legal advice, executive session for legal advice?
Okay.
All those in favor?
Aye.
Aye.
Aye. Any opposed? Dr. Gandhi, are we closed out on the other room?
Yes, Madam Chair.
Okay. So board members, we have, I guess, a decision before us. Do we wish to proceed with the case? The conference item number 25F, given the new information that Mr. Mohajerian has provided to the board, or do we wish to table this to a later time?
I'll get things rolling. My preference, Madam Chair, is to continue this matter till the July meeting and table it. That's just my preference. I'd like the chance to read the material and make the best informed decision I can make.
I agree.
Is that your motion?
If there's no other discussion, I'll make a motion to table this matter till the July meeting to give us a chance to review the material and make a well-informed decision.
Thank you.
Second.
I have a motion and a second. Any other discussion? Hearing none, all those in favor?
Aye.
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 Any opposed?
Nay, Goodman.
Motion carries. Mr. Mohajerian, we will be tabling this matter till our July meeting or beyond, depending on the staff's review of the material and giving us the opportunity to review it beforehand. Thank you for your attendance today.
Madam Chair, if I may add, we do have an agreement. If we identify products being shipped and violating that agreement, we'll keep you posted.
Thank you. Seeing that it is now afternoon, let's break for lunch. How long do we want to have? An hour or a half an hour?
Hour. Hour for me.
Be back at 1:06.
Yep.
Okay, thank you. Welcome back, everyone, from our lunch break. Dr. Gandhi, can you take roll to establish the quorum, please?
Early, Madam Chair. Mr. Solari? All right, gotcha. Mr. Dang?
At your service.
Mr. Minkus?
Here.
Mr. Leba?
Here.
Ms. Lehan?
Present.
Ms. Walmsley?
Here.
Mr. Tong?
Here.
Mr. Goodman?
Here.
And Ms. Nair?
Here.
All present, Madam Chair.
Thank you, Dr. Gandhi. Going back to the hearings, I believe we are on 28C.
Correct, and I don't believe Mr. Escobedo was planning on attending.
Okay. So let's go ahead and get started. This is the time, the date, time, and place where the matter dealing with Devin Alexander Escobedo, board case number 20-0010 PHR, is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine whether there have been violations of the board statutes or rules and whether there is disciplinary action warranted. The board is committed, we can probably skip that part. Board members today, board members present today include Lori Walmsley, Kristen Snare, Joseph Leba, Kevin Dang, Ruben Minkus, Mohammed Solari, Theodore Tong, Cedar Lehan, and Nick Goodman. Let the record reflect that the board members have been furnished copies of the complaint and notice of hearings and all pleadings of records. Will the parties please introduce yourself?
Jean Galvin, Assistant Attorney General for the state. And Mr. Escobedo is not present.
Thank you. Given that the individual is not present, Ms. Galvin, how do you wish to proceed?
We will put on a brief case, as this was a summary suspension. We were required to hold the hearing forthwith, and we did not, we are not able to file a motion to deem.
Okay, thank you. A hearing of this nature differs from court proceedings. The technical rules of evidence do not apply. Reliable hearsay evidence is admissible. The board will entertain objections concerning irrelevant, repetitious, or otherwise inadmissible evidence. Each party will be allowed to present evidence, cross-examine opposing witnesses, and make a closing argument. In a disciplinary proceeding, the state bears the burden of proof and shall present their case first. Each party may now make an opening statement. This is a brief summary of how you intend to present today. Does the state wish to make an opening argument?
Yes, briefly, Madam Chairman. The mission of the Board of Pharmacy is to protect the health, safety, and welfare of the citizens of Arizona by regulating the practice of pharmacy. The board accomplishes its mission in part by issuing licenses to pharmacists, interns, and technicians who meet the statutory qualifications, and by ensuring that those who commit unprofessional conduct are held accountable. Today, you will hear about respondent Devin Alexander Escobedo. He is a licensed pharmacy technician who worked for a Walmart pharmacy in Mesa until he was terminated for diverting drugs in February of 2021. On March 9th, 2021, Walmart was notified the board respondent had been terminated, and the board opened an investigation. The board's deputy director, Ms. Jennifer Galvanon, will testify to the results of the investigation. You will learn that on January 24th, 2021, while filling a prescription for tramadol, respondent diverted a bottle of tramadol into the trash at the fill station where he was working. Later that evening, he is captured on security camera approaching the trash compactor in the back stockroom with a bag of trash from the pharmacy. He appears on video to search the trash bag, and he removes one stock bottle from the trash and places it in his pocket. He then puts the trash bag in the compactor and leaves the stockroom. As part of the investigation, the board noticed Mr. Escobedo of the pending complaint and subpoenaed a response to the complaint along with any relevant documentation. Respondent has yet to file a response nor comply with the subpoena. On April 14th, you will recall the board held a special meeting to consider the factual allegations against Mr. Escobedo. He did not appear. After considering the evidence and the seriousness of the allegations, the board voted to summarily suspend his license. Respondent was provided a copy of that order as well, and he has yet to communicate with the board. At the conclusion of the hearing, the state will respectfully request that you revoke Mr. Escobedo's pharmacy technician license. Not only did he divert tramadol from his place of employment, he has demonstrated his inability to be regulated. And the state would call as its first witness the board's deputy director, Jennifer Galvanon.
Dr. Gandhi, can you please swear in the witness?
Certainly, Dr. Ganavong, can you raise your right hand, please? You swear that the testimony you're about to provide will be truthful and complete?
Yes, I do.
Thank you.
Ms. Galvanon, could you tell the board what position you hold with the board and what your responsibilities are in that position?
Sure. I'm the deputy director at the Board of Pharmacy, and my responsibilities are many and varied, but include upholding the mission of the board.
Okay. Are you familiar with Mr. Escobedo?
Yes.
And who is he?
He is a licensed pharmacy technician.
Please refer to this, what has been marked for identification as State's Exhibit Number 1, and identify that document for us.
This is a copy of his pharmacy technician license.
And we see that that expires in October of 2021. Is that correct?
That's correct.
And what is the purpose of today's hearing?
The purpose of today's hearing is to review the incident that occurred at his previous employer.
Okay. Refer to what has been marked for identification as State's Exhibit Number 2 and identify that document for us.
This is the document dated March 9th, 2021. It's a notification from Walmart to the Board of Pharmacy regarding this employee's or this individual's termination.
And does it say why he was terminated?
States that he was terminated for gross misconduct and theft of controlled substances.
So you receive this information and you open a complaint, is that correct?
That's correct.
Please refer to what has been marked for identification as State's Exhibit number 3 and identify that document for us.
This is a notice of complaint to Mr. Escobedo as well as a subpoena.
And he is asked to provide certain documentation via subpoena and the request or the notice of complaint. Is that correct?
That's correct.
And does he comply with the subpoena or the request to submit documentation?
No, he does not.
So he does not provide a response and he does not provide documentation as requested in the subpoena?
That is correct.
You are investigating this matter. Do you have contact with Walmart during this time?
Yes.
Okay.
Yes.
And do you receive a copy of their Walmart's investigation?
Yes.
Is that investigation contained at exhibit number 4? Which has been marked for identification as State's Exhibit number 4?
Yes.
Okay. Could you just briefly walk us through what these documents are that are contained within that exhibit?
Yes. The first document is the notification of his termination, followed by a DEA Form 106, a statement from Walmart regarding their interview of Mr. Escobedo.
And what briefly transpired during that interview? Did Mr. Escobedo either admit or deny to the diversion?
No, he did not.
What was Walmart's conclusion after that investigation?
Walmart made the decision to suspend Mr. Escobedo and contact police to file charges based on sufficient evidence.
And Mr. Escobedo also provided a written statement that is contained within the exhibit number 4, did he not?
Yes, he did.
Also included in Walmart's investigation was video from their surveillance system. Is that correct?
That's correct.
All right. And that was provided to you by their loss prevention team?
That's correct.
Okay. The video is going to be marked for identification as State's Exhibit number 5. And we're going to ask you to share your screen in a minute. But before we start the video, could you kind of please orientate the board members? What are they going to see on this video?
Sure. What you will see is Mr. Escobedo beginning the fill process for a prescription, retrieving 3 stock bottles from a shelf in the pharmacy and placing them on the filling station, opening a partial bottle and pouring the contents onto the filling tray and counting tablets, returning back to the aisle and retrieving a 4th stock bottle. You'll then see him opening a new stock bottle, counting out an unknown number of tablets and dumping the remaining tablets back into the stock bottle. At the 11:16 a.m. and 32-second mark, you will see him push one of the original bottles with an unknown number of tablets that was on the fill station into the trash. You'll just then see him finish filling the prescription and placing 1 stock bottle with an unknown number of tablets back onto the shelf. At the end of the video, at the conclusion, you'll see him approaching the compactor in the back stock room with trash from the pharmacy. You'll then see him open the trash bag and search through the bag. He then removes what appears to be 1 white stock bottle from the trash and places it in his front left pocket, and then places the remainder of the trash in the trash compactor.
Okay, if you would go ahead and share your screen, please, and play that video.
Okay. Is this large enough for everyone to see?
I believe so. I haven't heard that anyone can't see it.
Yeah, we can see it.
It
There is
is.
a little bit of feedback with the devices in the room.
And the video has concluded.
Okay, thank you. So you and your staff received this information. Walmart's investigation is complete. Then the board holds a special meeting on April 14th of 2021. And the result of that meeting is a summary suspension. Is that correct?
That's correct.
Please refer to what has been marked for identification as State's Exhibit number 6. And is that the interim order that was issued for the summary suspension after that meeting?
That's correct.
And was it sent to respondent's last known address of record? Yes. Did you receive, I believe it was also sent regular mail and email. Did you receive any copies that returned to the board?
No.
And then at exhibit number 7, we have the complaint and notice of hearing. And that sets forth the facts and the alleged violation. Is that correct?
That's correct.
And that was also sent to his last address of record?
Correct.
Were any of those documents returned to the board as undeliverable, or did they bounce back?
No.
At the conclusion of this hearing, could you please tell the board what it is, what sort of discipline that the state seeks with respect to Mr. Escobedo?
This revocation of his license.
And why is that appropriate in this instance?
And because in this instance, he's demonstrated that he is unable to be regulated.
And he also has diverted medication, a prescription controlled substance, has he not?
Yes, that is correct.
I would move exhibits 1 through 7 into evidence. The state has no additional witnesses and would rest.
Madam Chair, I'll make a motion to accept exhibits 1 through 7 into evidence, please.
Thank you, Mr. Solari. Do I have a second?
Second, it's Kevin.
Dr. Gandhi, roll call, or do we, no, we don't need a roll call for that. All those in favor, aye?
Aye.
Aye. Any opposed?
Aye.
Mr. Escobedo is not here. The state would have a brief closing argument if it would please the board.
Yes, please.
So the evidence presented to the board today was clear and uncontroverted. It was clear that respondent diverted tramadol from his place of employment. He's captured on video moving a stock bottle to the trash receptacle at a workstation, later taking the trash bag to the back stockroom, retrieving the bottle from the trash and placing it in his front pants pocket and throwing the trash bag in the compactor. The respondent also has failed to communicate with this board. He did not file a written response to the complaint. He did not comply with the subpoena. He did not appear at the hearing where his license was summarily suspended. He did not file an answer to this complaint and notice of hearing, and he did not attend today's hearing. He is clearly unregulatable, and revocation is the only appropriate remedy in this instance. We request that you find him in violation of the statutes as set forth in the complaint and notice of hearing. Thank you.
Thank you, Ms. Galvin. The board can now begin with general discussion or entertain motions to make the findings of fact, conclusions of law in a final order. Is there any discussion?
Hearing no discussion, ma'am, I'm willing to make a motion. I just want to clarify, the correct motion is to go to the adopting the factual allegations since there was no request to deem, right?
That is correct.
Okay, then I'll move the board to adopt the factual allegations and the allegations of unprofessional conduct from the complaint and notice of hearing as finding of the fact and conclusion of the law, please.
Do I have a second?
I'll second.
Dr. Gandhi, roll call, please.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Lebo,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Ayes have it, Madam Chair.
Now it's time for us to deliberate the discipline. The state's recommendation was revocation. Do I have a motion?
Madam Chair, I'll make the motion to grant the state's request for revocation of the license in this case.
Second.
I have a motion and a second. Any discussion? Dr. Gandhi, roll call, please.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Lebo, Mr. Lebo,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Ayes have it, Madam Chair.
Thank you very much.
Thank you. This concludes this matter. The board's decision will be reduced to an order. Thank you for attending today. Moving on to item 28D, Jacob Emmanuel Sabino. This is the date, the time, and the place where the matter involving Jacob Emmanuel Sabino, board case number 20-0382, is scheduled to be heard by the Arizona State Board of Pharmacy. This is a formal administrative hearing to determine if there have been violations of the board statutes and rules and whether disciplinary action is warranted. Board members present today include Lori Walmsley, Kristen Stair, Joseph Leba, Kevin Dang, Ruben Minkus, Mohammed Solari, Theodore Tong, Cedar Lehan, and Nick Goodman. Let the record reflect that the board members have been furnished copies of the complaint and notice of hearing and all pleadings of records. Will the parties please introduce themselves, starting with the state?
Jean Galvin, Assistant Attorney General on behalf of the state. Madam President, members of the board, this was to be a formal hearing. prior or just after the complaint notice of hearing was issued, Mr. Sabino contacted myself and the board staff and expressed his desire to voluntarily surrender his license rather than participate in a hearing. And that consent agreement is before you, and I would ask that you accept the consent agreement, voluntarily surrendering his license, and vacate this hearing.
Thank you, Ms. Galvin. Board members, any questions for Ms. Galvin?
Chair,
I'm sorry.
I said, Madam Chair, I'll make a motion to accept the recommendation of the state that the voluntary surrender and vacate the hearing.
Second.
Thank you. I have a motion and a second. Dr. Gandhi, can you take roll call, please?
Certainly. Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
Ms. Nair.
Aye.
Thank you.
Concludes this matter. Dr. Gandhi, we're going to go back to conferences under tab 25, correct?
That is correct, Madam Chair. 25D would be the next one.
Okay, item 25D, case number 20-0453. I am recused from this matter, so Kristen, if you could take over, please. Thank you, Mr. Harris. Appreciate you.
Likewise, thank you. Wish you a good rest of the board meeting.
Thank you, Mr. Harris.
Okay, so on this matter, we have want to check to see if respondent Ariana Rowe is available.
She is, Madam Chair.
Okay. Is there someone in staff who can tee this up for us?
Yes, I can do that.
Thank you.
So I'm back in on October 19, 2020. We were notified of a suspension of Ms. Rowe's fingerprint clearance card. Stated that she was arrested for felony drug paraphernalia, possession and use, and 2 counts of misdemeanor DUI and misdemeanor extreme DUI. Ms. Rowe did not disclose these charges to the board within 10 days. On November 4th, 2020, we issued her a complaint notice and subpoena with a response due by November 19th. During that time, Dr. Gandhi spoke with Ms. Rowe and requested that she provide arrest reports, court records, and a statement of what took place when she was charged. During that call, Ms. Rowe did admit to the use of recreational marijuana. On November 18th, she provided a personal statement and partial police records. However, she did not provide court documents or responses to why she failed to report the charges or her current place of employment, which was requested in the subpoena and by Dr. Gandhi. As of the time of this report, there is no record of employment for her in our database. On November 23rd, 2020, she was issued an interim order for substance use and abuse evaluation. The results of that are in your board file. She was not timely with this order. That included providing the date and time of her evaluation and name of her provider. That information was provided approximately 18 days after it was due per the order. She was also required to complete her evaluation by December 23rd. On December 21st, we were informed by Ms. Fine that an evaluation was scheduled on January 6th due to the holidays. Ms. Rowe did complete her evaluation on January 6th, but again, this was untimely based on the order. Ms. Rowe's written report from her evaluator was due by January 22nd, but we established a new due date based on the evaluation being completed late. Ms. Rowe did not provide the written report by the due date. I contacted Ms. Fine on February 8th, and she provided a copy of the report to me. Again, Ms. Rowe's evaluation is contained within your board file. There is a recommendation that was made by the evaluator. Ms. Rowe, at the time of this event, Ms. Rowe indicated that she would like to the board to accept what was ordered of her by the courts versus what could be asked of her by the board. The board offered her an opportunity for a consent agreement, and she insisted on using what was ordered by the court. So that is the nature of this complaint, and she ultimately requested to appear before the board to discuss the matter.
Okay, thank you very much. Ms. Rowe, can you please state your name for the record, and then you'd like to start off with a statement to the board? If you're speaking, we can't hear you. I'm not seeing or hearing you, actually.
I have requested Ms. Rowe to unmute herself, but she would have to do that on her end. I can't unmute her.
Well, I'll get the discussion started while she's trying to work on the technical side of it. It looks like we have an evaluation here. One of our evaluators did make a recommendation, which was that she would benefit from outpatient substance abuse counseling to be done once per week for 3 months. Anybody have thoughts on that? I personally would like to stick with what the evaluator had suggested. That's my thought on it, but does anybody have anything else to add while we're waiting on Ms. Rose to be able to work out her difficulties with technical?
No, Ms. Nair, I think I would like to hear what she had to say.
Yeah,
Maybe we
me
can
too.
go to the next item and come back to Ms. Rowe.
Yeah, thanks. I agree. Just hoping we could get it moving, but technology doesn't always play along, right?
Ms. Nair, I just tried reaching her phone and it rang and went to voicemail, so I will try again. So yeah, if we can
Okay.
circle back, that'd be great.
Sure, yeah, sure.
Do we want to table this one and come back to it, or do you want to keep moving forward?
We can't move forward without her. I would recommend we table it and come back.
Do we need to make a motion, or we just go back to it?
I would just move on. I would move on.
Yeah.
All right, let's come back to that one then. Item 25E, complaint number 20-0534, Bashis number 55, and Anthony Champagne. Is Mr. Champagne and somebody from Bashis in attendance?
Mr. Champagne is on, yes.
Thank you. Ms. Richardson, I believe you were the compliance officer for this case. If you could please give a brief summary.
Yes, I will. This complaint was received through an anonymous source in December of 2020.
There was both a complaint and some questions regarding the legality of the filling of a controlled substance prescription at this particular pharmacy. After inquiry, the board staff opened a complaint and an investigation was conducted on 2 specific prescriptions in question. The first one, I did visit the pharmacy personally on January 6th. I spoke with pharmacist Anthony Champagne. Again, I didn't have a written complaint to present him as this one was requested to remain anonymous. The first prescription that I viewed was for a Schedule II controlled substance, Adderall. The pharmacy didn't have the full amount that they needed at the time that they filled that. It was partially filled and dispensed, and then the balance filled the following day. It was reran through the computer system for the full quantity prescribed, and then the balance dispensed. While the computer record and the billing and the PMP show when full dispensing occurred for the full quantity, the pharmacy did have appropriate written records documenting what had occurred, how many the patient received on each day. There is also a note in the computer system that reflects the correct amounts dispensed on the appropriate dates. The second prescription reviewed was for Temazepam 15 milligram. This prescription was on a pharmacy refill request form that was originally for Triazolam 0.125 milligrams to be taken twice a day. And there was a space for the prescriber to fill in a new prescription as is required when requesting a refill for a controlled substance. There was a note, however, written on this one indicating to the prescriber from the pharmacy staff that the Triazolam was not covered by the patient's insurance and that the insurance preferred 3 other choices, one of which was Temazepam. The blank prescription form had been faxed back to the pharmacy with a prescriber's signature, but there had been no prescription written in or indicated, circled, anything like that on the form by the prescriber. However, Mr. Champagne, the pharmacist, did fill in a prescription for Temazepam 15 milligrams, one at bedtime as needed. I asked Mr. Champagne about this particular prescription, and he told me that the prescriber's office that this is from is actually hard to get a hold of and had done some computer updates causing some issues in communication lately. He stated that the pharmacy had been attempting to get the patient's original Triazolam prescription approved on their insurance for several months. That authorization was subsequently denied by the insurance company. Mr. Champagne said that in order to get the patient taken care of, he used clinical judgment, chose a medication that the patient had not taken before, which was the Temazepam, and chose the lowest dose. He said that he also chose the one least associated with sleep in his judgment. He then told me that he left a voicemail with the office after the fact to let them know what he had done. I did ask Mr. Champagne if he realized that he was not able to do this. And he stated to me that he thought he could use the COVID waiver to perform this function of authorizing refills, which in his words, he does all the time with this particular office because they're hard to reach. I did tell Mr. Champagne that this was not the case of authorizing a refill, and that even if it were, that would not apply in this case as it is a controlled substance. I informed him that he's not able to prescribe. He then stated that he thought that pharmacists could now change prescriptions. I then again explained that this was not a case of prescription adaptation, for example, changing a package size, that type of thing, but this was actually writing a prescription by choosing the drug, choosing the dose and the directions. I did leave the pharmacy, asked for him to provide a written statement to the complaint. Later that day, I received a voicemail from Mr. Champagne stating that his pharmacy technician by the name of Nancy had reminded him and refreshed his memory that he had called the prescriber first and not after the fact. He stated that he just didn't remember which scenario had occurred with this prescription, as it does happen frequently. I did request a written statement from Nancy, which I did obtain, and that is also included in your board book. In her statement, she has a slightly different version in that she states that Mr. Champagne filled in the blanks, signed off, and left a message for the office letting them know what he had done. This was in line with what Mr. Champagne had originally told me on my visit. I also requested a written statement from the other pharmacy technician that works at that pharmacy. Her name is Jody. Her statement's also included for you. In her statement, she tells a similar scenario of Mr. Champagne speaking with the patient, choosing the drug, and then later leaving a message for the doctor's office. In Mr. Champagne's written statement, he states that he left a message for the office, asked Nancy to expedite the prescription. Insurance would not pay for twice a day dosing, so they ended up processing the temazepam for once a day at the lowest dose. When this complaint came before the complaint review committee, a request was made that we follow up with the prescriber's office to see if there was any type of arrangement or any agreement between Mr. Champagne and the prescriber to allow this type of activity to occur. On March 26th, I did phone the office. I spoke with Helen Evans, the medical assistant for the prescriber. The prescriber was out of town for a family emergency. Ms. Evans proactively asked me if it was regarding the situation at Bashas', that she was already aware of this situation being investigated and that she had been directly involved in the incident, being the one who had discussed it with the prescriber at the time that it occurred. So I did go ahead and ask her about the situation. She confirmed for me that the prescriber had signed the form without filling in the information and that she, Ms. Evans, had personally faxed the form to the pharmacy. She stated that they were later informed by Mr. Champagne that he had selected the temazepam for the patient and had dispensed it. She did note that the prescriber did not see a problem, allowed the patient to continue on that particular medication. Ms. Evans did inform me that this has happened before with Mr. Champagne, but they didn't think that he had done anything wrong. She did confirm there is no agreement in place allowing this type of activity on behalf of the prescriber.
Thank you, Ms. Richardson. Mr. Champagne, can you please introduce yourself for the record and if you'd like to make a brief statement before we proceed with questions?
Yes. Okay. Initially, when this incident was brought to my attention, I was kind of caught off guard. So I didn't have all of the details or the facts at present time because it had happened almost 2 months prior. And it was during the first week in January when we were under duress as a pharmacy. So I didn't really have time or the wherewithal to recollect all of the pertinent details that to Sharon during her verbal investigation or investigation at the pharmacy location. After the fact, we started putting the pieces back together. This incident had actually been going on since verifiably since late September and October and November, and then finally dispensed in December. There were a number of conversations that occurred with the practitioner throughout this process. The reason that the prescriber signed it and faxed it back is because we did have a discussion about choosing the temazepam. It just that she signed it and then sent it back in. I then tried to reach out to her and get an actual prescription for it. And that never happened either. Then that conversation was more so me just circling back around and letting them know, hey, I'm dispensing the temazepam and going forward from there. I then also almost immediately got a conversation back confirming that that was the case. They asked if they even asked if they should send back another prescription, which in hindsight would have taken this whole scenario and removed any unidentifiable facts. But I figured I had spoke with the practitioner, the patient had known, and I was off the next few days. So I didn't want that fax to come in and actually not get transposed over the old one, but accidentally entered in as a new prescription. So I said, no, everything is okay. I do admit I did not document accordingly, which also would have helped strengthen, the uncertainty of the events that happened. And I also, in the interim of this, I also have a statement and a letter that was submitted from the Wickenburg Clinic confirming all of this. I sent it to the deputy director earlier this week. It did take me a great deal of time because Renee Bishop was another person at that location that I had worked with extensively. And she was unable to, she had COVID related issues and she's been very difficult to get a hold of directly. But speaking with Helen, the MA for Jenna Savage, she facilitated a letter. My question is, has everybody been able to read the letter or at least see the letter that I sent over earlier in the week?
Yes, it was included.
Okay. I do also acknowledge that I could have handled this better, and there is some missteps and wrongdoings on my part, but it isn't like I was writing my own prescriptions or making clinical decisions that are above my pay grade or above my licensure, what it allows. And I humbly, apologize for that. It was for patient safety. I was communicating with the office. As far as the other instances that happened, those were things that were happening because the system that they had put in place, they weren't receiving phone calls. They weren't receiving prescription refill requests. They weren't receiving, and I mean phone calls from anybody, patients, doctors, anywhere. So it was very hard and difficult to get a hold of them. So I would call them on a weekly basis and we would review the PAs and the prescription refill requests and things of that nature on a case-by-case basis. And we would approve them one by one verbally. Those are the instances that we were referring to. And those are the types of prescriptions that were understood under those manners were chronic medications like your metformins and your lisinoprils and your cholesterols and things that are chronic care meds, not something of this nature, where something in this nature was more an anomaly and an exception. And honestly, it's the only time it happened through this whole case. And it obviously will not happen again. And if anything does happen, it will be documented accordingly, which is probably my greatest error, because there was communication. It just wasn't documented on the hard copy specifically, which led to a great level of uncertainty, especially when I was a little bit blindsided at the time of the interview because I wasn't expecting it to happen. And again, we were under duress on January 6th, it being the new year. And also I was short a pharmacist and 2 technicians. We were slated to have 2 pharmacists and 4 technicians that day. And it was myself and 2 technicians solely.
Thank you, Mr. Champagne. I just want to clarify a couple things that you said.
Sure, absolutely.
So first and foremost, you did authorize some quote emergency refills because you weren't able to get a hold of the prescriber.
Those were the emergency refills were for chronic care meds because the patients could not get into the office, which is directly covered under the COVID relief.
Correct. I agree with you. That is allowed for non-controlled substances.
Exactly. I was, when I mentioned the COVID relief bill, when I was discussing with Sharon, I was more so trying to create or show that there was a working relationship together, not that I was directly using that in order to prescribe or write a prescription for a controlled substance. I know that that's not.
So did you ever authorize refills without a prescriber's authorization for a controlled substance?
No, I did not. I had a discussion with the office. It just was not documented correctly. That is also confirmed with the letter that I sent today. It was a misunderstanding, and I could have handled it better. So I'm not saying that I'm beyond, any guilt in this, but it's nowhere near as malignant as it may look as a pharmacist writing prescriptions for controlled substances on their own.
Okay. One additional question about the refills. So is this your normal practice outside of COVID that you would do this? If you weren't able to get a hold of a prescriber, that you would authorize refills?
Absolutely not. This was due to the fact that they were going through a major overhaul. They were, I believe, acquired by Honor Health, and their whole system was changed over to Honor Health system without any training. And then as a result, they lost a lot of personnel, which already made a bad situation worse. And then no training for anybody of the current or new people that they were using to replace them. So it created this big black hole where all requests for everything were not being responded to. And I was working directly with them as an exception, not the norm. And we aren't doing this anymore because they're back up and running. Yeah, this was an extenuating circumstance, not the norm.
Okay. And then related to the prescription for the temazepam. So
Yes.
you did therapeutically substitute within the same drug class
Yes.
for a controlled substance. Did you have the authorization from the prescriber to do that in advance?
Yes, I spoke with them before. I did not have the prescription. That was where, and all I had was a verbal with the prescriber's office. Okay, that I discussed
So you
with Helen.
discussed with them, but you didn't document it.
Yes, that exactly.
Okay.
That's the point. I didn't document it correctly, and because it had happened 2 months prior, almost by the time Sharon had come in, and the level of how busy we were at the pharmacy, I was unable to recollect at the time that she did her investigation. So I wasn't as of sound mind to have all the pertinent details and facts, because I was calling that office 2-3 dozen times a day for all different things, not just for this one here.
Okay. And I think technically that the therapeutic substitution within the same drug class is also covered within the governor's executive order. I can read from it here.
So too, but I wasn't. I don't want to claim to know it.
Just for the board members' discussion, I do think it's technically covered. Probably not good practice per se to do it for a controlled substance, but I think it probably actually is covered under this particular circumstance. That being said, I do feel better about hearing
Chair.
from Mr. Champagne. Yes, go ahead, Mr. Goodman.
Yeah, I've got some of a question here. Part of the narrative is that the phones were down, nobody could get in touch with them, but then the licensee was talking to that practice multiple times a day. How are you achieving contact when no one else could? And
I had a direct line to Renee Bishop. She was the administrative, she's the head administrator. So I had her direct line number. That was how I would get through to them in emergency cases. And then she would actually respond back in a timely manner, usually within the hour. But the regular number, 668-1833, area code 928, you call that number, it would put you into a black hole with no answer. That was quote unquote the incoming call for the whole hospital system. I had her number, which is 928-668. I forget.
Oh, yeah, it's okay.
It's okay. You don't need to
either,
give it.
but I was calling
Okay.
it regularly. That's how I was able to get through. And I did like a 911 message going, you call, we've discussed this. I don't have the hard copy. I'm dispensing it. And then that was where that came in. The technician, the anonymous technician who made the report, did not have all the pertinent facts, did not know the understanding of the working parts of the relation of what we were doing, does not know the details of the laws. It's above their pay grade and above their responsibility to know how, yet they made a complaint on their own regarding something, and also set a pattern and a story that only indicated incriminating facts, not the whole story, which is also another issue that I don't even really want to open up because it just turns into a he said, she said.
Yeah, let's keep it to the facts of the case.
Ms.
Board
Vaughn.
members, additional questions?
I have a question. Earlier you mentioned something about a letter that you sent today. Are
No,
you
it was sent
referencing?
earlier in the week.
Okay, you said today, so I was a little confused.
Oh, I
That
apologize.
was-
I'm a little
That was from
nervous.
the provider that you're
Yes.
talking about? Okay.
From the Wickenburg Clinic. And I can read it off if anybody has.
No, I've seen it. I just wanted to make sure I was understanding the same thing you were referencing.
Yes, and I apologize for the oversight again. This isn't something I'm used to doing, is sitting in a situation like this.
Madam Chair, Mr. Champagne disclosed that the office of Ms. Savage was purchased by Honor Health. I work for Honor Health, although I have no idea who these people are. Do I need to recuse myself?
I think it's Honor Health. I know they were purchased. That I could be speaking out of turn with that too. I just know that they were acquired by a larger hospital system. And it may be, I thought it was Honor Health. So please don't take what I'm saying is 100% fact. That And I apologize for misspeaking if that were the case.
Mr. Hargreaves, do you have any concerns?
Well, at this point, we don't know for certain Honor Health is involved. If there is concern by Mr. Solari, he can certainly recuse to avoid the appearance of impropriety, but I'm not sure we have enough information that would establish a clear-cut conflict.
Okay, I just wanted to be on the record that I work for Honor Health, but I have no idea who Ms. Savage is, or I've never met Mr. Champagne before, and it's not going to impact my decision on the board.
Yeah, I don't believe Mr. Champagne's objecting to you continuing to participate.
I am not, no.
So
Thank you. Board members, any additional questions? Discussion?
I'm just curious, why not establish a collaborative practice agreement with this office?
I discussed that with them. There isn't any way for me to, I did work under that during internships and rotations and things of that nature with the VA. When I was with the VA, I had access to charting and things that I would not be privy to make any type of decision and honestly, it's above my purview to be able to do that with another office that I don't have any type of I didn't want to create a conflict between my employer and another. But I had discussed it briefly, but they would have to give me a lot more information on things. And being that we're already understaffed now, I didn't want to put my license or my, or the hospitals at any more of a risk by making blanket statements that I could do X, Y, or Z when I wouldn't be able to have access to all the facts in the case.
Madam Chair, may I ask a question?
Yes, please.
Ms. Richardson, did we ever contact a patient in this case or do any follow-up with them to make sure they didn't have any adverse effects or problems with this therapeutic substitution?
No, my understanding is the patient's still on the medication.
I actually did do follow-up because of this. I did follow-up the following, it was prescribed, I believe, on a Wednesday or a Thursday. I did follow-up on Monday. I also followed up with the office. 3 weeks later, I followed up with her again. She said that the dose wasn't working. I called the office but the back number again had them reach out to her directly on her cell phone. And then they were able to schedule an appointment and increase the dose per my recommendation as well. I actually went over and above to help this patient. It's just, I didn't document, and which is what led to the uncertainty, and then allowed a complaint to be filed. I did not document correctly, and if I did overstep what I was allowed to do, I do apologize, and I humbly accept any consequences that the board deems necessary. But that was not the intention to do anything incorrect. I was actually doing everything for patient care.
Board members, any additional questions?
Madam Chair, I'd like to make a motion that we dismiss this.
Thank you, Mr. Minkus. Do I have a second?
I generally agree with Mr. Minkus. I think this was a documentation problem, not a substitution problem per se. I generally see his point. But rather than dismissing it, I'd like to put a letter to file so that if this put a advisory letter to file so that this kind of thing happens again, or Mr. Champagne doesn't improve his documentation and he ends up in front of us again, there's a record of it. So my preference would be for a non-disciplinary letter, advisory letter to file rather than dismissing.
We still don't have a second to Mr. Minkus' motion to dismiss.
Mr. Minkus, would you be willing to go with an advisory letter and revise your motion, and I'll second it?
Yeah, I'll rescind mine and I'll second your motion for the advisory letter, and then we got it. We're all set.
Okay, thank you, sir. Then I'll make a motion for the advisory letter as I explained a little earlier.
Thank you, Mo. I appreciate it.
You cut out, Mo. What's the advisory letter for?
Advisory letter for poor documentation practices, non-disciplinary to file, and hopefully he will improve his documentation and won't be in front of us again.
Okay, thank you. I have a motion and a second. Any further discussion? All those in favor?
Aye.
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 Any opposed? Unanimous. Thank you, Mr. Champagne, for your attendance today. I appreciate it.
Thank you.
Board members,
Madam Chair, Ariana Rowe did unmute her phone.
okay, let's go back to 25D. Ariana Rowe, complaint number 20-0453. Ms. Nair, I'll turn it over to you.
Thank you. Ms. Rowe?
Yes.
Glad to have you here and joining us. Would you please state your name and then make a statement for the board, please?
Yes, my name is Ariana Rowe. I am here in front of you guys to talk about my case with the court and to see if I can do something to work with you guys regarding my consequences.
What specifically would you like us to consider today?
So I am court ordered to do some counseling. I will have to do about 36 hours of counseling. I spoke with Dr. Jaffries. He recommended me to do some counseling through someone that they prefer. And I am wondering if I could dismiss those and stick with the counseling that I'm court ordered to do, because I do not have a vehicle. I cannot drive farther than the surprise location. And I was wondering if I would be able to do that instead and report it to you guys when I complete it.
Pharmacists should deserve for doing this.
So you're saying transportation is an issue for you?
Yes.
Well,
Madam Chair, may I ask a question or get
Yes,
a
Mrs.
clarification? Dr. Jaffrey recommended 1 hour every week for 3 months. So my math says that's 12 hours of counseling. For a month times 3 months, 12 hours of counseling. The court is apparently ordering 36 hours of counseling, 3 times the amount. So the court counseling is significantly more than what Dr. Jaffrey recommended. I just want to make sure, board staff, am I correct with that?
Mr. Solari, I am aware of what Dr. Jaffrey recommended.
Ms. Rowe,
Go ahead.
have you provided documentation to the board staff that the court has ordered 36 hours of counseling to you?
I'm sorry?
Have you provided documentation to the board staff that the court has ordered 36 hours of counseling to you?
No, not yet. My case is still ongoing.
But you already know what they've asked you. Is that just that you finish your counseling and then your case would be complete? Is that what you're saying?
So I am still working with my lawyer, but he said based on my based on what I'm going through, he highly believes I will do 36 hours. I still have to find a counselor.
Are you currently employed?
Yes.
And do you go into a job site?
Yes.
How do you get there?
I use Lyft and Uber.
Okay. Ms. Scounavong, did you have something you wanted to add?
No, Ms. Mayor, just that we don't have documentation of what was mandated by the court.
Okay. So it's just an estimate from the lawyer of what could be.
Yes.
Does anybody else have any discussion, questions?
Can we clarify if she's working in a pharmacy?
Yes.
And Who is the employer, just so we know that we don't have any conflicts of interest, if you don't mind?
Walgreens.
We already took care of that one. Okay. And Mr. Leba?
Ms. Rowe, was this your first offense? Do I remember seeing that somewhere in the reading?
Yes, sir. This is my first offense.
Okay. So the one thing that I would say on this is that I am reading this. I'm okay with that. Here's the problem with it though. We do not have a way to monitor it. And I would look to Mr. Hargraves and Ms. Galvin maybe to confirm that or just shed any kind of legal advice on that. But and the other thing is it's still ongoing. We do not know what's going to be the outcome. And I'd leave it at that.
Yeah.
I agree. I do believe that that's the problem. She is only hypothesizing what she could be ordered. There is a wide gamut of possibilities, and that would be up to the court. And we don't know when the case will be finalized and what the order will call for. I would think that it would be problematic to allow her to substitute whatever the court orders with what our expert has recommended when we don't know what the court is going to order.
I feel like it would also be inconsistent with what we've done in the past.
And there is a good possibility that any counseling that follows what Dr. Jaffrey has recommended could be done virtually.
Okay, any more questions or discussion? If not, I would be glad to entertain a motion.
Can I say one thing?
Sure.
So my next court date is May 18th. Is there any way I can notify you guys when I do know the actual answer?
I'm just speaking for myself. It wouldn't change my opinion of how the board would handle it, but that's just my thought. Does anybody have anything else they'd like to add? Okay. And is anyone ready to make a motion? If not, I will make a motion that we follow our experts' advice here, that she be put on a 3-month outpatient substance abuse counseling track that's done once per week for 3 months.
And is this attached to a 3-month term of probation? Typically, when you require performance of a licensee and order then some sort of act or term that attaches to a term of probation.
Okay. A probationary term of 3 months.
And she would have to submit a written request to have that termination lifted or terminated upon demonstration that she has completed the counseling. And would you like a report from the counselor at the end of that 3 months?
Yes. And do we need to stipulate that it's one of our approved counselors?
That's typical.
Yes, I'd like to add that stipulation as well as what you suggested. Okay, so I have a motion. Is there a second?
Second.
Okay, any further discussion or are we ready to vote?
We will need a roll call because it is probation.
Okay. Roll call, please.
Sure. Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leva?
Aye.
Ms. Mahan?
Aye.
Ms. Walmsley is recused. Mr. Tong?
Aye.
Mr. Goodman?
Aye.
Ms. Nair?
Aye. Okay, looks like ayes have it.
That deals with the recommendation from Dr. Jaffrey and what she needs, going forward to ensure that she is safe to practice. You do have the failure to notify. And what would the board like to have that?
Anybody have thoughts, or we do have a typical thing that we follow, which is a $250 fine. Does anyone feel like that shouldn't apply here for any reason? Want to speak up about that?
And if you do go that route, that because we are in a conference, this would be an order.
Okay.
Is Rowe working now? Madam President?
Yes.
Yes, you said she's at Walgreens. Okay, then I would add to the order a $250 fine.
Second.
Second.
Payable within like
90. Do we typically do 90 days?
Yes, and
Okay.
that would coincide with her term of probation.
Okay. That makes it simple. Would do within 90 days. And roll call on that as well.
Certainly. Just a point of clarification, Ms. Galvin said it's an order. We're in a conference right now. It doesn't still, consent agreement still apply? I thought order was only during a hearing process.
Let me double check.
Ms. Galvin, while you're looking at, could we just make one motion and do the $250 fine for failure to notify within 10 days and the 3 months of counseling in one sweep?
Well, there's already been a motion to require the 3-month probation and the counseling.
Okay. I was just thinking to put the two together because we are talking about it's on the same complaint, basically.
Mr. Leba, is there a benefit to that you're thinking of?
We wouldn't having to do an order on top of it. We'd just be one consent agreement. That's it.
Okay. I just didn't know if that was a different, like two disciplines or something like you were thinking that way.
No, I was not on.
Okay.
You're right. It would be a consent agreement. I apologize.
Okay, so it's consent agreement for $250 civil penalty.
Yeah, do within 90 days.
All
I
right.
guess if not signed, proceed to hearing.
We have a motion and a second, Madam Chair.
I amended my motion, so we do need an amended second. Is that Mr. Dang that seconded?
Yes.
Okay, do you amend your second?
Yes.
Okay. Roll call. Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leba?
Aye.
Ms. Lehan?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Yes.
Ms. Nair?
Aye.
And Ms. Walmsley is recused. Okay, ayes have it.
Ms. Rowe, the board staff will get back to you with the paperwork for this matter. Thank you for coming today.
Okay, can I just ask a quick question?
Sure.
So if I'm clear, I have to do 3 months of counseling. I have to sign a consent form and I owe you guys a $250 fee.
Yeah, the board staff will get back to you on all the elements, but it sounds like you pretty much got it there.
Okay, perfect. Thank you very much, guys.
All right, board members, it's about 2:15. I think we should probably take a 10-minute break before we proceed into the next two items, since I think those will probably be primarily discussed together. Anyone object to taking a 10-minute break?
Sounds good.
All right, thank you. Welcome back. Thank you, everybody, for the brief recess there. Dr. Gandhi, can you take roll again, please?
Yep, Mr. Solari,
Ready, sir.
Mr. Dang,
At your service.
Mr. Minkus. Mr. Minkus.
I'm here. Sorry, Cam.
Oh, that's all right, buddy. Mr. Leba,
Here.
Ms. Lahan,
Here.
Ms. Walmsley,
Here.
Mr. Tong,
Here.
Mr. Goodman,
Present.
and Ms. Nair.
Here.
See, if we were all here in person, I wouldn't have to do this every hour. We're good.
Maybe in July.
Let's
all,
hope.
all accounted for, Madam Chair.
Thank you very much. 25F was tabled till the next meeting. So moving on to item 25G, case number 20-0423, Clark's Pharmacy, Erica Cardone, Rodolfo Dragon, Dina Sosa, and Christopher Rayfield. Ms. Richardson, you were the compliance officer in this matter. Can you please give the highlights of the summary, please?
Yes, I can. A patient filled a compounded T4 thyroid prescription at this pharmacy on June 4th. It was supposed to be for 50 microgram compounded capsules. On June 12th, the patient presented to the emergency room with tachycardia. She was subsequently diagnosed with hyperthyroidism and admitted to the hospital, where she remained until June 20th. The patient, after finding out about the hyperthyroidism diagnosis, requested that her doctor send those capsules to a lab for analysis, which they did. There is a report included in the book from Dynalabs dated 8/18, and it indicates the capsule strength was 4,016.6 micrograms. In October 21st, after this complaint was filed, I did visit the pharmacy along with compliance officer Sandy Sutcliffe. We did meet with pharmacist Erica Cardon. After presenting the complaint to her, we looked at prescription and compounding records. In reviewing the compounding record, the levothyroxine is not identified as being either T4 or T3. However, when you match up the lot number for the levothyroxine powder to the T4 aliquot formulation record, the lot number actually corresponds to pure levothyroxine T4 powder that would have been used to actually make the aliquot. It appears this is what was actually used in compounding the prescription rather than the usual 1 to 1,000 aliquot. If you calculate the strength based on the T4 powder, the pure powder instead of the aliquot, you would come up with a capsule strength of 5,000 micrograms instead of 50. When reviewing the aliquot formulation record, I've included that in your book as well. The aliquot formulation record for the T4 lists T3 as one of the ingredients, not T4. On some of the various records, the T3 has been crossed out, T4 has been handwritten in, other records still say T3. Entries are also missing the NDC or the name of the manufacturer. There are also some additional sample formulation records for other medications included. Example is progesterone. Those have ingredients that have been changed as well. They differ from one record to another, etc. The compound in question was prepared by technician Christopher Rayfield. I did obtain documentation showing that he was appropriately trained and periodically evaluated. He is what they call a lab technician. He compounded the prescription. Should be noted that he actually compounded it correctly according to what he was presented with. The error that occurred was actually in the formulation record itself, where the calculation was made based on using an aliquot, but the ingredient selected was actually the pure T4 powder. What was determined through investigation was that while attempting to select a product with a new lot number, technician Dina Sosa selected the incorrect drug and changed the formulation record from the aliquot to the pure powder. Pharmacist Erica Cardon did not catch that error when she was checking the record. It is unclear whether or not she was presented with any stock bottles for the ingredients that were used. The pharmacy has been working at the time of this writing. I did not have copies of new revised SOPs. The current SOP at the time for developing formulation records was included for your review. It did allow technician access to formulation records and development of formulations. However, pharmacist Erica has since become PIC according to her, and she's changed that process along with many other changes. A lot of those SOPs and various items that she's put in place since then to prevent this in the future are included for you to review. Response to the complaint was requested twice from the PIC. The PIC at the time was Rodolfo Dragon. Response had not been received. As I mentioned, Erica does indicate that she is now the PIC. Her electronic profile does reflect that. However, the profile for the permit itself does not show a change in PIC. It still indicates Mr. Dragon as of now. When I visited the patient in October, I obtained a sample of 6 capsules from a prescription bottle that was labeled according to the prescription in the complaint. 5 of those capsules I immediately took to Clark's Pharmacy, transferred those to Erica Cardon. I observed her prepare those, package them up for analysis, and ship them out to Eagle Analytic. That report is also included for your review. It indicates a strength of 2,888 microgram per capsule, which is a significant degradation in potency from the point that it was made in June. I am not sure how the medication was stored at the patient's home, although there were no special storage instructions indicated. The bottle did have a 180-day beyond use date on it. And it was still within that 180 days. And that lab report is also included for your reference.
Thank you, Ms. Richardson. Who do we have present from Clark's Pharmacy? If you could please introduce yourselves for the record, please.
My name is Rudy Dragoni. I am was the pharmacist in charge at the time, and I'd like to have a lot of comments if I could. And we have the new owner, Dr. Chambers, here.
Hello.
Are you currently the PIC or not?
No, we went in, Erica and I went in and changed it on the computer, okay, in October of 2020, okay?
So the answer is no. That's all I need for now.
Okay.
And, Madam Chair, Mark Bozen, counsel for Erica Cardone.
Thank you.
Erica Cardone.
Thank you. Who else do we have on the line?
And this is Carol Romano on behalf of Dr. Chambers and Clark's Pharmacy.
Thank you.
Chris Rayfield.
Ms. Romano, are you? Thank you. Ms. Romano, are you the attorney on their behalf?
I'm sorry, my what?
Are you the attorney on the behalf of the pharmacy?
Yes.
Thank you. Would someone from Clark's, I'm sorry, like to make a brief opening statement?
Yes, ma'am. Erica Cardone. I'm responsible for a huge error that hurt a patient. I was the pharmacist responsible for it going out that day. Like they said, what occurred was that T4 pure aliquot or pure API was used in place of aliquot. The formulation was originally correct, and in the refill, the ingredient was changed. And I should have caught that before it went to the lab and on final verification, but I saw what I was expecting that was actually there. So we've done a lot of corrective action and updates to try to prevent this from ever happening again, and I am confident it won't happen again. But I am really sorry that it did.
Thank you.
Madam Chair, looking at the packet, it looks like Dina Sosa is also listed as a party to this, and I see she is on the screen, but I don't think she had, she stated her presence.
Yeah, it looks
I'm
like she
here.
just popped on. Thank you. Can you please introduce yourself, Ms. Sosa?
I'm Dina Sosa, former employee at Clark's Pharmacy.
And you're a pharmacy technician?
Yes, ma'am.
Thank you. Board members, questions for Ms. Richardson or Clark's Pharmacy?
Madam Chair, I just wanted to clarify, we're doing these separately, right? 25G is the one we're doing right now, not H concurrently.
Yeah, to me, they're the same pharmacy, but they're a little bit different circumstances.
Okay, just wanted to make sure I form my questions for the right case. Thank you, ma'am.
Thank you.
Sure.
Board members, questions? Go ahead.
Let me see here. Ms. Cardone, could you have I don't want to call it an action plan, but you had a reply to what happened to the board that I read in there. Can you tell me a little bit about that and kind of what's transpired today? Has that been put into place, and are you following what you put down on paper?
Yes, sir. We have locked up the T4 and the T3. T3 is currently commercially available as a dilution. We're using that exclusively. T4 right now is on back order. So unfortunately, we're still having to make the aliquot. That aliquot is being tested. Each batch is being tested. Additionally, in the computer system, the T4 is inactive to be used for anything but a stock. And so that's no longer able to be selected for a formulation. Formulations are being checked differently by myself. I've started reading them out loud multiple times. There's more surveillance available in the lab by installing high definition cameras. There's speakers back and forth. Another pharmacist is double checking my work. So the API, the aliquot and individual compounds are being sent out for testing. There was significant training done. I did a number of CEs. They mentioned I updated the SOPs for the relevant sections. Stock logs that were problematic have been completely redone. And there was increased staffing allowed. This was a rush compound. And so those situations, promise times have been changed, and the staffing is allowing for me to focus more on what I need to be doing with less distractions and interruptions. And I did get the opportunity to talk to the patient a few times, and I met with the doctor as well. But it's still something I can't take back.
Didn't catch the last part, I'm sorry.
Oh, I met with the patient and the doctor. I just can't take back the harm I did.
In your words, what do you think happened? Where do you think it went wrong? Like, what was it that you, looking back, wish you could have intervened on?
I wish I'd thought to lock up the T4. It never been used. It was just something I didn't think of. And I wish I thought to inactivate it in the computer system and not have the technician access to change ingredient. A better way of updating lot numbers. And we are getting a new computer system with a lot more safeguards with barcode technology. We're switching to RX Dispense, which is designed specifically for compounding and has a lot of safeguards against human error like this situation.
Thank you. I do want to mention, I think it's one of the better responses to preventing a type of error from happening again. So I do thank you for that. Can you talk to me a little bit about the training that you instituted for your technicians? That's my last question.
Of course. We went over normal dosage ranges, and it's my job to catch that, but just so that they're aware, reminder that thyroid is micrograms, it'll never be in milligrams. We went over error prevention. We went over some quality assurance trainings, compounding best practice, reviewing of all that. I did reassessments on the staff. I have them listed in the corrective action if I'm missing one. Overdose education, so everybody, really understood what happened to this woman. And then requested that they do more CEs as well and reread 795.
Thank you.
Ms. Cardone, you mentioned that you've taken a number of continuing educations. I believe those are outlined in your response. Have you completed all of those continuing education programs?
One of them expired. I didn't realize when I started it, but I did over 10 continuing educations on thyroid, error prevention, compounding technique. But yes,
okay, thank you. So you've completed a total of 10 hours?
Yes, over 10.
And how about your technicians?
They are both no longer employed, so I wasn't able to follow or enforce it. They left during this situation or during this time.
Okay, thank you.
Madam Chair, may I?
Yes.
Mr. Dragon, you were the pick at the time this incident occurred. Is that correct?
That's correct.
The board staff requested that you send them a statement twice, and as far as I know, you did not. Why is that?
Well, first things first, when I found out that there was a problem, they called me on my cell phone, and I went in, and the inspector that was there, and she said to me, I will get back in touch with you, and I never got anything back. When I found out that we were going to be talking, I went in with Erica, sat at the pharmacy, and we sent in a message to the board saying that I didn't receive anything, but I wanted to be clear to exactly what had happened. If I can get a few seconds in right now, what I'd like to tell the board is that I've had a very big career. I've been a pharmacist since '85, been licensed in Arizona since the '90s. We've never had an issue with the board. In fact, there were times when the board came in and actually took my paperwork and brought it out before 800, before 795 to tell us that this is the way it's supposed to be done. I've treated the T3 and the T4, the straight one, like if it was plutonium, okay? But when I sold the store in 2019, I still remained PIC in charge, but I had some health issues. And I had open heart surgery, so because thereafter came the COVID, and it was scared of going in and getting infected. Basically, Erica was the one that was taking care of everything, and she did a phenomenal job. But I did not change the PIC, and that was my error. I trained her as best as I could because we do a lot of bioidentical hormones there. We're renowned around the country for it. We give a ton of information. We get calls at 2 o'clock in the morning, at 3 o'clock in the morning. Taking care of our patients is our number one issue. One of the things that as I was training Erica and trained everybody in there, we always say, I don't care if we don't make any money, but we got to make sure that the patients are taken care of correctly. Erica went above and beyond calling the patient, making sure that she was okay. She befriended the patient. And when the patient found out what was going on, she actually said, you know, I'm not going to continue anything. I'm not going to sue it because Rudy and your staff have been so good to us. And I can name hundreds of not only doctors, but also patients. So I really would love to retire with my reputation and the reputation of the pharmacy unscathed. I apologize sincerely because I was not on top of everything. And I apologize again that anyone would be harmed because of my unable to do something. But I really do believe, okay, that we did everything possible. I told her, I said, as soon as we found out there was something wrong, I said, pull the script, find out what happened, find out where it was going on. When we found out that there was a discrepancy, I said, weigh the pure powder immediately, see what was on. And before we had it analyzed, I said, look, there's a discrepancy in the pure powder from the log sheets. That tells us somebody used the pure powder beforehand. Okay, so before we even had analyzed, we already found out what was going on. Okay, but we dropped the ball.
Thank you. I do want to say, like Mr. Leyba, I was impressed with the corrective action that Ms. Cardone submitted. And in addition, I was also impressed by the action she took to meet with the patient and meet with the prescriber. So she did a good job there. I do want to say that.
Thank you.
Madam Chair.
Yes.
Question for Ms. Sosa. Can you tell us what took place and what you think happened? I remember in your statement, you don't remember exactly, but it looks like you were the one that changed the product out. Can you speak to that, please?
Yes, so when I first started working at Clark's Pharmacy, it was owned by Rudy Dragon, and I was trained in May. During the time when Rudy was, when the company was owned by Rudy, we didn't change lot numbers, so everything stayed the same. So when I was trained, I didn't realize that there was a difference between the bulk powder and the 1 to 1,000. So when Dr. Chambers took over the company, that's when we started changing lot numbers. and one of the lot numbers had changed. I didn't realize, I just noticed that I had to add in the new drug. I added it in as a bulk powder, not realizing, and it was sent off. And, you know, Mrs. James, you know, she came in all the time, so I knew who she was. You know, she was always really nice, and it was just really upsetting, you know, that this happened.
May I say something else?
Yes, go ahead.
When she says we didn't change, the text didn't change it, the pharmacist did.
Yes, that's correct. Sorry.
Yeah.
Chair, Ms.
Thank you.
Richardson, in your review, was the documentation in line, or was there record-keeping documentation of concern?
The record keeping was a concern. It is all manual record keeping, which is one of the things that Erica has said is changing. They're going to get a system that's more geared towards compounding. The paper records, as I said, for example, the T4 for compounding record, formulation record said T3 is one of the ingredients. In some cases that was crossed out and rewritten with T4. In other cases it wasn't, it still said T3. I believe, and there are samples of all of those in your packet as well. So the ingredients are listed incorrectly. The progesterone example that I gave you is the strength is crossed out. The inactive ingredient is handwritten in with a different amount. Then on a second sheet for the same product, that's not the case. So the ingredients, the inactive ingredients are different depending on which one you look at.
Thank you.
Board members, any additional questions?
One more for me.
Go ahead.
The technicians involved, we heard of the CE that Ms. Cardone had completed. Were you able to educate yourselves as well?
Not of yet. I just finished my CEs. Usually I wait a couple months, but that's definitely going to be a CE that I look into. After the issue happened, you know, me and Erica sat down.
Mr. Rayfield? You're on mute.
I did 20 hours worth of CEs last month. There were some on compounding. I would like to make it known, though, that I did not leave the pharmacy. I was fired over this. So I hate what happened. I hate that I missed catching it. I was great at, you know, catching mistakes, but we were so shorthanded and COVID was killing us back then. You know, it's, you know, not an excuse, but it did play into it. And I mean, I'd like to say I was hired to help get the place in compliance for 800. Had the stuff me and Eric had recommended back in January of 2020 been done, the computer system we requested, this would have never happened.
But just to follow up, you have taken steps to ensure that you've learned from this error.
Absolutely, absolutely. I mean, I always take some compounding CEs, you know, when I do my CEs, just to, you know, keep myself on top of the game.
Thank you. Board members, any additional questions?
Mr. Rayfield, how long have you been a technician or a compounding specialist?
I've been a technician since 2011, and I've been compounding for about 4 or 5 years now.
Mm-hmm. And did you get all your training at this particular pharmacy, or you came in with training?
No, I came in with experience. My first training obviously was when I went to school for pharmacy tech, and then I worked for Roadrunner Pharmacy.
I see. Thank you.
But you're saying you did 20, which would satisfy your 2 years. You didn't do it above that, right?
No, ma'am.
Okay. Just clarifying.
Board members, any additional questions, or are we prepared to make a motion at this time?
Madam Chair.
Yes.
If I can just follow up for Mr. Leba on his question. The board book page I'm referring to, on my board book, it's 3252. You'll see a T4 1 to 1000 acidophilus record. And if you look at the ingredients, the ingredient listed is T3. So that's the example I was referring to on the records.
Thank you. Board members, are we prepared for a motion or is there additional discussion?
Madam Chair, I think I'll just try to attempt this. So for Ms. Erica Cardone, I would like to honor the CE that she has done and completed and do a non-disciplinary advisory letter and honor the CE that she has taken. So I do feel like there is a solid plan in place, and I think there's been some great learning from it. And I think CE in this case was something that should not be dismissed, that there was merit in it. For the technician, Diana Sosa, I would like to do a non-disciplinary advisory letter with 3 hours of CE. For Christopher Rayfield, honor the CE of showing proof of 3 hours that he's completed. And then for the permit holder, the concern that I have with the permit is the record keeping. And if he has had his name as PIC but was not there, I get it, but he was still the PIC and the owner of the policy and procedure. So I think that's something to discuss. But where I would start off would be with those individuals.
Can you restate what you said regarding the technicians?
I will try. For Erica Cardone, I would like to honor the CE that she has completed. For Rodolfo, for Diana Sosa, non-disciplinary 3 hours CE in addition to the requirement due within 90 days. For Christopher Rafe, honor the 3 CE shown proof in compounding or drug safety, and honor that if he shows proof as well. And Ms. Cardone, I would ask that you show the proof as well. Where I fall short is I'm not quite 100% sure on the Mr. Dragon. Yeah, I'm not.
Well, one thing, I'm sorry, I was just wanting to clarify, is it above what's required for the technician CE?
Yeah.
Okay, just wanted to make sure we clarified that. Thanks.
Mr. Labor, if I can just get some clarification. For Ms. Cardone, you said an advisory letter and honor the CE?
Honor I do non-disciplinary CE, but she's already completed it.
Right, so the order would be, so it would be order for non-disciplinary CE,
yes,
but give credit for what has already occurred?
Yes.
But it cannot be used in the future?
I think 3 hours is fair, and that the other 7 that she did, she can use that, but the 3 is on top of.
Okay, so what specifically was the 3?
Let me go back. She got very specific. Ms. Cardone, do you have the management of thyroid disorders, and do you have the compounding basics for non-sterile products and complex non-sterile compounding for oral dosage form CE? That would be 3.
Yeah, yes, sir.
And Mr. Hargraves, if those 3 are presented to us, that would satisfy me.
Okay, and for Ms. Sosa, and did you also say an advisory letter with that as well?
I shouldn't have said advisory letter, non-disciplinary CE.
Okay, and same thing with Ms. Sosa?
Yes.
And what are the 3 hours of CE in?
Compounding or I would say compounding and drug safety would be acceptable.
for
Okay.
thyroid.
I don't, it doesn't have to be that specific.
And for Mr. Rayfield, you said you honor 3 hours of CE for compounding or drug safety if proof of that's provided?
Yes.
Okay.
But the 3 hours needs to be above and beyond his normal 20 hours of CE.
For all of them, yeah.
Okay.
Madam Chair.
Yes, Dr. Deng.
I have a question, just a thought, Mr. Leba. Why non-disciplinary? Because evidently there was some patient harm. Patient ended up in the hospital because of the error. So should we make it disciplinary instead of non-disciplinary?
Mr. Deng, you bring up a point. I look at this and I look at what took place, thought put into it, presentation of the Ms. Cardone that on here, and to me, it's a presentation of somebody that made a mistake and they learned from it, and there was no malintent. It was a mistake. It was just a mistake. And I think 10 hours of continuing education shows remorse. I think meeting with the patient shows remorse. I think meeting with the doctor shows remorse. I think the pages of the action plan that she put together shows remorse. I think the corrective action that's put in place at that pharmacy should help prevent those things. We are humans, we make mistakes. What I am seeing in front of me leads me to believe that non-disciplinary is okay.
I agree with you.
I do too.
I agree with you, Joe.
I agree.
I'll complete my motion. If I could get a little help from the board on the last part of the person named Mr. Dragone in the complaint. That is the one where I'm struggling a little bit with. It should be record keeping or not, because as far as I can hear, he wasn't there when this took place.
May I interject?
Yes.
I just want to reiterate the fact that what I said was, after the store was bought, I thought it was an ulcer, and I walked into the hospital, and 3 days later I was having open heart surgery. So they had to replace a valve. Since then, I was not in the pharmacy, but my biggest problem is I didn't change PIC. And I was worried about COVID, and I was worried about this. I was still available over the phone for any questions and stuff. And I spent a great deal of time talking to doctors and patients, because I'm known as quote unquote a hormone expert around the country. And I even have a video on the use of thyroid and how to help doctors to help patients with thyroid. And that's why when Erica spoke to the lady, she said, "Oh no, Rudy's been wonderful. I don't want anything happening to him." Not to say, I'm not patting myself on the back here. I'm just saying there was an error that happened, and no one feels more remorse that it happened than I do. In the past, I had 10 pharmacies back in New York when I moved here in '98. And during that time, there was one mistake that was done. And I drove 3 hours on a prescription that was mailed to pick it up and bring it back. So I don't ever want to hurt anybody. And again, the statement that's told, and you can ask Dina, and you can ask, because Dina was working with me before, and even ask Erica, I go, I don't care about the money. I want to make sure that all of the patients are taken care of. And I've had a stellar reputation. I want to maintain it. But I apologize sincerely for not being able to do it.
Are you confirming that you had record keeping in place, policy and procedure, in the example that we saw, it just wasn't followed, or what's the explanation for that?
It fell through the cracks. What had happened was we had a binder, and in that binder it had T4 to make the aliquots, and it would say T4 levothyroxine and T3 liothyroxine. But for whatever reason, they would make a copy of that, and then instead of printing out a new one and put it in there when it needed more paperwork to be able to fill into the binder, and someone filled out T3 instead of T4, continued to put in the lot numbers for T4, okay, but just the paper went through the wrong way. We didn't notice that until the inspector came in and showed it to us, and no one paid attention to it because it said T4 liothyronine instead of T4 levothyroxine, and we just looked at the T4 and just continued to sign. And that was our mistake. okay? And I apologize for that, but no, none of those aliquots were done wrong. The record keeping was wrong. And then those were all adjusted and fixed for the future. And now with the new system coming in, okay, which has been, again, because of COVID, very hard to implement, okay? And it's been taking a lot longer than what they expected. I'm still involved as far as being able to give some kind of example or some kind of help in advice, okay? But I'm not working in the pharmacy anymore. Haven't been since we sold the store.
Okay, thank you. I think that my motion is complete, board members.
Do I have a second for Mr. Leba's motion?
Just want to clarify, are you saying you want to take no action on the record keeping, Mr. Leba?
I am.
I think that there probably will be some action on the next issue would be my guess, but I don't want to say that prematurely either.
I would be in support of a letter of concern.
Would it be easier to pick one of these at a time against the pharmacists against each technician? Would it be easier to do separate motions so if someone disagrees with one aspect, they don't have to vote against the entire motion?
I agree. Let's do that.
Yeah.
Okay, so we will take as moved for Erica Cardone. May I have a second?
Second.
Okay, I have a motion and a second. All those in favor?
Aye.
Aye. Any opposed?
Then motion as moved for Christopher Rayfield.
Do I have a second?
Second.
All those in favor?
Aye.
Aye. Any opposed?
Aye.
Motion as moved for Diana Sosa.
To clarify, Mr. Goodman, was that an aye in support?
It was in support. Thank you. It was just delayed.
Thank you. All right, we had a motion on Ms. Sosa. Do I have a second? Okay.
I'll second.
All those in favor?
Aye.
Aye. Any opposed? All right, on to, do we want to address Mr. Dragone specifically, or do we want to address the permit?
I'll make a motion for that, that we do a letter of concern to Mr. Dragone for record keeping.
Non-disciplinary letter. of concern.
Non-disciplinary letter of concern.
Thank
Do
you.
I have a second?
Second.
Any discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed?
Nay, Kevin.
Okay, 8 ayes, 1 nay. And do we wish to take any action on Clark's Pharmacy regarding this matter?
Can we have a case
I
discussed
don't,
later on 25H?
not for this, no.
Mhm.
Ms. Galvin, do we need to dismiss the pharmacy from this portion of the complaint, or can we just move on?
No, because they were named, I would recommend a motion to dismiss if you're not going to impose any sort of other action.
Move to dismiss Clark's Pharmacy.
Second.
Any discussion? All those in favor?
Aye.
Aye.
Any opposed? All right, thank you very much. I think you all will be staying with us. So let's move on to item 28H with perhaps, I don't know that we need Mr. Rayfield or Ms. Sosa, but thank you both for your attendance today. The board will be in communication with you.
Thank you.
Thank you.
Item 28H 20-0046, Chambers Pharmacy, Rodolfo Dragone and Erica Cardone. Ms. Richardson, can you provide just a brief recap here?
Yes, so when investigating the prior complaint, I noticed some prescriptions in the pharmacy that were written by Dr. Keith Chambers. Clark's Pharmacy underwent an ownership change in January of 2020. An inspection for change of ownership was conducted by myself and Dennis Wagner on January 15th. And the new owner, Dr. Chambers, who's a licensed naturopathic physician, was informed that based on Arizona statute, the pharmacy would not be able to fill prescriptions that were written by him. He said that he understood that. On January 21st, a telephonic meeting was held between Dr. Chambers, the executive director and deputy director of the Board of Pharmacy, to discuss that issue once again. During that meeting, Dr. Chambers acknowledged that Clark's Pharmacy would not fill any prescriptions written by him, and written confirmation of his intent to enforce that was obtained. That is included in the board book. The new permit under the new ownership was opened on January 22nd of 2020. As I mentioned, when investigating the prior complaint, those prescriptions were found. At the time I was there, I ran a prescriber report and obtained a list of prescriptions that had been filled under Dr. Chambers' name. A complaint was then opened, and Dr. Chambers and the PIC, Rudy Dragon, were notified of that complaint. On November 19th, I returned to the pharmacy for further investigation. I took with me the original report that I had run in October, and I attempted to obtain prescription hard copies and refill dates. I ran the identical report with the same dates while I was there, and I have a summary of those findings included. I'll just point out a couple prescriptions. Prescription number 1 that I've listed for you no longer appeared on the new report when I ran it. This particular patient had 5 prescriptions from Dr. Chambers on the October report. 2 of those filled after the ownership change. And again, one of those, that prescription was then missing from the new report when I ran it. It had been changed to a Dr. Wool, and all fills for that RX were changed. And I provided a prescription label from back in April for your review so that you can see that it changed all the back fills as well. The next prescription that stood out was one that had an origin in the computer as being a telephoned in prescription. There was no image available, and the hard copy was missing from the file. The staff that was there at the time was unable to find it, but thought they remembered seeing it as one of the ones that Erica had pulled. I wasn't sure at the time what that meant, but Erica did email me the next day with the hard copy. That hard copy now reflects a Dr. Wool as well. She also sent me the back tag dated February, and the report that I ran on 10/21 and 11/19 both lists Dr. Chambers, not Dr. Wool, in that prescription. The next prescription, a controlled substance with an original date of June 30th, which was therefore written after the ownership change and refilled in July and September under Dr. Chambers. That current prescription and all of those above fills now say Dr. Wool as well. The image in the computer is an undated phone in, and the PMP shows Dr. Chamber at the time of writing this report. I have since checked again, and the PMP now shows Dr. Wool for any prescription filled for this patient by at that particular pharmacy. Prescriptions that are written for that patient by Dr. Chambers are filled elsewhere. And then there was similar with another controlled substance change to Dr. Wool. PMP still showed Dr. Chambers. And the final prescription that stood out, again, no image in the computer, no hard copy in the file. Erica was able to provide it. It was one of the ones, again, that they asked her to pull. This was an RX filled in March. Dr. Chambers was crossed out. It was changed to Dr. Wool with a note stating that it was changed in the computer. However, it had not yet been changed in the computer, and I'm thinking that may be why it wasn't back in the file or imaged yet. In total, when you go through the reports, there were 7 prescriptions from Dr. Chambers that were written after the ownership change and 65 prescriptions that were refilled after the ownership change. I went for a date of 1/22 because that is the date that we officially opened the permit. There were prescriptions filled after the time that Dr. Chambers was first notified of the requirement, but I did not include those in this total. In his response to the complaint, Dr. Chambers does state that he has not submitted any new prescriptions to Clark's Pharmacy. Again, there are 7 with original dates in this time frame, and one of the hard copies that I've provided for you is a phone-in prescription phoned in from Dr. Chambers. I asked Erica about the prescriptions that she been asked to pull. She stated that when the complaint notification was received, by the permittee and the PIC that they asked her to run some reports and to pull some prescriptions. She believed they wanted to know how many prescriptions there were. It's unclear what the actual purpose of pulling them from the files was. Dr. Chambers is the owner of Chambers Clinic, where he practices as a naturopath. Dr. Wool is also a naturopath practicing at Dr. Chambers Clinic. According to their website, Dr. Chambers specializes in pain management, general medicine, and hormones. Dr. Wool in gastroenterology and autoimmune disorders. However, the prescriptions that were changed from Dr. Chambers to Dr. Wool are for hormones.
Ms. Richardson?
Yes.
In their system, is there a history of what has been done with the prescription? So if an NDC was changed, is that logged, and by whom? If the name was changed?
Right, I know
does it
what you're
have a
saying,
date
and I
by
tried
whom?
to find that, and I was unable to be able to determine that.
But we were able to see on a number of the prescriptions within the prescription drug monitoring system that the prescriber changed from Dr. Chamber to Dr. Wool, where controlled substances were related. We do have
Correct.
history of that.
Right, we had a history of where it was changed at the pharmacy, but not in the PMP. And then, as I said, when I checked again this week, the PMP has been changed since then.
Okay, thank you. Somebody from Clark's Pharmacy would you like to make a statement?
I'd like to start if possible.
Thank you.
When the inspector came in and told us that when we found out that there was a problem with the prescriptions, I was the one who asked Erica to pull the prescriptions. By that I mean I want to see the hard copy. I said, actually I didn't say I want to see. I said I want you to look at the hard copy. I said look at the hard copy and find out what exactly went on there. I also said take a look at how many prescriptions were done by Dr. Chambers the year before he took over. And I think there was around 700 or 800 prescriptions that came in from Dr. Chambers. And I had said to her, when we did this, we all knew that no, we cannot fill any prescriptions from Dr. Chambers. Those 7 that went through were mistakes, okay? As far as changing from Dr. Chambers to Dr. Wool, I know nothing about that, okay? And I also don't know anything as far as the refills were concerned. When we asked pull is a bad word, but just say pull the records and see how many prescriptions were done, they showed there was like 70, we thought it was 73 prescriptions that were done as refills and 3 prescriptions that were done as by mistake that came through and someone just didn't realize it. When I saw there were 73 prescriptions, I said, deactivate Dr. Chambers' license so that there's no way that any prescriptions can be put through for Dr. Chambers. As far as Dr. Wool's ability to do hormone prescriptions, I have a reputation, which you can look up, on teaching doctors on bioidentical hormones. I've been doing it for almost 30 years. And so I spent a great deal of time with Dr. Wool, and he has a couple of my books, and he has been doing bioidentical hormones, but his website has not been changed. Because Dr. Chambers can't write any prescriptions, and people want to go to Clark's Pharmacies to have access to me, to be able to call me and ask questions about it, he was given to, those patients were given to Dr. Wool. That's what I know. Again, I'm not in the pharmacy, and I've not done anything with the records or with the computer. That's what I can state.
I have a question for Ms. Cardone.
Go ahead.
If you deactivate someone in your pharmacy system, what happens to the prescriptions that have refills?
You can no longer fill them. So we did that. We just did it too late.
Okay, so if you took out the doctor's name, the prescription is no longer valid. You're not able to refill the prescription.
Correct.
So did you have to go get new prescriptions for those patients?
Those patients were going elsewhere, to my knowledge. So we haven't. So the things that were changed, it was in the error analysis I did when we learned of this, there was 5 or so prescriptions that were called in under Wool, but the patient had seen Dr. Chambers in the past. So it was human error that we discontinued and reassigned the prescription, and they didn't update the doctor. And it's my fault that I didn't catch some of them on the pharmacist review, but they were prescriptions that were supposed to be under Dr. Wool. The daily reports keep our history of the error being made, and I'm sorry that I went in to try to prevent that from happening again, tried to explain it in response to the board, but I would have done it different now. We tried to find the stroke history, and I reached out to the QS1 to get those records to show it, but unfortunately it wasn't set up. We set it up immediately. And when we adjusted the PMP reports, we reached out to the board to let them know that's what we were doing.
Ms. Cardone, what was the process from changing the prescriptions from Dr. Chambers to Dr. Wool? As these patients, since Dr. Chambers, you were no longer able to fill prescriptions for him, were these patients seen by Dr. Wool? Was there a valid patient prescriber relationship in place for each of those prescriptions as you changed them?
That was understanding. There wasn't too many of them, but in these cases, yes, it was our understanding that the patient was now seeing Dr. Wool because Dr. Chambers was stepping back from practicing as much.
I can answer that question. So before purchasing the pharmacy, obviously I sent hundreds of prescriptions through Clark's Pharmacy each year. When Ms. Richardson came in, we discussed on site as well as over the phone later on that I wouldn't be able to write prescriptions to the pharmacy. I acknowledged that and understood, and I also understood sort of the Herculean effort in looking at my patient base and transferring care to one of my doctors. Dr. Wool wasn't the only one. So if those patients really wanted to have Clark's Pharmacy and I was able to transfer them to one of my other doctors for care, I did so. And I also instructed my office not to send any of the prescriptions that I write for my patients to Clark's, as well as we had a discussion at the pharmacy. You know, if something happened to come through with my name on it, to not fill it. And obviously there was some that fell through the cracks, but and comparatively 3 or 5 or 7 or whatever it was, compared to the 700 or 800 a year, we made the best effort we could to steer away. So I write prescriptions. I have my prescriptions that I write filled by the pharmacy.
Ms. Walmsley?
Yes, go ahead.
Mr. Chambers, are you saying that you would see the patient and Dr. Wool would write the prescription?
No, I'm saying I transferred care.
Okay.
Transfer care of my patient to Dr.
So
Wool.
if they wanted to go to this
Or-
pharmacy, you would transfer their
or-
care to the other doctor.
Right, with of course their permission. Or
Do you have an-
or I have plenty of patients that I've kept and I send their prescriptions elsewhere.
Do you have any statement about it, maybe the prescriptions being out of scope for that physician, Dr. Wool?
No, they're certainly not out of scope. He's very, he does a tremendous amount of hormone work, as well as my other doctors do a lot of hormone. I have other doctors that do hormone work as well. He happens to just like I do pain management and other things, but I also do hormone. He does GI work, rheumatology work, but he does a tremendous amount of hormone work too, and has had a great deal of training.
Madam Chair, if I may provide a comment, Mark Bozen.
Yes, go ahead, Mark.
The question from Christian Snare is an interesting one. And as a matter of law, a naturopathic physician, that is their scope of practice, everything that's within their practice act. Simply because they advertise a specialty or subspecialty doesn't negate the fact that their scope of practice is that of which was in their physician practice act. It's a classic law school teaching question, actually. Can an ophthalmologist who's a licensed MD write for birth control for a patient that's under his or her care? Absolutely, they're a licensed MD and their scope of practice is that of the Medical Practice Act. Naturopathic physicians enjoy the same scope. So simply because someone advertises gastroenterology on a website doesn't negate their full practice privileges.
Okay, thank you for that clarification.
Dr. Chambers, you did, just to, I guess, ask a little bit more pointed question, did you instruct the pharmacy staff to change any prescriptions written by yourself to another prescriber?
Oh,
Okay, thank you. Board members, additional questions?
I have one.
Go ahead.
So, Dr. Chambers, can you confirm that every prescription that has Dr. Wool's name on it, Dr. Wool assess that patient prior to writing that prescription?
yes, we have a process in place that we turn over those patients and usually even make sure everything is has been seen and documented and carefully transferred. Those patients that are okay with that and you know, so we've really worked hard on having a seamless transfer and making everything. I really tried to, as I told Mr. Richardson, you know, I really want to be compliant on everything we do. You know, it's a point of pride.
Ms. Walmsley?
Yes, go ahead.
I have a question for legal counsel in the relationship with Mr. Chambers, Mr. Wool, and all the others working under his roof. Is it still a violation of the Arizona regulation that he cannot profit from the prescriptions written by pharmacies?
Are you asking for legal advice?
Yeah, if that's where you want to take it, or it's just a question, is he profiting from this even though he's not writing it? People that work for him are writing it.
I'm not sure I could answer that. I'm not sure what arrangements or agreements they have. From what I have in front of me, I'm not sure I can answer that question.
Can I say something?
Yes.
We were discussing the revenue since I sold him the pharmacy. We were discussing the revenue that was being done. When I sold him the pharmacy, we were at $1,250,000 a year. Okay. Since he's gotten it because of the implementation, okay, and other things, including COVID, and since he's moved his business from giving it to Clark's Pharmacy to other pharmacies, the pharmacy itself is under $1 million. So he steered or suggested that all of his pharmacy prescriptions go to other pharmacies. And that's a matter of record. So there should be no question here that he's not steering the business towards the pharmacy, because if it was, we'd be at $1.5 million. You know, we're down $250,000 more, 300,000. So we were just discussing that because, you know, he still has to pay me for the rest of the pharmacy and so on and so forth. And we were saying, well, the business is down. And this is a large part of it, that he moved his business elsewhere. So to say that he's not trying would be completely wrong. Okay, he did every honest effort to comply with what it is that you guys asked him to do. Some of them, the refills and a few prescriptions fell through the cracks, okay? And since when we found that out, the minute we found that out, and Erica told me, I said, Erica, real simple, just deactivate his license, okay? Stop it forever. So if the prescription comes in and you're not there and the other pharmacist there and it says Dr. Chambers on it, it cannot go through, okay? You just say, listen, I can't fill it. And you give it back to them. And you say, hey, there are other pharmacies that can fill it. And if he had not done that, we wouldn't have this downward turn in the finances.
Also, I didn't know about the refills. I mean, when I was instructed to not write any more prescriptions to the pharmacy, I refills just, that wasn't even in my head. I didn't even consider it because I wasn't attending.
And neither did I. And once we found out, we deactivated the license.
Thank you, Dr. Chambers. I do have one question, and then I'm going to make a motion for executive session for the purposes of legal advice. But before we go into executive session, Dr. Chambers, does Dr. Wool work for you directly?
Yeah, he works for the clinic, yes.
He's your employee.
Yes.
Does he receive any revenue from your pharmacy?
No, no.
Okay. But he is your employee at the clinic that you own?
At the clinic, yes.
Okay. I'd like to make a motion for legal advice.
Second.
All those in favor?
Aye.
Aye. Any opposed? Great, welcome back, everybody. Do we have the meeting room closed out?
Make sure Seth is still not in there. Hang on.
Yeah, we've closed it down. I don't see anyone in there now.
I see Seth.
Perfect.
All right, board members, additional questions or discussion? We're ready for somebody to start to formulate a motion.
Ms. Cardin, just real quickly, maybe you've already addressed this, but when we saw a crossed out name on the prescriptions of the provider's name and then the other name written over it, why was that done?
Can you tell me which one you're referring to? Oh, at the top of a refill authorization?
There were a couple, let me, just 1 second, I'm trying to get back to it. I'm pretty sure it was a progesterone script.
Yeah, I see that one. So if anytime, not just at that clinic, but if a doctor changes, but the patient's had the medication before, we can print a renewal form for the verbal. And so then I initialed that it's a change of doctor at the bottom. So we crossed out the top so there wasn't confusion upon entry, but unfortunately on a few of them, there's still the entering technician missed it. And then I unfortunately missed it as well on the check. But these were discontinue reassigned prescriptions with, it was supposed to be a change of doctor that was not entered correctly. Does that answer your question?
Yes.
Madam Chair, I'm willing to make a motion at this point, if that's okay.
Yeah, go ahead.
First of all, I'd like to ask both Ms. Cardone and Mr. Dragon, number one, get together with the board staff and correct the record. As of right now, your record is not correct. Mr. Dragon, you're still listed in the board as the pick, even though you've informed us that you're not. So make sure you get together with Dr. K or other board members, other board staff, and fix that record as soon as possible. You agree to do that?
Oh,
Yes.
oh, without a doubt. We went in, both Erica and I went in and changed it. We don't
just
know why
make
it
sure
wasn't
it's done.
changed.
We don't need an explanation. Just make sure it's done.
Okay.
Number two, let's go to the motion. At this point, based on the evidence we have, there has been about 70 refills and 7 prescriptions that were filled. I'm satisfied with the corrective action that the pharmacy has taken by eliminating Dr. Chambers from their database. And so I'm making a motion to put an advisory letter to file so that we have a record of this. If in the future Dr. Chambers does appear to prescribe again, there's a record of it and we can take more substantial action. But at this point, I think an non-disciplinary advisory letter to file is sufficient. So that's my motion.
Second.
You say to file, who's the advisory letter addressed to?
Well, the advisory letter to Dr. Chambers Pharmacy, I guess, the Clark's Pharmacy at this point, the permit.
I would like the advisory letter to be for record keeping just in general, to be more specific, especially given the circumstances from the prior case, the lack of documentation related to the PIC, and then the prescription record keeping just in general. So that way it's a little bit more all encompassing in the event that there are other record keeping issues that come up in the future.
Thank you, Ms. Walmsley. Yes, I'll amend my motion to that effect.
But that would still mean it's to the permit holder, correct? Or to the permit?
Yes.
Okay.
So I had a motion by Mr. Solari and a second by Mr. Minkus, correct?
Yes.
Right. Amended second.
Thank you. Any further discussion, board members? All those in favor?
Aye.
Aye.
Any opposed?
Goodman, nay.
All right, motion carries. Thank you all for your time and attendance today.
Thank you.
Thank you.
Thank you.
Thank you.
Dr. Gandhi or Jennifer, direct me. Are we on to
We're on the special request.
30, tab 30?
30A.
All right. Discussion, consideration and possible action regarding Adam Nye's request to lift his suspension. Is Mr. Nye present?
Yeah, I'm here.
Thank you. Mr. Nye, can you please introduce yourself for the record?
Yeah, I'm Adam Franklin Nye. I'm just trying to see if I can get my suspension lifted and moved over to the probation status, I guess.
Thank you. Appreciate that. I also see that Ms. Fine is here. Board members, question for Mr. Nye related to his request to lift his suspension.
I have a question as to when your suspension went into place.
Back in October. I'd have to look at the agreement, but I think it was October 27th, possibly.
That is correct.
Can board staff verify that date for me, please?
Yes. Yes, it was
October 27th.
This is Jennifer. It was October 27th.
Okay, thank you.
Madam Chair, if there's no other questions, given that Dr. Fine has written a letter of support and Mr. Nye has completed the appropriate steps, I am willing to make the motion to allow him to end his suspension and move to probation per terms of his contract.
Second.
I have a motion and a second. Any further discussion? Ms. Galvin, do we need roll call for this?
Yes, because he's going to continue on a probationary status. That would be advisable. And just so everyone is clear, the suspension then would be lifted on May 27th, pursuant to the terms of the previous order.
April would have been 6 months.
I'm sorry?
April 27th would have been 6 months.
That's correct.
Galvin?
We would have to, do you want it effective immediately or upon drafting of an order by staff?
Mr. Solari?
I am satisfied with immediately. I don't think he should have to wait for our paperwork. So April 27th was a 6-month anniversary of his suspension, and he's satisfied that, so we can effectively immediately let him move to probation. The paperwork can catch up as necessary without a rush.
You in agreement, Mr. Minkus?
Yeah, I agree.
Thank you.
Okay, thank you. Dr. Gandhi, roll call, please.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Okay, ayes have it, Madam Chair.
Thank you very much, Mr. Nye, for your attendance today, and we wish you best of luck in your continued recovery.
Thank you. And just to confirm, I'm allowed to start looking for work now?
Yes, you will be placed on probation immediately.
Thank you.
Thank you. Next up, item 30B, discussion consideration and possible action regarding Andrea Stump's request to lift suspension. Is Andrea Stump present?
Ms. Stump withdrew her request for this meeting. And I don't see her in the in the agenda.
May have to refresh your book, Madam Chair, but 30B now is actually a deviation extension.
Oh, I'm sorry. All right, I don't know how I missed that. Okay, so 30B is a request for deviation for Remuda Ranch, DBA The Meadows Limited Service Pharmacy. Board members, this is a request to honor a deviation, to extend a deviation that had already been in place for 2 years. Any discussion? Do we have anybody present from Remuda Ranch?
Madam Chair, I'm recused.
Thank you.
Yeah, Lori, I'm present. My name is Fahad El Noah, pharmacist, regional manager, and I'm here with Tammy Hall.
Thank you much. Thank you very much, both of you. Board members, any questions?
Looks like we might have one other person on, possibly.
Yes, my name's Alan Benham. I'm the Chief Operating Officer for Meadows Behavioral Healthcare. Thank you for allowing me into the meeting.
Thank you very much. Board members, any questions for Remuda Ranch?
Maybe they could give us an update since it was a deviation.
I don't know. I don't know that I think that it's necessary. In my opinion, I'm comfortable with extending this. I think that we had intended to address this through rulemaking at an earlier time, and we are a little bit, perhaps that did not happen as quickly as we would have thought. So I would be in favor of continuing this on, especially given the fact that we're continuing on with the Rural Rewrite Task Force. And I think this will probably be addressed during that meeting.
If that is your motion, I'll second.
Madam Chair, that logic would apply to 30D as well. If you want to carry that over together, it may make sense.
I would be fine with that.
30D, you said, as in dog?
Yes, D as in dog, D as in David, something like that. Yep.
Yes, I would agree with that logic, and that was for BioCare Inc. Canyon RX. Board members, any additional questions or discussion? I would be in favor of allowing the deviation to continue for another 2 years in both of these cases, so we continue on with the rule writing.
I would like to blame COVID for the delay so that we have a good excuse.
We would like to, yeah.
We'll accept that.
So I have a motion and a second. All those in favor to approve the deviation request for 30B and 30D?
Aye.
Aye.
Any opposed? Noting Dr. Leba's recusal from, I guess, both items, since we took them together.
From the other, but I did.
Okay. Okay. Thank you very much to both of you. Best of luck. Thank you.
Thank you.
Thank you very much.
And I would encourage you to participate in our rule discussions.
When are those discussions scheduled? I'd be happy to participate.
Look for an agenda on our meeting, on our meeting calendar.
Very good. I will do that. Thank you very much.
Thank you. Item 30C, we have a deviation request from Medavail. I believe Mr. Morris is who requested this. Who do we have present from Medavail?
You have Roger Morris as counsel, and then Paula and Pooja, can you guys introduce yourselves?
Hi, I'm Paula Booker, and I'm the pharmacist in charge of the Phoenix operations.
And hi, I'm Pooja Shah, and I am a manager for patient care operations in Arizona.
Thank you. For the record, Ms. Booker worked for Walgreens a period of time ago. She did not work for me directly, and it would not predispose my decision with this. If you don't have any objections, I feel like I can participate impartially. Mr. Morris.
We have no objection.
Mr. Morris, the same goes for me.
We have no objection.
Thank you. Mr. Morris, would you like to provide just a brief summary of your request here?
Sure. The request is for SpotRx, which is the name of the pharmacy for Medavail in Phoenix that operates the kiosk that the board is familiar with, and we've done some rule writing. What the request is to allow certified technicians, Arizona technicians, to accept and to give prescription transfers for non-controlled drugs. The request is substantially similar to the ones that CVS, Humana, and PillPack have had approved by the board over the last couple of years. We actually held off on this, hoping that there would be rules in place, but I think we can blame it on COVID that there were no rules ultimately put in place for this, and we'll continue to work through it. But it's a deviation to allow for the technicians, again, for non-controlled prescriptions to be able to accept transfers and to be able to give transfers. You have the policies and procedures in front of you. You have an outline of the materials that we submitted back in February that went through it. And Paula and Pooja are prepared to talk to you about the process and the procedures they have, if you like. But as I said, they're substantially similar to what Humana, CVS, and PillPack are doing now.
And I tend to agree with you, Mr. Morris. I think that this intended to be taken care of, and the technician rules that we had proceeded with that, again, are probably a little bit behind due to COVID. So if people, I don't know if anyone has any questions for Mr. Morris or the others, but I would be comfortable with approving this.
I have one question.
Go ahead.
When the technician does the transfer, is there any place, I didn't notice a place that has the technician's initials or name of who did the transfer for your history purposes?
Pooja?
Yeah, so on the form itself, it will have technician's name as well as the pharmacist's name. And all of our calls are also recorded, so we can go back and listen to them as well.
What I was meaning was in the software, if I looked at the prescription later, I don't have the hard copy in front of me. I'm just looking at the history in the software. Is there a place where that's documented?
Yes, so in our Enterprise RX, actually the prescription is scanned in and the name will be there. And also we use Salesforce, and that also has the technician's name who will be closing the case, and who they have there all the notes and everything as well.
Okay, that was my only question.
Madam Chair, may I ask a couple of questions? Mr. Morris, help me with this. When the previous PillPack and such came in front of us, they had their technician training manual with them, and there was about 20 hours of training. I don't see that you guys are going to do any additional training other than what the technicians already have. It says 1,000 hours of practice experience, must have completed 3 hours of patient safety and error prevention CE. Is there additional training other than the one-on-one with the pharmacist, and how many hours would that be?
Sure. Pooja, Pooja and Paula, you guys want to explain?
I can go ahead and take this. The training will include the following. We're going to have 40 hours, about 1 week of going over working one-on-one with the pharmacist. And additional to that, the technicians will have to do 10 mock transfers. The identifiers that the technicians will have to get is the patient's name, date of birth, phone number, or address. Additionally, at the end of each verbal transfer, the technician will be coached on or required to read back verbally the prescription transferred.
And then my next question was, are these phone calls that they'll be taking on the transfers recorded?
Yes.
Yes.
All the calls are recorded, and we use the Genesis software for that. And they also have transcript on it, so we can go back and also provide coaching or evaluation form attached to each call.
Then thank you, Madam Chair. I'm also comfortable with proceeding as we have with the other cases.
One question
Thank
for
you.
you, Madam Chair, real quick. You
Go
had
ahead.
mentioned that you guys will be going back and listening to 10% calls. Will that be doing 10% daily, or how are you going to do that? And just because I'm curious, how did you pick 10%?
That's a good question. So 10% we felt was a good number for us to be able to do the verbal transfers. So the many of our prescriptions that come in are fax transfers. We felt 10% was a very good number. Now that is the minimum that we will accept. We can always go up with that as well.
Thank you.
And Mr. Lieba, to answer your question, I think that was implied in there, they're going to be doing that daily.
Yes.
Thank you. Board members, do I have a motion?
I'll make a motion to approve.
Do I have a second?
I'll second.
I have a motion and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Thank you very much. Appreciate your time and best of luck to you.
Thank you.
Thank you.
All right, item 30E, Ismail Abuhani. We have a consent agreement, a proposed consent agreement on behalf of Mr. Abuhani. Mr. Bozen, are you his attorney?
I am. I represent Mr. Abuhani.
Would you like to make a brief statement?
Yes, Mr. Abuhani has been before this board rather recently. He has a disciplinary history. His history was one of spending some time behind bars, and his license is currently under suspension. While he was going through his criminal trial that extended for the 2 years previous to his renewal, he forgot to do the CE. He didn't do the CE, and we are requesting that the board use its guideline and fine him $100 for every CE that hasn't been done, complete the CE that hasn't been done, complete 45 hours of additional CE, that's 30 hours that would be required upon the next renewal, plus a 15-hour penalty, plus a mandatory audit.
Chair.
So, go ahead.
Chair,
Yes,
this is
go ahead, Mr.
Goodman. To be very clear, you're suggesting we follow our guideline after our recent discussion?
I am, because this is a completely different set of facts and circumstances. This is not a pharmacist that has an unscathed record. This pharmacist has been convicted of a felony. He spent some time in prison. He is currently under suspension, and the guidelines in this case seem to be more than fair.
Okay, thank you.
Board members, any additional questions for Mr. Bozen, or are we ready to entertain a motion?
Yes, ma'am. Just one thing. In the consent agreement, there is an error, and I wanted to make sure that gets corrected. I'm sorry. The consent agreement calls for 70 hours of continuing education on the last page, where we're talking about conclusion of the law and the order, and it should be 75. And I just want to make sure that is corrected on the final copy of the consent agreement before it goes out.
That is absolutely appropriate. It is a typographical error if it was missed. 75 is the request.
In that case, I am comfortable making a motion if there's no other discussion.
Second. No.
Okay, let me make the motion then to accept the consent agreement given that there was 75 hours of continuing education. With that correction, I'm in favor of the consent agreement.
I have a motion and a second. Since this is discipline, roll call, please.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Bonsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye.
Ayes have it, Madam Chair.
Thank you. Mr. Boson, thank you for being available for us.
Thank you.
Okay, on to 32 board members. How's everybody doing? We've got, looks like a kind of a lengthy list under Dr. Gandhi, and then a couple of other things. Does anybody need a break, or are we okay to continue?
Endeavor to persevere. Let's go.
All right, thumbs up, everybody.
Thumbs up.
All right, let's go. Dr. Gandhi, your report.
Thank you, Madam Chair. Best for last, I would say.
No, actually, I think just for the record that Mr. Scavarla is last on the agenda.
That's what I meant. But, Madam Chair, you and I discussed this earlier this week. I had a call from the governor's office about furthering the discussion about what's needed today with the health emergency. I think there's discussion about moving forward as the numbers improve and the crisis here in Arizona is kind of being under control a little bit. Governor's ask was, from governor's assistant's ask was, can we remove our executive order? But there was some items on the executive order that we had questions whether we could use discretion using their guidance and stuff. I have not heard back from Ms. Guzman, Trista Guzman, about that. Their appetite is to try to eliminate all the executive orders that kind of apply to COVID. That's their goal. But I don't know where we stand on our concerns that we had. The concerns we had was around the DA requirements on Schedule 2 medications. There was a labeling requirement for hospitals so that patients can take home multi-dose packages. That was a waiver we asked for. So we did address that. I can keep you posted if it's okay with the full board to allow me to continue to work with board chair to express our concerns with the governor's office. That'd be easy. That'd be the easiest way to manage it.
And just to be specific for the board members, the three provisions that Dr. Gandhi and I had asked for either to remain in an executive order or for some sort of discretion that could be memorialized for the public are around items 1C and 1D, which are the DEA waivers that are in place for emergency prescriptions to allow for the follow-up prescription to be provided within 15 days versus the original 7 that's required in Arizona statute, as well as for some discretion around the additional methods by which the emergency prescription can be submitted to the pharmacy. And then lastly, under item 1, why am I not finding it? 1E, to waive the hospital provisions related to multi-dose medication. So those were the 3 provisions that we are continuing to work on.
Would you like a motion?
Dr. Gandhi?
Yeah, just allowing me to work with board chair through this process.
I'll make a motion for Dr. Gandhi and staff to work with Ms. Walmsley going forward on this.
Second.
All those in favor?
Aye.
Aye. Any opposed? All right, Dr. Gandhi, next item.
Next one were a list of House bills and Senate bills that have been signed into law by the governor. Obviously, it won't be official until 91 days after session closes. One particular bill I want to draw to your attention, and it's not on this list, but I do have a caveat in the agenda item, is Senate Bill 1357 that was signed into into law by the governor recently. And one of the provisions in there states that the discipline that we have posted on our website, today it's by law, it has to be for life of that discipline. Going forward, once this becomes law, there's a term limit of 5 years for discipline to be posted on our website. Mr. Bozen actually introduced this last legislative session. It carried over to this one. He and I discussed this, wanted to understand how our website should look with this law kicking in August. And obviously we can't post a consent agreement anymore. But I wanted to, and if Mr. Bozen's still on, maybe you can chime in. We have a category under license verification where it says discipline and or why. Today, obviously, it would say why. Should that why stay on with this language, or does that why need to be removed?
Thank you, Dr. Gandhi. Mr. Bozen, do you want to make a brief statement?
I can speak to what I advocated for in front of the legislature. I can also refer you to the bill's sponsor, Senator Barto, who would be more than happy to assist staff with legislative intent. But it was the intention that the board's website for pharmacists describe discipline within the last 5 years, yes or no. And if
that would
there
only
was
be for pharmacists.
It's a good question. It's presumably for all licensees. I do not know the answer to that, but I promise to get that information back to you, Kristen. And I am embarrassed that my brain wasn't going there, and I apologize. But I'm happy to broker a meeting between the bill sponsor and board staff if that's necessary, or even between Leg Council and board staff, so that there's an agreement on what the legislative intent was. But it is my understanding legislative intent, what I asked for when I lobbied for the bill, was that the public-facing discipline only be available for 5 years. People could do a Freedom of Information Act request and ask if there are things older than 5 years, but the publicly facing information that was free on the website would be very descriptive, and it would simply say discipline within the last 5 years, yes or no.
Mr. Bozen, it is all licensees or certificates.
Thank you.
It doesn't talk to permittees though. So it may not apply to that category.
Thanks for clarifying.
And so yes, Kristen, the intention was all individual human beings that have a license, not necessarily the businesses.
Thank you.
So yes, Mark, if we can set that meeting up so that we can start working with our vendor to modify the coding, because that takes time, obviously. Just to get the intent and how our website should look by the time, this is implemented.
Dr. Gandhi, do you need a motion specifically related to this, or just allow you to, or just we can bring this back to the next meeting?
Well, we can bring it back to the next meeting. I mean, it's already going to be law here in the near future.
Mm-hmm.
My job right now is just to make sure our website aligns with what the intent of the law was.
Correct.
So no, I don't need a motion. I just wanted to bring that to your attention.
Thank you.
You
Anything
do
else
have
on the bill?
you do have the other bills for your consideration. These have all been signed into law. As more bills continue to drop, if it's okay, I can share them with the group. Obviously, you can't discuss amongst yourself, but at least you know what is being going to be the new law going forward. I left a placeholder in my agenda item, which is update on prior asks. I believe Ms. Snare wanted that. There is nothing under there.
Before you go on from bills, just one point of discussion. With the bill, and my brain is failing me right now, I apologize, related to the non-disciplinary the non-disciplinary fine that will become an option for us as the bill becomes effective. I assume the board staff is going to need to start to work on that and perhaps bring something to us at the August meeting. I'm sorry, the July meeting on what we expect that to look like moving forward.
That is correct. And we probably will need to get together with a stakeholder meeting so that we're all aligned and the expectations are set with stakeholders and board members.
I think that's a great idea, and I think that might tie in nicely to some of our other discussions as well.
And
that is Senate Bill. That's Senate Bill 1087, Madam Chair.
I think one item too is communicating with the public on the changes and what does that look like as far as the changes that with these bills taking place. I think there's a degree of education that should be our responsibility.
That is correct, Mr. Leyba. I did have the luxury of having some interns this round. They're on our meeting, paying attention to how board meetings work and stuff. And they wrote a summary of the bills that have already been approved that are listed here. We do annually post them on our NABP newsletter, create a link on our website for the summaries. And obviously we're happy to talk to them about the changes that are coming forward. We also, believe it or not, have a Facebook and Twitter page. So we're hip, we're a hip board. It's just a matter of getting a following. I don't think we're very popular yet, so we don't have a big following. Any other questions?
I'm good. Any board members, any questions on the legislative piece? Go ahead, Dr. Guys.
The next one is more a placeholder. I know Ms. Nair had asked about updates to be provided by us. I think we already talked about technicians, expanded scope, delegated by pharmacist. Kelly is managing that with the Medical Association. She did recently have a meeting. I think she's making some traction there. So I'll keep working with Kelly on updates on that one. Other asked by the board are actually later on in my agenda items, so they're incorporated in our discussion here in the near future. But I will continue to be a placeholder going forward, just in case we do have stuff that I can't agendize and I got to give you guys an update on. Board fees is the next topic. I put in there for you what our fees are currently, where the fees are nationally from the pharmacy boards across the country. There is some consideration I'd like for you to think about, and maybe we can, as food for thought today, and we can maybe address this at the July meeting, is reciprocity fee. I think with modernization and electronic transmission of a lot of information, what we charge today for reciprocity may not make sense anymore. We may need to address that fee. Certificate of free sales also, we charge $200 for certificate of free sale. Again, I'm not sure if we need to charge that much. Can we cut that in half? So that's something for consideration as well. So that agenda item is there for food for thought, for you to compare and contrast, and then maybe we can readdress in July and capture, maybe move forward on what we want to do.
Go ahead.
I just have a request as we go forward. The spreadsheet you put together with the other states' fees, I am just not a young man anymore, and it's just too hard to see. Any chance you could enlarge that or make sure in the board book it appears a little bit larger so seniors like me can see it?
Well, I'm glad you didn't request a magnifying glass. Certainly, we can send it out for you guys to enlarge on your screens.
Thank you, sir.
Thank you. I would request to, with you bringing this back to the next meeting, what your recommendation would be included in the packet, as well as what the impact we would expect to our budget would be, just so that we have a full picture and can kind of wrap our heads around that before the discussion.
Certainly. We had touched this, the next subject is community service hours attached to substance use program. We had touched this some time ago. And our board staff and our two partners, Community Bridges and PAPA, recently met to talk about other matters as well as this. And there is apparently value to doing community service hours. One what we've learned from our discussion with our partners is they get to know these individuals far more than we do. We see them on paper. We don't interact with them normally, so we don't really gauge how they're progressing through and what kind of community service hours they're doing, whether it's self-serving or whether it's not. So my first ask and question is, what is the appropriate amount of service hours? 200, 400 hours? I'm not sure what the magic number is. I'll leave that up to you guys to discuss. And the second ask is, are you okay with our partners managing and signing off on those hours?
How come the amount of hours keeps coming up? It seems like each year we come back to it. Is there a problem with the hours? Does somebody feel it's excessive? What's the background?
No, I think what happened, Mr. Leyba, is there was a case that happened some time ago, and we felt as board staff that it may have been self-serving because they were coaching their own son's sports event. But it was not seen that way by one of our partners. So we're not the best people to gauge whether it's self-serving or not, because we don't know these individuals. So I think this ask is, can we have just our business partner sign off on those hours being done?
Well, I also remember someone going to school and they wanted to count that.
Correct. And so again, I don't know if we have the ability to judge a person's character because we have a consent agreement. We once in a while speak to this individual, but we'll never understand them. And I think, again, the two partners we have a better gauge on these individuals than we do.
I think what we have in place is appropriate, and as long as it's not self-serving. And if there's a question, then it should come before the board, maybe. I don't know.
Yeah, but again, if Papa or Community Bridges attest that these hours were not self-serving and they fulfilled the 200 or 400 hours, is that acceptable?
I personally would be okay with that. I don't know that I think that our staff needs to micromanage that, as long as someone is validating the type of hours it is. These are trusted partners that have an agreement with the state. And this is probably, not to belittle the value of it, but probably the least complicated portion of somebody's treatment and recuperation. So I would be confident in allowing either any of our partners to monitor this.
And
Do they request to monitor it?
I'm sorry, Mr. Leyba?
Is this a request by them to monitor it?
They are good with monitoring it. Yeah, it's a request by both parties, us and them. I think it's mutually agreed upon that they can do it, and we're more than happy to let them do it because they're in a position where they can make a smarter decision than we can.
Yeah, and I agree with what Ms. Walmsley said. They are the most qualified to judge rather than us. Like you said, we only see these people once in a while.
So the magic number 200 or 400, is that a concern, or should I can flip a coin?
Well, what is it now?
It's 400 right now, I believe. That's what it used to be, and that's what it's usually written down as.
I'd like to hear from Ms. Fine if she's available.
She is online. I can request her to unmute.
Can you hear me?
Yep, we got you.
Okay.
So Kelly, just some feedback from you. Are you hearing concerns from participants related to the number of hours, or do you have any thoughts on what the appropriate number is, 200 versus 400? You work with these individuals day in and day out, so I'd be curious as to your opinion.
Yeah, so I think in the past, the board consents had 400 hours. That was kind of the standard. I think we discussed this. We think community service hours are important. I think 400 hours, I think you can accomplish the same thing with less. So I would, be more comfortable with a lesser amount, but I think the question was also, should it be added in the board consent? Or is this something that the programs themselves are supposed to do? We haven't been doing that, and a lot of the orders recently haven't had that in there. And so that's where I think this question kept coming up before you guys. We feel it's important, but we feel like it should be in the board order and then managed by the program as far as compliance, though, if that's something that the board decides.
You would suggest that it's included in the order.
Yeah.
That it's not self-serving? Is that what you're speaking about?
Well,
or that
just
it's being
that,
monitored by-
yeah, that just any of the requirements that are going to be, that the participants are going to be held to would be in that consent agreement, and not something that our individual programs would then have to mandate or contract with them. So if the board agrees and feels this is beneficial for participants in the program, that be part of the order like it used to be. And then we can monitor it. So they can come to us, let us know where they're volunteering. We can, sign off on that it's a legitimate organization, fits the definition of community service hours, and then be responsible ultimately for attesting to the fact when they go before you to graduate from the program that they've completed all necessary program requirements, including any volunteer hours that would have been assigned.
Do you know what it's like in other states, like other PRN programs or similar programs in other states?
I haven't done a recent survey. I know our contracts and the board agreements mimic what a lot of the other states had done in the past, and that's where the 5-year contract came from, based on studies and evidence, based on what's the greatest likelihood that we can kind of prevent or help with long-term success and sobriety. The peer support groups came out of that as well, and so do the volunteer hours. So I can't say specifically how many states require or don't require.
Okay.
Thank you, Ms. Fine. Board members, thoughts on this?
Just when you're talking about a 5-year contract, 200 hours over 5 years is 1 week of full-time work, basically 8 hours a day for 5 days or 1 week. Whereas 400 hours would be 2 weeks a year. And that's typically what you get for a vacation from an employer. So I think 400 hours every year, 400 hours over 5 years or 80 hours a year is not an unreasonable amount of time to ask somebody to donate to their community. So I'm generally in favor of sticking with the 400 hours.
I'm also good with it. I don't see a big enough reason to change it, not to mention half it. Like it just arbitrarily came up with, let's do half. I just don't see any support to why necessarily. And I do think that adding that it's monitored and by the program and the hours are not self-serving would probably be smart to add that into our contract.
As far as putting it in the order, legal counsel, is there any difficulty with making sure this is in the template for the consent agreements for this sort of thing from now on?
Not a problem at all.
Do we need a motion here?
Yes, that would help, please. So it'd be 400 hours to be in the consent agreement, monitored by the program.
I'm willing to make that motion. 400 hours, add the community service as part of the contract, and anything else I missed?
Monitored by the program.
Monitored by the program. Thank you.
And not self-serving.
And not self-serving, exactly. So all those in my motion.
Second.
Although, any further discussion? All those in favor?
Aye.
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 Any opposed? All right, Dr. Gandhi, next.
Madam Chair, actually, I needed to go back to the legislative bills. I have in our meeting, Mr. Frank Thorwald was the author of one of the Senate bills, 1219. That's the donation bill. And I think the whole thought process of running that bill by Mr. Thorwald and the sponsor was, I think our donation program language is not very effective. And so Mr. Thorwald did his own research, found this language being used in other states, and seemed to have some traction and benefit there. We may need some regulations around it. I know we're doing that comprehensive rules package that we can definitely incorporate the discussion. But Mr. Thorwald, if you want to take over from there and just introduce yourself, as you're going to play a part in this equation.
Mr.
Thank you.
Gandhi, page number real quick, just so I can be on the right page.
It's Senate Bill 1219. Let me see where we have that.
Sorry, I didn't mean to cut you off, Mr.
Oh, no, you're fine. Well, 19 is page number 4166 in my book.
Thank you.
Sorry, Mr. Thorwald.
Thank you, Dr. Gandhi. My name is Frank Thorwald, and I'm representing myself today. Just a quick bit of background. I've lived in Arizona for over 25 years now, and I've served on boards and commissions and councils for the last 20 plus years, and I serve on 2 other ones right now. And prior to that, I was a special assistant to the President of the United States and 2 U.S. Attorney Generals, and have conducted a number of national campaigns, and my expertise lie in logistics, government and public relations, and legislation, to name a few things. I saw quite by accident when Cam was testifying before me, and my mother and an assisted living, the immense waste with the prescription drugs. So I contacted a variety of organizations, did a lot of research, and talked to other states as well to see what was working and what hasn't. And in all but 3 states, it really hasn't worked effectively. And the reason it hasn't in those states is because they didn't have a central storage and processing area. They didn't have a central software database. They had multiple parties trying to handle this. They lack public knowledge of the program itself. In the states where, even with those various problems, there's hundreds of millions of dollars that have been saved, and hundreds of thousands of people that have been helped by this prescription program. And I've looked at a variety of different things, and I've sent you some material of which I won't go over, just from what I gathered from the other states, and some material on one organization that I talked to, that I asked to put some material for you so you'd get a better idea of what was out there and the kinds of things that are done. And if there's any benefit that I can provide, I will be happy to provide it to you folks, or Dr. Gandhi, or your board. And if you have any questions for me, please feel free to ask.
Thank you, Mr. Thorwald. I appreciate you being here, and I certainly think that your expertise can be helpful as we're look forward to writing rules with our comprehensive rule package. I know this is something that we discussed in our earlier meeting that certainly will be a priority of the board as we look to draft rules this year.
Thank you. Thank you for letting me speak.
Thank you.
Madam Chair, moving back in line with what I was discussing. Last board meeting, you guys had asked a question of legality of housing compressed gas in a neighborhood in this county or any other counties throughout Arizona. That is still being researched, so we don't have any additional information today, but it is on our radar to keep researching so that we can provide you that information that you've requested.
And this is Jean Galvin, and we are working on that. And we have reached out to the city of Phoenix, a couple of individuals, to discuss with them the direction our research was taking us and kind of confirm with them. And we're not getting any return calls, but we'll continue to work on that.
Thank you. Appreciate the update.
The next agenda item was brought forth by Dr. Dang. Can retail pharmacies deliberately refuse to fill paper C2 RXs? There may not be an issue here in the near future anyways if the executive order is eliminated, because we go back to e-prescribing per state law. But it's, I think in my opinion here, how do you investigate deliberately? I mean, it is a pharmacist's professional judgment to fill a prescription, and to deliberately not fill a prescription would be an interesting adventure for us to go and try to figure out if they did it deliberately. Dr. Dang, you want to elaborate on your concerns, and hopefully we can maybe talk through it.
Yeah, thank you, Dr. Gandhi. So I have received multiple complaints from various individuals. Complaints came to me from a public member, just as citizens, and some of them are in healthcare fields, including physicians. What they're not happy with our profession or our pharmacists out there is that, like you mentioned earlier, some pharmacists deliberately refuse to fill prescription, and they just, irregardless of what the board regulations are, they just refuse to fill it. And since we are here for public safety and public services, and safety is a concern to me when pharmacists just deliberately refuse to fill pain medications when patients had just got discharged from hospital. Imagine if the pharmacist refuse to fill the prescriptions, and that could potentially result in rehospitalization. And it's just not working out for everyone, including the patient and the physicians and the patient's family members. So that's the reason why I brought this up to the board members. What can we do as a board to mandate or to have some control over these pharmacists out there? For religious reason, I agree. But if the board has already allowed you as pharmacists to fill C2 prescriptions that are written on paper prescription pad, what, as a pharmacist, shouldn't you do that for patient care and patient safety? I just don't get it. When the board allow you to do so, but you still say, no, I cannot fill it, and I would choose not to fill it. So as a board, what kind of action can we take on these individuals who deliberately refuse to fill the prescriptions?
So, Dr. Dang, in my personal opinion, I don't think that this is within our purview. I feel very strongly that the pharmacist should have a choice to fill or not fill a prescription based on their own clinical and professional judgment. I think, unfortunately, sometimes pharmacists are put into awkward positions and perhaps don't really tell a patient the real reason why they deny a prescription. But ultimately, the pharmacist, especially when you're talking about controlled substances, is required to utilize their corresponding responsibility to ensure that they are dispensing a prescription for a legitimate medical reason. And I think sometimes the fact that it's on paper could be a convenient excuse. That being said, I am concerned about patient safety first and foremost, but I think if we don't allow pharmacists to use their judgment, there could be negative consequences from a patient safety standpoint. Also, if pharmacists feel like they have to fill prescriptions, which I don't think that's good either. So I am of the opinion that I don't think we should do anything here, but I'd like to hear from the others as well.
Mr. Dang, did you mention for religious reasons? I didn't catch that.
No. All these complaints that were reported to me had nothing to do with religious reason. It just purely pharmacists refuse to fill the C2.
But did you just mention that in your statement though, a minute
Yes,
ago?
I certainly did.
Okay, I just didn't understand the correlation. I was just curious.
Well, the reason why I mentioned that was because me as a pharmacist, if I were to work at the retail pharmacy, some pharmacists are strongly believe in anti-abortion, and they have the right to refuse to fill the prescription for birth control. That's something that you can't.
Okay, I just thought that this discussion was just about paper C2 prescriptions.
No. So Ms. Wormley.
You just mean be able to refuse prescriptions, filling prescriptions?
They refuse to fill the C2.
But you want to broaden the discussion to that, is what I'm asking.
Yes. So I understand pharmacists, all of us should be allowed to formulate our own clinical judgment. But that should strictly pertain to clinical matters. Here is black and white. Physicians wrote prescription, C2 prescription on prescription pad. And the governor executive order, as well as the board of pharmacy, had officially allowed pharmacists in the state of Arizona to fill those written prescriptions. It even stated clearly on the state's control PMP website. So me as a pharmacist here, when I run into these kind of complaints from my colleagues at work, I just think that our peers, pharmacists out there in the community, are neglecting the board's regulations and the governor's executive orders.
I agree with Ms. Walmsley. I just want to also add there could be confusion on what the rule is. And there's also perception on the patient's part of what they're being told. They might come and just express it to you saying they were refused when actually they were told they needed to wait a couple days. So it might be a perception issue as well. We just can't, I think that pharmacists have their own professional judgment for a reason, and I wouldn't want to take that away from them.
Madam Chair, if I may.
Yes.
There's certainly a big blind spot when it comes to a retail pharmacist when they get a controlled substance opioid prescription, because there is no requirement to put an ICD code on a prescription. That is something that is being discussed, I think, across the country in the PMP world, whether that's needed or not needed, how that will assist us in cleaning up the PMP data to get accurate data on what needs to be checked, what not, and that's a different subject matter. But I think if that PMP, if the ICD code was on there, a pharmacist may have a better idea of why that prescription was prescribed and is more inclined to feel the patient's pain, I guess, and would in turn maybe feel it, but right now, that's a big blind spot, and they just don't know when a prescription comes in, what it's intended for.
Well, and I also feel that there may be some people that this is the first time that they've seen a hard copy prescription come through during the epidemic. So they've been told for so long that they were not allowed to do that, that it could be just a lack of the knowledge. Even though it's out there, they may have reverted to the things that they had always been doing instead, perhaps. And at that point, I know that there's been with some of the retail companies that they've put out additional information to make sure that all of the pharmacists are aware that those are prescriptions that they can honor during this time to help alleviate some of these concerns.
I think, yeah, to expand on what Ms. Lehan is saying, in the early stages when that executive order did come into play, we had a lot of calls to say, hey, is this allowed? And obviously, we did put it on our FAQ, but people don't necessarily read. So we did field a lot of questions and cleared up the air, but not everybody calls us for that information or to get clarification.
Madam Chair?
Yes, go ahead.
In my opinion, if we're talking about just this paper thing, that's one topic. But if we're talking about, it was said to mandate pharmacists to fill C2 prescriptions, very much against that. There's got to be that professional judgment on that license holder to assess the situation, and then determine if they're going to fill that prescription based on clinical judgment factors, based on the factors that are presenting to them with the prescription. A lot of times the prescription is presented in a different light than how it was written. It is that pharmacist's ability and their job to assess that it's appropriate and a medical legitimate need and move forward. We get into a contest of who's right and who's wrong, and something happens at the detriment of the patient that the pharmacist could have caught, that we've now made them mandate to do. That's nowhere we want to go in patient care, in my opinion, at all. Now, if the conversation, and I do believe every pharmacist has the right to refuse a prescription as well. You have the right to do that. Doesn't mean you're going to be employed, but you do have the right to refuse a prescription if you are concerned about the medical legitimate need. If we're talking about the paper here and we're talking about those prescriptions turned away, I can tell you there's a lot of really, really good things going on out there. And I feel we're focusing on a few bad things that have taken place. An education effort, in my opinion, on those people would be better than us saying we're going to mandate people to dispense all prescriptions. There may be a reason a paper prescription isn't filled. I don't think that we can go there. I think this is way too big of a topic to go into. You get into a individual's clinical judgment and how they're practicing pharmacy in that theory. I don't want to go there.
Madam Chair, I just have one last thought if I can.
Yeah.
I totally feel for the patients that are not getting their meds that may need them. But we're stepping in, we're crossing the line here a little bit where we're entering federal corresponding responsibility law. And that's a little, so I mean, we can entertain this discussion, but I don't know if we can do anything at our level because it is at a CFR level.
Yeah, I'm not
and that's exactly my thought. So, you know, to Ms. Lahan's prior comment, you know, if a pharmacist typically always sees electronic prescriptions because there is a requirement that a C2 opiate has to be prescribed electronically prior to the pandemic and the governor's executive order, all of a sudden now you start to get a bunch of paper prescriptions. Okay, now is this a red flag to me as a pharmacist, which the pharmacist is required to clear as part of corresponding responsibility? Now, there should be some communication to the prescriber, in my opinion, and that's probably what was lacking here. But I hate to take a stand on something that could put the pharmacist in a bad place when I think we're making assumptions that they're doing it to be deliberate when they could very well think that they're trying to be compliant.
Or company policies that they would follow as well.
Well, in this case, the scenario that I ran into, the nurse, first of all, the nurse approached me and said the patient went home without pain meds. Then I told the nurse that the frequently on the board's website, pharmacy board website, if the pharmacist is to look into the frequently asked questions, he or she will see that it is permissible to fill C2 prescriptions written on paper. So the nurse called the pharmacist, communicated with the pharmacist, but then nothing was done. Then I even called the pharmacist. The pharmacist said, well, my manager told me not to fill it. And she just left it there. Even the nurse and I myself informed that pharmacist that, yes, it is permissible to fill the C2 prescription. It's clearly stated on the board's website. Nobody's making these things up. But in this particular case, that's why I brought up to Cam's attention. And I told Cam that this particular pharmacist said she's not going to fill it. She's going to wait to get the permission from her manager, not the district manager, the store manager.
Well, I mean, that person sounds like they might have been in a tough spot, and we may not know all the factors.
I'm not pinpointing anyone from our profession here. I just feel bad for the patient. Patient went home completely without pain med. And as you all know, during COVID pandemic time, not a lot of pharmacies are open late. Before, the pharmacies are open till 9 o'clock. Now they close at 7. And there's handful number of hours pharmacies in the Valley. So at the end of the day, I'm bringing this up to the board members, not because not because I'm upset at the pharmacist or anything, but if you look at the patient, if you put your loved one into that patient's shoes, you will know exactly how it would bother you.
Dr. Gandhi, do we need any action here?
No, I think the only advice I can give is when we have concerns like board staff doesn't have an issue educating. We're definitely not going to force a pharmacist to fill something they're not comfortable filling, but we don't shy away from educating and saying, hey, if you're comfortable, this is allowed, and here's the executive order, statute, or whatever it may be that we can point to. So if you guys come across situations like that, please don't call the pharmacy. Please let us know. We'll definitely educate if that's what's needed. We're not going to be forceful. We're not going to twist anybody's arm to fill it, but we're in the education game.
Okay, that's fair enough.
Okay. Madam Chair, if I may move on to the next topic.
Please.
I think the next topic is maybe premature on the agenda. It is to discuss the grid and adjust or delete. Obviously, we have some bills that have been signed into law, but not yet law. So once those kind of play out and we start feeling out how we need to move the grid. So my point is maybe we agendize this for a future meeting and not discuss it today.
I would agree with that, especially noting the fact that we need to come up with some action related to the non-disciplinary fine. So I agree. I think we should hold off a little bit until we can address that as an overall topic.
Perfect. The next topic is we did have our first task force meeting on a comprehensive regulation package, rules package. We set some ground rules as far as the board's position on how to move forward with this. We also, I believe, addressed the fact that priority right now are the bills that are coming live in 90 days, 91 days. So we do need to address those first, and then we can start biting off more section by section and prioritize them. In a nutshell, is that the gist of it, Ms. Walmsley?
Yep. I think for those of you that were not a part of the task force, this is going to be a pretty long and deliberate process, but hopefully we'll be able to address a lot of the deviations that come before us and hopefully allow us to modernize our rules as well as get up to speed with the legislative pieces that need to change. So certainly if you have suggestions, please let Dr. Gandhi know. Even if you're not a part of the specific task force, we're also going to be looking for feedback from the public in a more broad fashion to make sure that we have a lot of stakeholder feedback above and beyond what's required by law.
I think if we start digesting the feedback as we're writing the new regulations, and when there's a public comment section open up for public comment, we might not get as many to address, and so trying to get ahead of the curve with that thought process. Madam Chair, with that, that's my report.
Thank you, Dr. Gandhi. Item 32B, the Deputy Director report, Ms. Ganavan.
Yes, I just have one item. It's the Compliance Officer Activity Report for March 2021. You'll note that please note that there were 9 violations during the month of March. Really, they were pretty evenly spread amongst these topics, but the top 2 being counseling and immunizations. Are there any questions?
Any questions for Ms. Ganavan?
Okay, Madam Chair, best for last, Mr. Scavarla.
Hello, Doug.
Hello, Madam Chair and board members. After 2 full days of covering many different subjects, I'm still very grateful that you give me a little bit of time to talk a little bit about the CSPMP. Today should be a little bit better because you don't have to listen to me the whole time. But there's 4 topics I wanted to touch on, and 3 out of the 4 are really quick. But first of all, we have a collaboration going on with Maricopa County that I mentioned last meeting. And I have Merritt Gourmet, who's my epidemiologist with the board, with the CSPMP. She's going to talk a little bit about her work, and it's really interesting. You guys are going to love it. After she gets done, I'm just going to give you just a couple numbers regarding our integration efforts. We have a new team member on the CSPMP. I'll introduce you to her. And last of all, just a reminder about our ASAP standards. You know, we talked about them in the fall, and we said that we would upgrade to 4.2b. I'll just let you know about the communication that went out. But more importantly, why don't we let Merritt share a little bit about her work with you guys. So Merritt, it's all yours.
Thank you.
Thank you, Doug. Hello, my name is Maharad Karmai, and I'm one of the epidemiologists for the Board of Pharmacy. Today, I'm here to share with the board some of the works that I have been working on. In addition to my daily tasks, I also collaborate with the Maricopa County Department of Public Health on some projects by sharing non-identifiable data and producing aggregated reports for them. And today I'll share some examples with you. So one of the earliest data I shared was for their public dashboard. Maricopa County intends to show its newly built dashboard on prescribing practices with regard to geographic variations, trend over time, and indicators of potentially harmful prescribing practices. So to create this dashboard, they are linking different data sources, and the PDMP data I shared as one of the central data sources that would glue all the other data sources together. So it's a very important project or collaboration. For this project, they were looking for a 5-year trend, which was from 2016 to 2020. And we were able to give this data broken down by different levels. For example, they asked for total control substance dispensed, and we gave them a granular data by breaking it down into different fields such as drug type, and these drug types were further broken down by age groups. Another thing they requested was for prescription counts specific for opioids, and this were given to them by broken down by daily MME greater than or equal to 50 and 90 MME. And again, this were further broken down by drug schedule. The last one they requested was number of patients with opioid and benzo overlap. And this were further broken down by patient county, patient code, and also year and month, which is 2016 to 2020 again. So because Maricopa County projects tend or focuses on patient health, all the information that we give them is or uses patient county rather than prescriber county or prescriber informations. I'm gonna share my screen just for a moment. Can you see my screen? Sharing it. Okay. So this, sorry. This graph is just to show a visualization of what some of the data that I have given to them. And if we were to put it into visualization, this is what it would look like. So this one gives specific prescription count on benzo, and it would, it's breaking down these numbers by different counties, and each separate line or different colored line would represent different counties. And again, as you can see, this gives information on from 2016 to 2020. Some of the general updates I gathered while working on this and wanted to share with the board today is that within a 5-year difference, or compared to 2016, what we're seeing now in 2020 is that we're seeing a decrease by 32% in opioids, 37% in benzo, and 11% in stimulants. So I think this is very good news that we're seeing a decrease in prescriptions in opioids and benzo. I'm also collaborating on a non-fatal overdose project with Maricopa County. So this project is a fairly new project, and it links non-fatal overdose Maricopa County data and our PDMP data to do the analysis. This is done monthly, and I prepare a non-identifiable aggregated report for them. To do this, to do the analysis, we look at the 3 months data prior to the event month. And when I say the event month, I'm referring to the non-fatal overdose month. So for example, if I'm working on a January non-fatal overdose list, then I would be using October to December data, or a 90-day ahead of the non-fatal overdose month. So just to give you a quick step-by-step of how this goes is, so the first step would be getting non-fatal overdose data from Maricopa County team. And then step 2 would be I combine the 3 months PDMP data together. And step 3 would be linking the non-fatal overdose data with our PDMP, combined PDMP data. On step 4, I would calculate the fields they required. And step 5 would be preparing the aggregated report and sending it back to Maricopa team. So the table that you have in front of you is what I would send back to Maricopa County. And in addition to this table, I just add additional informations on explaining the numbers and just giving some calculations used to do this analysis. So far, I have done 2 reports only. Like I said, it's a very new project, and I'm working on the 3rd one right now. So while doing this, one of the interesting things that I found is that on the first report I worked on, the October non-fatal overdose, out of the 159 patients that were on the list, only 28% had controlled substance prescriptions, or only 28% matched to our PDMP data. And of those, only 18% had an opioid prescription. Again, on the second report I did, which was the January report, again, I had 159 patients on that list as well. And of those, only 23% matched to our PDMP data. And of those, only 13% had opioid prescriptions. So this one was very interesting to me because I know that as an epidemiologist, I see different reports from CDC and other studies that overdose mortality is going up, but we are seeing a decrease in our opioid and benzo and other prescription going down or decreasing. But we see that the overdose mortality is going up. So my assumption would be that it could be due to illicit drugs like fentanyl. But again, as an epidemiologist, I cannot conclude saying it's because of that. And I'm sure with further research, there will be more other things in addition to illicit drugs that is causing overdose mortality. And that's all I have for today. If you guys have any questions, I'm open. Thank you.
Thank you, Ms. Gourmet. Board members, any questions?
Good job.
Appreciate you providing the information to us.
Thanks, guys. Merritt, thanks for presenting. And, you know, I think the one thing I want to highlight is, and she just mentioned it, but what we're seeing is we have non-fatal overdoses where patients have no history of the last 3 months of receiving an opioid from pharmacies. And when you look at those numbers, it's really pointing that these overdoses are occurring because of other means, and that the means could be still a prescription drug that they got from a friend, a medicine cabinet, but you know, the odds are right now that it's probably coming from illegal fentanyl. So I think that's really good to know.
Thank you.
If okay with you, I'll just blaze through some integration. I sent you guys a little graph, and the graph is really just showing you guys that we're seeing more and more queries of the PMP through integrated EHRs or pharmacy software systems. And we're starting to see less of them being done the manual way. So that's ultimately what we want, because we know it's easier to use the PMP if you have an integrated entity. It saves you time, and we're starting to see more and more prescription lookups in the PMP being done through integrated EHRs.
Are you seeing that on the prescriber side and the pharmacy side?
We are. Those numbers are both together, but yes, the answer is yes on both. Well, I mentioned that I have a new team member, and recently the prescription drug monitoring program, we purchased from our vendor an enhancement, and that enhancement's designed to allow us to look at high prescribing and poor utilization of the PMP all at once. So in the past, we had this data set and this other data set. We'd be trying to match those different data sets the same way Merit's matching Maricopa County data right now. And it wasn't really efficient. So with this new enhancement, we're able to look at both in one step. And as a result, we have a new team member. Her name is Eva Diaz. She is originally from Arizona, moved back to, she was living in California and moved back to Arizona with her husband and recently started with us about 3 weeks ago. So she's going to become our expert on this new module that we purchased, and we're going to do a deep dive into looking at high prescribing and low utilization all at the same time. That's going to be Eva's role. And finally, you know, we put out some communication recently about the CSPMP is adopting version 4.2b of the ASAP standards. What that does is it allows certain fields that can't be reported to the PMP with version 4.2 to be added to be able to report those into the PMP. An example would be ICD-10 codes like Dr. Gandhi talked about earlier. I don't know that we will one day need to report ICD-10 codes, but by upgrading to 4.2b, it gets us to where we can in case there was ever any legislative activity that required such a thing, the PMP will be ready to handle that ingestion of data. 4.2b does other things too. It's not just all about ICD-10 codes. It puts clarity around when a prescription is sold. There's fields that make analyzing the data a little bit better and also using the PMP data better, because I often get questions. The PMP says it was filled on October 1st, but the patient saying it wasn't sold until the 3rd. But what's reported to the PMP could be one date or the other. And then version 4.2b allows us to put a little more clarity around that. For big chains, there are other states that are using version 4.2b. So big chains aren't going to have any issue with this. What you may get though is if you're a leader of a big chain, you might have your pharmacist reaching out to you saying, I got this communication from the Arizona PMP. Can you tell me what it's all about? And I think it's important that I let the leaders know that really there's nothing the pharmacist can do. It's really on your, if you're a big chain, you have a CSPMP department, and they need to coordinate with the vendor if you have a vendor that does your submission, and the vendors know how to do that.
Doug, two questions for you. Are we changing anything with the required fields that are required to be reported into the PMP? I know per your, as you said, there are a lot of additional fields in 4.2, but are we changing anything that's going to be required to be submitted?
The prescriber pharmacy phone number and prescriber phone number in our user guide, it never said it was required.
Okay.
Almost every pharmacy did report those to us. We didn't have problems with it. So we've turned them on to be required because we do expect those to be reported. But right now, the answer really is no. This is more about being proactive and not about like changes that vendors and pharmacy teams need to know about.
But that would be the only major change in terms of in terms of the dispenser's guide.
You got it.
Okay, and then are you making any proactive communications out to the major software vendors just to make sure that's getting communicated to all the corresponding individuals? I know many of us do work for large organizations, and I'm sure we will pass it along. But for those of us that maybe some of the people we've lost, just to make sure that people have time in terms of transition, I want to make sure that we're doing our best to notify the public.
It's a great question. And, right now there's like 462 EHR vendors that currently would participate in being integrated with us. And therefore, I think that's a way of saying that there's a lot of people to make sure that we're touching, out of those 462, they're not all pharmacy vendors, right? But what we are doing is our vendor is communicating with the EHR and pharmacy software vendors themselves. And we status with our vendor weekly, and I ask them for follow-up. So yes, they are putting out communication directly to the vendor. My team is putting communication out directly to the pharmacies and pharmacists. And if you find that your vendors aren't being communicated with, I want you to reach out to me directly, and I will make sure they communicate with you.
Thank you, Doug, and I appreciate you bringing this to the board early. That just for the public, we're looking at this transition in November of 2021, so we are giving the public lots of time in case there is software changes that need to be made. So I just thank you for doing that, because I think sometimes the heavy lift for IT changes, whether you're a small organization or a big organization, is harder than sometimes people take for granted.
Yeah, you're exactly right. And, I consulted with a lot of different states and different people within the industry, and just said, what's fair? Because I really don't know. I think that what we still need to remember is the small mom and pop shops that may not have a vendor that's doing their data submissions and they're doing it themselves. They may need even more attention to this, So we have a user guide for them. And we'll be able to share that. We have that up on our website, and that's where we'll guide them.
Thank you.
Okay. Well, that's all I have. Thank you.
Appreciate it, Doug. Thank you. Board members, we are to the point of discussion of items to be placed on a future meeting agenda. As I mentioned a couple times during the meeting, I do think that we need to find a way to address the amount of materials that are coming through to staff. I don't know if that needs to be an agenda item or if that's something that I can work with staff on, but I do have concerns with the number of documents that we're getting the day of the meeting, the day before the meeting, and just to make sure that everybody has the opportunity on both sides, both if there's new information that's provided by a compliance officer for a case that the respondent has the opportunity to look at it, and or the opposite, whether it's our staff needs the opportunity to review it or us. I certainly think we need to come up with some sort of guidance for the public on what will be expected and kind of how we want to handle those items moving forward, because this seems to be kind of a common theme that's becoming, at least in my opinion, more difficult. Mr. Goodman, are you speaking?
I'm talking, but without you hearing. Nevertheless, since I was all alone, now I'll make it so you guys can hear. I concur, we need to have that in the discussion. If we could allow the item on the agenda to be even more broad, to include how the pharmacy board will delay cases to come back later that day and then the next day. It's just not a process that I'm familiar with happening with other boards, and I don't have any great knowledge on it, just a little. And it seems like, you know, the discretion to, oh, we'll have them come back after lunch the next day sometimes doesn't add to us being successful as a board. So I'd just like us to have that as part of the discussion.
Thank you. Good suggestion. The other item, just for the group, there were a number of things because we didn't have a quorum from the complaint committee that we had to pull forward to this meeting. And I think that probably made this meeting a little bit longer. I don't know if we need to add that as a future agenda item, if we want to look at the composition of the complaint committee, if there's a slightly different way we want to do it. One of the thoughts that I had is potentially, should we look at having a rotating alternate, somebody that is available and prepared in advance to participate in the event of an emergency if a committee member wasn't able to be able to participate, those kinds of things. We all read the materials anyway. I think as long as we had the ability to prepare, it probably would work out fine that way. But just food for thought as I was kind of thinking about how the meeting went this time, something that I thought might be an opportunity for us to look at for the future. That's all I had. Any other items from the rest of the group?
No, and then just a question. So I think the intention was the items that didn't get answered from the last meeting that were on the request to be on the agenda. Will they automatically flow over on the follow-up section?
Yes, they would.
Gotcha. Okay.
Any other agenda items for the future from other board members?
I don't know if we need to put it on the agenda or not, and it was said it would be taken care of, but what the bills that have passed, once we start getting into that territory, the education piece to the public to me is important. So maybe we could get that on the agenda to hear what board staff had already had in the works and plan to do.
Sounds good. Anything additional? Hearing none, let's go to call to the public.
Okay, Madam President, we're going to queue up the slide. There's about a 20-second lag.
Thank you. Looks like while we're waiting for that, looks like Mr. Morris perhaps would like to make a comment. Is anybody that's on the Zoom available that would like to make a comment?
Sure. And I would thank you, Ms. Walmsley. I had two quick ones, and it deals with I think the last point that Mr. Liba just made. There are two laws that just got passed that this board is going to have to deal with fairly promptly. One was spoken with just during Mr. Gandhi's report about the donation law. There's a lot of folks watching that law and wanting to put it into effect very quickly to start getting donations. It was set up so that the board has to do one thing, is just set a reasonable fee that the pharmacies can do. And so I'm hoping the board can do that promptly, and setting the fee may be something as simple as, like other states have done, limiting them to, quote, a reasonable fee, and not trying to get into some dollar amount that's going to have to be constantly changed. And it's going to really be different if we're talking about a routine maintenance drug or a specialty drug or a refrigerated drug. But there's a lot of folks that are interested in, as pointed out earlier, the donation product. If we can save millions of dollars for folks and get those drugs to them, it'd be really helpful. So hopefully this board can do it fast. The second issue, which just came up, and I don't know how many folks were able to see this, but yesterday, Governor Ducey signed a bill into law effective immediately, dramatically expanding Arizona's telehealth rules. It is listed under the governor's public disclosure as the new Arizona law will be the broadest in the nation. And the issue for that is there's going to be a lot of ramifications as to how those prescriptions that are being issued from that are going to be affected by the pharmacies. And we're going to have a lot of unintended consequences that some of our older laws never dealt with. So that law is in effect as of yesterday. It does not have the 90-day wait. It became effective immediately. So the board's going to have to work on these pretty quickly. There will be others like this coming very fast. That's it.
Thank you, Mr. Morris. Mr. Hyber, do we have anyone else?
No, I do not see anyone in the queue. So it's just the individuals that have been in the meeting all along. And if there's no one else to talk, then I think we're done.
Very good. Thank you all for a productive meeting. We will adjourn at 5:23 p.m.